Today is February 15, 2017, and this is a regular meeting of the members of the State Liquor Authority. Present today are Chairman Bradley, Commissioner Ford, General Counsel Riano, Deputy Commissioner of Licensing Held, and myself, Secretary of the Authority Donahue. We're going to call matters in the order they were signed in for the most part. First in Buffalo, then in Albany, then in New York City. However, we're going to make one exception to that. When your matter is called, please come up to the microphone, speak clearly into the microphone, because that is what records the meeting for posterity. The next meetings of the authority are March 2nd, which is a Thursday, March 15th, and March 29th, which are all Wednesdays. All right, the first, Chairman, do you have any other items to discuss?
No.
All right, the first item we're going to do is 386C, which is a proposed advisory regarding bill and hold. So if anybody wishes to speak on that, please come up to the podium.
Good morning, I'm Kevin Dano. I'm here on behalf of Empire Merchants, basically to oppose this advisory. First, don't believe that there is a need for this advisory. The Liquor Authority years ago went through the there are provisions of the statute and the regulations that deal with warehouse receipts, and they say that a warehouse receipt is the equivalent of the sale of goods, and Empire's procedures follow those regulations completely, and they were vetted and approved by the Liquor Authority. We'll put that aside for a second, as you know. As the second question is the advisory itself. All right. I don't believe that it is appropriate for the Liquor Authority to be setting either prices or procedures for the wholesaler in connection with bill and hold. It's somewhat the equivalent of price fixing for you to say that they have to have the same prices as the three local stores. The issue for the Liquor Authority should only be the issue of gifts and services, whether or not the prices are sufficiently within market value to be within, to be outside the issue of gifts and services.
And how do you suggest we measure that?
Well, for one thing, we sent you on Empire's prices, the current prices, that they're charging pretty much the same thing that they're being charged. That's a definition of market value. You add to that the fact that you had a response from the Retailers Alliance, which indicated that most of the wholesalers are charging around the same amount for the services involved here. That's also an indication of fair market value. For you to say that...
But isn't it true that many wholesalers are using warehouses because they don't have the ability to warehouse themselves?
Right, and if they use an outside warehouse, the usual outside warehouse is in New Jersey. So when you say the three closest warehouses, you're not even talking about the three closest warehouses to the wholesaler. You're talking about wherever they're warehousing, and most of the places they're warehousing in New Jersey. In New Jersey, they don't have unions. They don't have
Well, we're not suggesting that you should be setting the price based on the price in New Jersey, and we're not suggesting that it has to match the price. We're saying that you should be justifying the price you're charging. There are wholesalers out there that are not charging what other warehouses are charging.
I'm prepared to, I don't disagree with the idea that the wholesaler has to stand behind the fact that the prices that they are charging are reasonable under the circumstances and not a gift or service. They certainly can't give the service for free, and they certainly should have some kind of method of, like an in-and-out charge or some other kind of charge to make sure that there are no free goods. One of the things that the Liquor Authority has to concern itself with is that we have monthly price posting, and as a result of monthly price posting, you have to make sure that you can't use bill in store with no fee or a nominal fee to move from January to February without in a price shift, because it's contrary to our price posting laws. But in general, any method that is fairly within market value and is close to what or the same or more than what the wholesaler is being charged should be okay. To say what the advisory says, the three closest stores, the three closest warehouses.
Well, I think the intent is, and I can tell you because it was my intent, that the fee be justifiable, as you said. That's all the intent is, to make sure that it is within market. In my view, that was the best way to figure out what market was.
Okay, well,
But if there's another, and I guess we can draft or amend the advisory to indicate that if the wholesaler comes up with another way themselves to justify what they're charging, as long as they can justify it's within market, I don't think we'd have a problem with it.
That's the big problem for me. Not looking to find another way to give gifts and services to retailers. I'm just looking to find a way that everybody can set their own policies within the tolerances that are not a gift or service, which brings me to the second point. There is no reason for the Liquor Authority to be saying that the maximum time you can hold goods in storage is 6 months. It's an arbitrary period of time. That kind of issue should be an issue for the wholesaler. If the wholesaler is charging a reasonable fee, then how long it holds it for, it should have...
Yeah, but I think that's, and I'll give you an example. We've run into problems where a retailer has put their license on hold and gave it back to the authority to hold and left stuff in storage for 4 years.
Well, first
Do you
of all...
think that's, I mean, it gets to the point that it's ridiculous.
Well, first of all, I have to say I'm familiar with the particular case you're talking about. I believe that the Liquor Authority's rules are that you can't put goods in safe, you can't put your license in safe storage for more than 6 months. Sometimes you extend that period of time. I've never seen before the extension of 4 years. I would say to you, Mr. Chairman, that you should not set the rules of the authority based on the most outrageous abnormality.
No, I'm not. I mean, we picked 6 months. I didn't pick 4 years.
Well,
But, I mean, other states have put a limit on it. And I think in order for every wholesaler to be on the same playing field, if we put a limit on it, and I'm not saying 6 months that we're tied to it, but if we put some limit on it, and maybe a year, maybe it's 18 months, I don't think it's unreasonable to put a limit on it.
I would say to you that if it were a year or 18 months, please do not misunderstand. In the first place, I don't think it's right. Okay? But on the other hand, they've never offered me the seat up there, so it's what you think that
You wouldn't take it. We both know that.
It's what you
Because you'd
think
have to change your lifestyle, and I don't think you're willing to do that.
it's what you think that ultimately matters. But if it were 18 months or a year, I think it would be much more reasonable in terms of not interfering with the wholesaler. 18 months, okay. It's not the wholesaler's intentions either to hold goods forever. But I would like you to understand that most of the wholesalers have set up rules about how long they'll hold them for, or when they'll. For instance, many wholesalers have a policy that says if we lose the line, we're not going to hold it for you anymore, and we'll give you a reasonable amount of time before you take it, but you have to take it. And I think those kind of decisions about how to run their operations and what they're going to do should be left to the wholesaler and shouldn't be legislated by the authority, because it's not within the purview of what I think the authority should be concerned with, which is the issue of gift and services and the issue of price posting. Right? So when you get past the issues that are where the action might be inconsistent with the statute, the rest should be left to the wholesaler. And again, if you say 18 months, I don't think that it's worth arguing further about it.
Well, and we have gotten input from the retailers that they don't like the time limit either, but they would like it to be extended if there is going to be one. So I'm not adverse to that.
Okay. In connection with the way the advisory is written, I would appreciate it if you would put in there is a place where you say whenever you talk about the date that the goods have to go into storage, and you do that based on the order date, it should really be on the acceptance date. Sometimes somebody will make an order, and it'll be a few days before the goods come in, and I advise my clients that they can't take a bill and hold or a warehouse receipt order for goods that they don't have. So it should be based on the date that the goods are, the order is accepted. And there should be a statement that on year end and at shutdown, the authority sometimes adjusts the date for bill and store, and as part of the year end adjustment. There should be some recognition that unless it's in some other advisory to the contrary. You have a statement that says that if the retailer has paid for the storage fee, you must deliver the goods. I would suggest to you that there should be included in that statement that they have paid for the goods, because sometimes you have that 30-day credit period. When people buy goods, they go into bill and store. If they've never paid for the goods, the wholesaler should not be required to deliver them. They haven't paid for the storage, you shouldn't be required to deliver them. And in the situation that you described, Mr. Chairman, in which the license is not active, the wholesaler should not deliver them. So there are...
Don't you think that goes without saying?
When you... I think it goes without
I
saying...
mean, then you'd be
except when you
delivering it
say
to
something
someone
the
who's
contrary.
unlicensed.
When you say you must deliver it if they paid for the storage, then I think you have to say, except under these circumstances. Because now there's something that every retailer is an attorney. You know, they look at it, and they say, you have to send it to me because it's there. Then I have to go to the counsel's office, and the counsel's office looks at it. If you put it in, there's no problem. And the last thing that I would like to discuss with you with regard to the last paragraph that you have, there are such, in general, I completely agree with the concept that when somebody buys the goods, it's their goods, and the goods have to be there. The Liquor Authority has accepted the idea of fungibility of goods. That is to say that all Johnny Walker Black is the same. So and your advisory actually accepts the fungibility of goods. The place that I would like you to make some adjustment is when you're dealing with what we call flow vintages. Flow vintages are those vintages which don't really have any, they're not really bought based on the vintage date. Most of the time when you see James Bond movies and he goes in and he orders a wine and they say Chateau something or other 1946 and nobody knows what it's supposed to be, but those wines are bought based on vintage. There is something called flow vintage. Some wineries, many wineries, actually most wineries, will put, instead of having no vintage, they will put vintage dates on the bottle, but the bottles are not sold based on those vintages. And when they're price posted with the Liquor Authority, there is no distinction in the price posting from one vintage to another. They either have the same item number, they are treated as a single item, they are often price posted as VV, which means various vintages, or 2005, 2015, 2016 with a slash. They're running vintages. And the retailers and the wholesalers all know that when retailer orders one of those goods, whatever vintage is the current vintage is the vintage they'll take. Calling those vintages fungible is useful for the consumer, the retailer, and the wholesaler because it keeps that wine fresh. You know, the wines in the market. It's the equivalent of saying you can switch out beer. Because if you say we can't, Empire will live with it. But what will happen is...
I mean, you're talking about like a yellowtail or something of that nature.
Yes.
Okay.
I'm not talking about Yellowtail because Yellowtail is a Southern Wine and Spirits product, but I'm talking about something like Yellowtail, you know, where the vintages really are not what either the consumer is buying, what the wholesaler is selling, or what the retailer intends to have. They don't care. Those vintages should be fungible. And the way you can tell is that a fungible vintage will have the same identification number in the price posting regardless of what the vintage is. A non-fungible vintage will have a different number and usually a different price. So I ask you to consider flow vintages fungible.
Not to be Clarence Thomas up here and not talk, but, you know.
Talks now.
All right, he talks, he's got to make up for his buddy now. But I guess I don't have an issue with that, what you're saying. My question would be, would it be fair to, like, at least notify the retailer that you're holding, that, you know, holding this for, that perhaps, you know, getting near the end of stock here and need to do something? Would you be opposed to something like that?
It's, you know, it would require a lot of computerized work and it'd be very expensive and would really not serve enough of a useful benefit to the retailer to be worthwhile. I mean, if we were dealing with vintages that are not flow vintages, my answer is deliver the vintage that they ordered. They want it.
Right.
So if you paid for a vintage, you should get that vintage. You know, we shouldn't be able to substitute. I can't substitute Johnny Walker Gold. I don't know if there is a Johnny Walker Gold, and I have my clients behind me. I can't substitute Johnny Walker Platinum for Johnny Walker Black, or Johnny Walker Red for Johnny Walker Black. The retailer, the consumer, everybody knows that that's a different product.
Right.
There is nobody that walks into a package store that asks for Yellowtail 2015. You know, they're not judged in the marketplace on the vintages. There's nobody reviewing them based on vintages. These are fungible goods. Everybody knows it. And to create a paperwork system, you know,
Yeah. Yellowtail is
what I
Yellowtail.
would say is that if the retailer, if you want to have a system where if the retailer says, I want those specific goods, identifies the goods and say, I want the specific goods, there's no reason why the wholesaler shouldn't be forced to say, okay, I'll take those goods in as the specific goods or I won't take them. Right? If you did it that way, if you said, anytime the retailer buys the goods and says, I want those at the time he takes them, right? That the wholesaler can say, I won't take it into storage, or I'll take it into storage, and I will hold those goods the way you want them. I think that that's reasonable.
Okay. Yeah, I think it is too.
I got nothing else.
Okay, anybody else? Oh, everybody stands up.
Good morning. David Waldenberg and Connie Ulmer, representing the New York Alliance of Fine Wine Wholesalers. We've submitted, first of all, we welcome the idea of leveling the playing field and defining the individual responsibilities for the wholesalers. There is some confusion. There's a lot left up to us to make judgments on, which could vary from wholesaler to wholesaler. We've submitted comments. I'm not sure if they've been reviewed or incorporated.
Yes, we
at
have.
this point.
They have not been incorporated, but we have reviewed them, but that, we haven't incorporated anybody's comments yet.
Okay, so initially, our first comment regarded closeouts. We would like to see closeouts excluded from bill and hold as a sort of counter-indicative of what closeouts are. The closeouts are meant to move the product through the system quickly. To include them in bill and hold is just moving a problem from one area to the next. So our preference would be to exclude closeouts from the advisory or from bill and hold. We're thinking our second point in number 5 having to do with public warehouse versus a warehouse that is controlled or owned by the specific wholesaler. We're assuming that we would like to see the use of a public warehouse, which a wholesaler is already using for their ongoing business, to be also used as the bill and hold location for the retailer.
So, and this was something I was not aware was happening. The smaller wholesalers are actually, because I don't understand how that would still be bill and hold, because you're putting it in another warehouse. At that point, the retailer owns the products.
We'll back up a second. Many of the smaller mid-tier wholesalers use a third-party service provider as their public warehouse.
But it is a public warehouse, correct?
Correct. Yes. The bill and hold would still be under the account of the wholesaler. The
So
wholesaler.
you're passing through the expense of the public warehouse through the whole?
That's exactly what we're doing.
And can I ask you why? Why wouldn't it be the retailer's responsibility to warehouse it?
Because the public warehouses don't want to open 100 accounts for 5 to 20 cases each with 100 different retailers.
And who's delivering it to the warehouse? The wholesaler?
You mean, the goods are staying in that section of the warehouse that the wholesaler has.
Oh, I see. Okay. Okay.
Product's already in the warehouse, it's just the idea that you're segregating it somehow as a bill and hold versus the ongoing inventory for the
Okay.
wholesaler. Then there's a question, probably a little detailed, is that if something comes into storage between the 1st and the 15th of a month, standard operating practice of a public warehouse is you charge the full storage for that month. If it comes in between the 15th and the end of the month, it's usually 50% of the storage rate. So we just want to make, that's operating practice that the wholesalers currently pay the public storage warehouse for. So we'd like to carry that through to the bill and hold.
Well, I don't see how what we have here would affect that in any way. We're not really commenting on that.
Well, just define, and again, it's continuity because that practice varies from wholesaler to wholesaler. So what we're saying is, if we're going to address this, let's make everybody handle it the same way, if that's the intention of the directive here.
I mean, when particularly a public warehouse is charging a full month or a half a month, I don't know that we need to get involved in that.
Okay, so the understanding is that that's an acceptable practice?
Yes.
Okay.
Whatever, we're not here trying to regulate differently what the public warehouses are doing right now that are operating presumably within the bounds of the law.
Okay. Then in point 8, where we talk about whether or not payment has been made for the product and the responsibility of the wholesaler to release the product, whether the product has been paid for and or the storage costs have been paid for, we think it should be an obligation that the payments due either for storage or for the product should be made prior to the wholesaler being responsible to release the goods, because therefore it destroys any leverage that a wholesaler may have. Plus, public warehouse law, you have a lien on that product by the warehouse if it hasn't been paid for by the storage client. So we're just carrying that through to the retailer relationship.
Okay.
And also definition in the same on point 8. We're talking about a 6-month period of time. We would prefer a smaller period of time, obviously, because for our standpoint,
Well, if we say 18 or a year or 6, it's not stopping anybody from going to a smaller period of time.
so the flexibility would still exist for the wholesaler to establish their own rules.
Yes.
For the time frame.
Yes.
Okay. Then on point 11, we'd like to see that we're not replacing goods that have been placed into bill and hold. If damage is discovered or pilferage or something along that line, the credit's given to the customer. They're not entitled to replace that product with another product because it may not longer exist in inventory or be available.
You want to give a credit to them?
Yes, if, for example, they buy 50 cases and it's bill and hold,
Right.
and when we go to ship the last 5 cases, we discover there's only 4, and 10 bottles, 2 bottles are broken, due.
But it's the retailer's product.
Correct. So
So,
the retail is in a public warehouse situation, the public warehouse would be liable for the cost of that product.
right?
We, as the wholesaler, someone would have to fulfill that obligation of crediting back the customer for the lost product.
We bill back the warehouse reimburses us, and then we reimburse the retailer.
But you're talking about a case that's been destroyed or has gone bad, something of that nature.
Not bad,
Not that you didn't have enough.
No, dropped,
dropped, let's say.
damaged.
Uh-huh.
And also the idea of what the timing would be of this advisory and what the retroactive effect might be, because bill and holds already exist in the system. So the question is how these rules would be applied. Do we have a waiting period? Is it something that existing bill and holds are excluded? It's only new bill and holds going forward. So just some definition as to what you think the effective date would be of whatever the provisions are.
Okay. Thank you.
Thank you.
Morning, my name is Martin Mailer. I'm the attorney for the Retailers Alliance. A member of the Retailers Alliance, Mark Herman, is going to make a presentation on behalf of.
And just for the record, we did get an email of written comments from Mr. Saunders as well, but go ahead.
Good morning. So the first point is regarding gifts and services. We don't believe that allowing bill and hold with a fee, as long as the same rate is charged to all customers, would constitute a gifts and service.
We agree with you, but the problem is that that's not what's happening.
Right, so we're saying as long as they're charging a reasonable rate, at this point in our industry, where almost every wholesaler has almost every item exclusively, we as the retailer can't really be influenced by a bill and hold fee, because if we need to buy product XYZ, we have to buy it from that wholesaler.
But not every store is carrying, they're all alternative products. You may want one type of vodka, there may be something that's an alternative that you would go for if you're getting a much cheaper bill and hold. And some of the warehouses are charging a cheaper bill and hold, some of the wholesalers, I should say. They're not all charging the same.
You also don't have to take advantage of the quantity discounts.
Well, in our market, to stay competitive, we have to.
No, that's the point, though, is that because of the bill and hold being available, you can take advantage of the quantity discounts.
Correct, and the volume items that we're speaking of which we would need to utilize bill and hold for, those are all items that most retailers can't live without, and those are the products that we're speaking of.
That's true in many cases, but not all cases,
Okay.
in my experience.
To your point, Mr. Chairman, about an alternative product, that's not true. I mean, when someone walks in the store and wants Dewar's, he wants Dewar's. If you say, I've got brand X,
I know a liquor store where I live that does not like to deal with certain wholesalers, and he frequently will not carry those brands and will upsell them on something else.
that's his choice.
I understand that, but that choice shouldn't be made because someone is getting a cheaper rate at a wholesaler for a bill and hold.
The point is not that you're buying the product because you get a cheaper bill and hold. If the store that we're talking about wants to have Dewar's, it can't go to two different wholesalers and ask them, okay, let's negotiate as to bill and hold. If they want Dewar's, they're going to get Dewar's.
But I'm saying that decision could be made based on a profit margin that is affected by the amount of the bill and hold. You're right, it may be they want Dewar's, but they're going to get this other product so much cheaper because they can buy a quantity discount, which they can then store for much cheaper than they would for the Dewar's.
They will try, but if Dewar's is in the store.
Well, it doesn't matter if it
Mr.
works or
Mailer?
not.
It's the customer that rules.
Mr. Mailer, you need to speak into the mic because they can't hear you.
It's the customer that rules, not the.
But there's not, I get that, but you're telling me then that someone is not at an advantage if they're charging less for a bill and hold.
Not if you can't get the product from them.
That's assuming that this person's coming in and just wants Dewar's. What about the issue where they're coming in and they want to try vodkas? There is an advantage.
Who's the they?
The customer.
Retailer or the customer?
The customer.
But that, we don't know that going in. I mean, I think the premise is incorrect. It's not as if we bought the other scotch in the hope of because we've got a better bill and hold. I mean, we're ruled by what the customer wants. So if we go into I'm sorry, if we order the Dewar's, we're not getting, there's no advantage because my store, or his store anyway, gets the bill and hold at the same price. The store down the block gets the bill and hold at the same price. There's no gift or service that would influence.
Well, see, I disagree, so.
I mean, yeah, because your basic premise is that you'll upsell some other product.
Well, we're not the only state that's dealing with this issue. And so other states have recognized that there should be the same, at least market rate for the storage. We're not the only ones that are doing this.
Well, let him go on, but the term market rate is what is a tremendous problem. The problem being that, as was brought out by Mr. Danow, the warehouse, the public warehouse, is in the business of storing goods and making a profit on that. The the wholesaler has made his profit already. I mean, he's told the licensee it costs X dollars, and I would assume his markup is there to begin with. Whether there's going to be a bill and hold or not should not influence the price that the retailer pays for the goods. It's just something that's there, and it's not being given to one retailer over another retailer. Once the policy is set by the wholesaler, all retailers are in the same position. So there's no.
See, I disagree. I don't believe they are in the same position. Because if a person decides they're not carrying one of those products and then they're going to use an alternative product, they are then forced to pay more for that alternative product if they desire to bill and hold it.
But that alternative, that's your premise, but I don't think that's.
Well, then we agree to disagree, but that is my premise.
So you're holding bill and hold up for ransom because.
I'm not holding it up for ransom. I believe that there should be a level playing field on where things are stored. You just heard a group of wholesalers come up here that basically are using public warehouses for bill and hold. So their retailers are paying more because that's a public warehouse.
But at the same time, I'm assuming whatever product they have is a product exclusive to that wholesaler, and so whether you buy it or not, everybody who goes to that wholesaler is paying the same bill and hold price. It's the product. It's what.
I'm telling you that in my mind, it's not always the product. There are alternatives that people will buy based on price, and it may not be Dewar's. It may be something else, and this bill and hold will affect the price because it'll affect the cost. But continue.
And so respectfully, regarding other states, a lot of the other states where there are the bill and hold issues, there is not the exclusivity that there is in the New York market. So you could have an unlevel playing field if wholesaler A has Dewar's, for example, and charging a lower rate than wholesaler B, then retailers could be influenced to go by wholesaler A. And again, the volume of product that we're doing on a national brand like a Dewar's, if we're going to use that example, would be significantly higher, which we would need to use bill and hold as opposed to the upsell product that you're referring to. The other unintended consequence would be a smaller store who doesn't have the amount of space would have to be paying this higher rate as opposed to a larger store that has a larger basement or a larger storage facility within their store. You would create an unlevel playing field in which the smaller store then would have a disadvantage by having to pay these larger bill and hold fees.
Well, they're already paying bill and hold fees.
So, and if they're going to increase, which is what would happen in this advisory.
Well, why should they? And they're to another point. Why should they pass that cost on to the wholesaler? If the wholesaler, many of the rates that I've seen, the wholesaler's not making money on storage. They're getting hurt by it. Meaning that they could be using that space for other product that they could be selling, or if it was at a higher rate, at least break even, whereas now they're losing money.
Right. I'm okay with them not losing money, but I'm just saying just to have an artificially increased rate.
It's not artificially increased. It's going to go basically, ideally it should be a market rate. And I realize your point is that the public warehouses have other costs that the wholesalers don't. But at the end of the day, the alternative for the retailer is to go to a public warehouse.
Okay, which would also increase the cost to the retailer
Right.
and to the consumer, the end user. The other point is on number 8, which the time frame. We are in agreement as well that we would like to see the change in the advisory go from 6 months to 18 months, just based on standard industry practice and the amount that.
How long typically do you, and I know that your alliance represents a lot of smaller stores. Typically, how long is the bill and hold? Well, I mean, Mr. Saunders' store is small, so I'm using that as an example. Typically, in a store like that, what is the bill and hold? What is the hold period?
I don't want to speak specifically for Mr. Saunders' store, but I would say typically it could be up to 18 months, and it could be as little as 6. But I think to have the leverage to be able to use it up to 18 would make sense. It also could pose logistical challenges if you order a certain amount of goods and you don't sell them at the rate you expect to sell them at, and 6 months later they're knocking at your door with a truck full of goods that you don't have room for. I just don't think that was the intent. So we would like it to see to go at least 18 months as well.
I don't think that's unreasonable. reasonable.
And as far as number 7 with setting aside specific products, we agree that there should be a designate on each item that would say either various vintage or flow vintage, as Mr. Donow said, or vintage. So where the flow
What
vintage.
about giving the retailer the right to dictate whether they want the specific vintage?
Well, they do that now. So if there are items, some of the items just say VV or variant vintage. Some of them do say a vintage. So, right, if we're buying 2013 a first growth Bordeaux, we obviously want that item.
Right.
So as long as it's specified that way on the bill, they should be holding it. But you're, in the advisory, number 7 says the wholesaler does
No,
not have to
I
set
understand
aside.
what the advisory's saying, but I'm
Okay.
talking about what Mr. Danow said. Assuming we go to the price posting, if it says various vintages, should the retailer also get the option to say, even though it says various vintages, we want this year of this product?
I think we're okay with accepting the practice of various
Okay.
vintages. But again, they would have to be set aside. So
Right.
that's a little contrary to number 7. I'm just saying it from just on its face. You specifically say that the wholesaler does not have to set aside a specific product, but we're saying if it's a vintage specific, then you do have to set that aside.
Yes, right.
Okay. We would also like to see that if there's any future changes after this, that the wholesaler would give, or if there's any wholesaler policy changes, that they give retailers at least 90 days' notice in advance of any storage fee changes. We'd also like to see that the wholesalers be required to deliver bill and hold goods either with the next standard delivery or within 3 business days. The last point,
Hold on, I want to go back to your, what was the last thing you just said? I just got the 90 days notice. What was the other thing?
it's in the email from Mr. Saunders, it's number 13, if you have the email there. We have a new number
Okay.
13. We would like the wholesaler to be required to deliver any goods in bill and hold with the next standard delivery that the retailer is receiving, or within 3 business days, whichever is greater.
Okay.
And finally, a lot of wholesalers have a minimum delivery quota. There's not a level playing field now where what we'd like to see is that if a minimum quota is set, for example, some wholesalers rather have a $1,000 minimum delivery fee, we'd like it to be mandated that any item in bill and hold, that value is calculated towards that minimum fee.
Explain that to me.
Yeah, say it again.
So if we have 100 cases of something, or let's say we have 10 cases of something that's $100 each.
Right.
If we order those 10 cases, that should meet the minimum $1,000 requirement. Or if we order 9 cases at a bill and hold and then a $100 case at a regular inventory, that should meet the minimum $1,000 also. So we're saying that the calculated value of the storage of goods in bill and hold should count towards the minimum delivery fee when they're making a delivery. Because if we ordered $1,000 not at a bill and hold, that would count. So it's the same value
What
as
if
on
you
the truck.
what if you order $1,000, or what if you order $1,200 up front and 1,000 of it's going into bill and hold?
I'm saying on the release from bill and hold.
So only once?
Correct.
Okay. Okay. Yes.
You, Mr. Chairman, you indicated at some point that you know that a number of wholesalers are losing money. I mean, if part of the purpose of this advisory is to bolster a wholesaler, that has nothing to do with,
That's not what it is. It's that I'm finding, having looked at this, that a number of wholesalers are charging one price, and there's another that are charging significantly less than that.
but not for the same product.
No, it's not for the same product, but it's for the same service.
You mean within the same wholesaler
No.
organization? No. I mean, at least the wholesaler is being consistent as to all its products, whatever it is, it is. I don't think that the authority should stand here and. try to
See,
bolster-
the way I look at it, retailers, you believe retailers only make choices based on what the brand is that they don't have. I believe they make choices based on profit margin as well. And when they can get a better profit margin because they're getting a break through the bill and hold, I see that as a gift and service.
But they're not getting a profit based on the bill and hold. They're getting a profit based on, when somebody walks in the door and says, I have an alternative scotch, and it's better and it's cheaper, they're not thinking about the bill and hold aspect. They're hearing that it's X dollars. That's what attracts a new product.
If you're going to hold something for 18 months and be charged per case of 100 cases, and they're going to charge 10 cents, and another person for that other alternative scotch is going to charge 25 cents a case, there is a cost there.
But the cost, you know the cost when the presentation is made, when the solicitor walks in and says. "This is
I
what
understand that, but it shouldn't be based on the fact that the storage is cheaper by one wholesaler than it is by another. That shouldn't come into play.
But it doesn't. That's what I'm trying to
I
tell you.
disagree. I think that it must, because it's the profit margin is being eaten up to a certain extent by that discount.
Chairman, can I just ask a question too?
Yes.
If a retailer is looking at buying product, right, and it wants to get a volume discount and buy a lot of product,
Correct.
right, isn't going to be influenced by the fact that I can put this stuff in bill and hold because I can't put it anyplace else.
Well, he's going to need, if what you're saying is, does he have enough
He's
space in the
going to
store?
factor, he's going to factor into the decision, I can buy this product because the wholesaler is offering me bill and hold.
What, no, he's not buying it because, well, all right.
He's buying the
You can tell-
quantity.
If he's buying
Let's
it-
put it this way, if the wholesaler wasn't offering the bill and hold, and the retailer wanted to buy the product and had to go someplace else to store it,
Right.
that would make a difference in the decision, wouldn't it, to buy the product?
I don't think so, no. I think if you're going to buy the product, it's because the price, whatever that price is, enticed you to buy the product in the first place and it's given you the risk. You're going to take the risk of trying to sell that product in your store because you bought it. The fact that you have a bill and hold at a price other than what, again, the premise is for the sake of argument, if Dewar's is being charged at 50 cents a case, and this Brand X is being charged at 25 cents.
Forget about Brand X, just talk
But
about,
that's what we're talking about.
no, that's, my question is different, okay? There's product, and there's a really good quantity discount available.
Okay.
Are you telling me that the fact that bill and hold's available doesn't at all factor into the retailer's decision to buy the product at the quantity discount?
We're talking apples and oranges.
No, no,
Because-
but-
No, wait, no.
But could you just answer the question?
No, the answer would be no, because if I'm interested in a quantity discount, I'm basing it on the price that's being given to me by that wholesaler. And if I do decide to go with bill and hold, I know that the guy next to me, if he's interested in the same quantity discount, will get the same bill and hold. So there's no advantage
I'm not,
to me.
no, see, you're doing apples and oranges.
No, I'm not.
There's discrimination between retailers, and then there's gifts and services. Gifts and services have nothing to do with discrimination, has to do with inducing the retailer to buy the product.
Correct, but that's the part that you said
That's my
now,
question.
I'm telling you, it's my position, that it doesn't induce the retailer to purchase that product because of a certain amount that's going to be attributable to bill and hold. What happens is, when they walk in the store, the solicitor says
Now,
it's
the fact
$10 a
that the
case
fact
or
that the
$100 a case,
wholesaler can
whatever
say, "I'll hold a product for you until you're ready to take it," does not at all factor into the retailer's decision to buy the product.
No. If he offers it to me personally and not to the guy down the street,
To
no,
any
that's one
to
thing.
any retailer.
But if he's doing it at the same price, it has nothing, it's not a gift or service that influences you to buy the product. If he's offering it to everyone, that's not a gift or service that influences the purchase of that product. And to think that way, I think, is an improper.
So a
assumption
retailer
on the part
doesn't,
of the
a retailer doesn't say,
authority.
"Look, I can buy this product at this quantity discount," and they'll hold it, so I don't have to worry about going and finding a warehouse someplace where I can keep the product myself.
I'm not the only one it's being offered
I'm not
to.
talking about discrimination. I'm talking about an inducement to get the retailer to buy the product at that price.
No, I would say no, that.
There's no possibility that could be happening.
No, because they're not, the price is the price. The bill and hold is a cost to the retailer. It's over and above whatever the price is. So no, it's not an inducement. It's costing that retailer whatever the number is per month. That's not an inducement. No, it's not at all. No.
Okay, well, we agree to disagree.
So I have 3 points.
Well, I want to ask you one. Do you have an issue with the 90 days notice of any storage
I have no
change?
issue, I have no issue with 30 days. 90 days, I think, is too long. Again, this is a question, I don't think that the Liquor Authority should be setting policies for wholesalers, and I think that
Well, what is it now if you change your,
in Empire, it's 30 days. They give 30 days notice. I think that you have to give the retailer a reasonable amount of time to know that you're going to change your price, and so that they have enough time to make alternate arrangements if they choose. And I think 30 days is reasonable. You make it 90 days, and it's unreasonable to force, especially, I think it's counter to the rest of the SLA's argument, which is, I'm looking at it, and I think the prices have gotten too low. They're out of line with what it costs me and what the marketplace is. And now you say I have to hold the wrong price for 90 days. Now you're actually forcing me into the very,
Right.
okay.
okay.
The second thing I would like to say with regard to that, but again, 30 days I think is reasonable. The second thing I would like to say is that we can't just use, with regard to the flow vintages, those that are marked VV. The problem with that is that the supplier is the one that marks the original way that this takes place. So I think that it's best to use the item number and to work with the idea that if a retailer really wants one that, that is a flow vintage and says, that's the one I want, he should say, that's the one I want, because they all know it. And the third thing I would like to say is that the Liquor Authority has taken the position, and correctly, I believe, that it is for the wholesalers to set their own delivery prices. And in fact, the Liquor Authority's position is that there is no need for a wholesaler to charge for delivery in the first place. So for you to get involved in the policies of the wholesaler as to whether or not it's 100 cases or 10 cases or 15 cases is, again, stepping out of the purview of the Liquor Authority and into the nitty-gritty of the business and price fixing on behalf of wholesalers, and I don't think that's either the job or within the purview of the Liquor Authority. That's the kind of thing I think you should stay away from.
Thank you.
Thank you.
Anybody else? All right, well, we'll take these back and next meeting. I mean, we're not taking any more public comments on this, but we will vote on it at the next meeting. Next.
All right, now we're going to go to Buffalo, and the first item there is 348 J.D. Wally Holdings Incorporated.
Chairman, Commissioner, my name's Chester Mintet. I'm the consultant that did the liquor license application for the applicant Jason Wallace of J.D. Wally Holdings Incorporated. It's a liquor store that's approximately 2,200 square feet in East Rochester. It will be the only liquor store in East
So
Rochester.
let me stop there. Are there any protests up there?
There's no opposition present.
Okay, go ahead.
There is, it has a population in East Rochester of approximately 7,000 people, and it would be the only liquor store in East Rochester. And we're here to answer any questions you have about the application.
So his wife owns a liquor store?
Yes, sir.
How nearby is it?
It's in downtown Rochester, so approximately, I'd say 5 miles, maybe 6 miles.
How long has she owned that?
She's had that, I believe, since
2009?
2009.
Any history with that?
2008 or 9.
Nope.
Have you ever worked there?
I have helped out there, yes.
Are you going to continue to help out there?
No, the two stores will be completely independent of each other.
I was assuming that. I'm asking if you're going to continue to work there.
No, I will not.
Do you work there now, or have you currently just helped her out?
I'm
you say it?
helping out, and, based on the note that we said is once, if I am approved for my license, I will sever all ties with it.
was this, it was disapproved pursuant to Divisional Order 589A. Okay, thank you.
So you had a license canceled back in 2001?
Which license you're talking about, the 240 South Avenue Incorporated?
814 South Clinton?
Canceled or just went out of business? It just went out of business.
It indicates that we canceled it because,
They didn't pay the second installment. Back then, we were only getting one license fee for a 2-year license period. It goes back a few years. And they didn't pay the second installment.
so you owe us money.
Something
quite.
I'm not aware of.
Yeah, I think forget about it.
How much of this 2,200 square feet is going to be retail?
I would say 1,600, 1,700.
Okay.
Ready to go?
Yep.
Yeah. I'm going to vote to approve. There's no protest. Looks like the other stores are holding their own, and I think the public convenience and advantage could be served.
I'm going to vote to approve as well. The four closest stores, 3 of the 4 closest stores are showing increases. The closest store is 1.2 miles away, and over the last 4 years has gone up 200,000 in sales and does well over 2.6 million a year. The 4th closest is 3.6 miles away and is doing over 20 million a year. And as Commissioner Ford pointed out, there's no protest. So given that the other stores are showing increases and the distance that you're going to be away from the closest store, I'll vote to approve.
Thank you.
Thank you.
All right, the next item, also in Buffalo, 340 Statesman Geneseo LLC.
Good morning, everyone. I'm Robert Romano. I'm here with Rocco Dragiani, who is the principal of the Statesman. We are here to give a conditional offer of $12,000 of satisfaction in full of the charges. We've submitted to the authority, which we've worked with counsel's office to come up with a plan that would allow this premise to remain open and still allow under 21s. We did so. We've submitted a floor plan that shows that we'll be basically segregating the 2 categories with a small wire, well, it goes up to the ceiling, but a wire mesh fence. And there will be absolutely no transfer of any beverages, alcoholic or non-alcoholic, between the 2 areas. There'll be one entrance where they will be separated. I can tell you, as I mentioned in my paperwork, I've been here many times. My child, my daughter still goes to Geneseo.
You've been in this bar? You've been in this bar?
I have been to this bar several times. And I've known Mr. Dragiani for approximately 6 years now. He is.
So have you known him? I mean, my big concern here isn't just that there were obviously allegedly a significant number of people underage drinking, but he actively, on more than one occasion, obstructed the investigation. In fact, he interrupted interviews. I mean, what is alleged that he did in here, given the fact that you know him? So I would imagine you have advised him in the past, would indicate to me that he's not listening to anybody.
Well, I think he can best speak out on his own behalf on that with regard to.
Well, then maybe he should.
Right.
Mr. Chairman, and I've heard this allegation numerous times that somehow I or someone who worked at the Statesman has obstructed interviews or any investigation, but I have yet to understand exactly which interview or where this occurred, because I've been there under all the times that it's been open, and I was there when the SLA with a large number of police conducted a raid in January of 2015. 2016, and there was no obstruction of any investigation.
Well, January 23rd, 2016, our investigator Burke was in the process of interviewing bouncers when you and your manager interrupted the interview and attempted to interfere with her investigation. You ordered the male bouncer that BCI Burke was about to question and all the other employees within earshot not to talk to the investigator. You're telling me that never happened?
That did happen, Mr. Chairman.
So why
but
would you?
That happened on the advice that, generally speaking, people should not speak to investigators when they have the opportunity to speak to an attorney.
And that is where you're being misled. No, there was not a criminal investigation going on.
I think at that point, Mr. Dragiani was under the mistaken impression that he was not obligated to discuss the matter with the authority. But I have since instructed him otherwise.
I mean, that to me is I haven't seen obstruction since I've been here to this degree. Especially when he was, whether he knew or didn't know about the number of people that were underage in the bar on the night that we're talking about. I mean, so I'm not inclined to accept this because I don't see, given what happened here, that this fence is going to do a heck of a lot. What I would probably agree to is something that would indicate that no one under 21 will be on the premises ever while it's open, and the dollar amount's going to have to be significantly higher. And if what I'm being told didn't happen, then he should go to hearing. But if it comes out of the hearing, it's going to be probably a lot worse.
Mr. Chairman?
Yes.
Mr. Chairman?
Yes.
I'd just like to point out, I'm not sure if the board is aware, that the Statesman has been what is colloquially referred to as an under-over bar. So
it looks like it looks like on this night it was mostly under.
No, what I'm trying to say is that the business of the Statesman is that there are people over the age of 21 and under the age of 21 permitted, acknowledged. It's not that there were under 21 that we didn't know were under 21.
I get that, but there were a number under 21 that were drinking. The whole premise of an under 21 and over 21 is that you're able to control the number of people that are under 21 from drinking, and you were not able to control that, or you decided you weren't going to control it. And I don't know which it is.
I do not agree with the 400 pages of documentation that was submitted by the State Liquor Authority. I believe that a solid 90% of it is unsubstantiated, without evidence, and is hearsay.
Okay. Well, then hearsay is completely admissible, but if that's the case, then this case needs to go to hearing. I mean, I'm not here to make decisions on what can be proven and what can't. I'm here assuming that what they're telling me happened, if you want to make a settlement. If you don't, and you're telling me it didn't happen, then we move on to the hearing.
Well,
I don't have a problem with that because I don't go to the hearing. So,
what I'm saying, you asked me if there was an obstruction. I mean, I didn't classify it in my mind as an obstruction of an investigation. I didn't realize that someone is required to speak to the state without representation of counsel. I still didn't think that was the case. And as far as the under-over, I mean, there's a lot of pages of allegations in the documents that were submitted that are simply one person saying what they think happened. And I would like to also point out, since we're on the matter, that during the overall investigation, at least 80 or 100 people were not allowed to leave the premises until they spoke to the SLA, and they were told by the state police that they wouldn't be allowed to leave the premises until they spoke to the State Liquor Authority. And I don't know that that's legal, but it certainly didn't seem on its face that it is.
well, then that you have a lot of questions that to me would indicate this needs to go to hearing. So if you want to talk about no under 21 and more money, then
We've discussed that, and I think it doesn't work in his business plan, so I guess.
Okay.
I'm saying 118 sustained pattern of noise, nuisance, disorder, and visibility.
Could you repeat that, sir? I couldn't hear you.
I said, I'm reading in this report, 100, sale to minors, failure to exercise adequate supervision, 118 instances.
Well,
118 instances
Of
combined of,
118 sustained pattern of noise, nuisance, disorder, and disability.
That's the section number, section one.
Section number?
Section number 118.
Oh, section 18, all right,
I thought that was
all right.
excessive.
Okay.
All right, so.
Yeah, he can vote, but I don't, at this point, it doesn't matter.
No,
Deny the
I'm
offer.
going to vote to deny that.
Okay.
Okay, thank you.
All right.
The next item, also in Buffalo, is number 310, Golden Land Incorporated.
Oh, section, doesn't say section 118.
They missed the word.
Good morning. My name is Justin Giuliano. I am the consultant that helped Zayar Tun of Golden Land Incorporated assemble the New York State liquor application for a liquor store on Elmwood Avenue in Buffalo, New York.
So the first question is, does the 200-foot law apply? And
We deem it grandfathered.
right.
The 200-foot hearing, or the 200 feet, there is, I believe it is a synagogue that's about 145 feet away, but their I think that they only do mass about once a month. Their primary use of that building is not specifically just for masses or congregation. They also have community activities there as well.
Can we take a 2-minute break? And it has been licensed for decades prior to that, so there simply is a gap from 3/30/16 until now, so we're not gonna, it is grandfathered in under the 200-foot law. In my opinion. Commissioner Ford?
And mine as well.
Great, thank you.
Questions?
Are there any protests up there for, regarding this store?
There's no opposition present.
So the question I have is that how's he going to be active, manage this place and still be run a taxi business?
So I was actually discussing that with Mr. Tun prior to this meeting in preparation, and he had told me that his wife, which is Yu Yang, she will actually be listed as a manager. And now that we do know that that will be the case, we will submit the appropriate manager paperwork for her supervisory role within the liquor store.
He just disclosed that he's separated. We don't have the name of the wife.
Right. So actually, when this was filed back in November, they were on a separation. They have since reconciled, and this will be her active role. Like I said, they've since reconciled, and they are back together, and we will give all of the pertinent information necessary for this to be approved.
Okay, and what's he going to do as far as product and services in the business that the other liquor stores nearby aren't doing?
As far as, would you be doing like wine tastings?
No, basically, yeah.
He was talking of, there's a counter within the premises that is, the previous people were actually utilizing it as the point of sale. Mr. Tun is actually going to be utilizing that counter for wine tastings. And then we are also installing a different point of sale. So he's going to actually have a much more interactive role with the public, and they will actually be able to do tastings in order to hone in exactly on the type of tastes and wines that that they are looking to purchase.
Okay. You have anything? I'm ready.
Yeah, you have in your application, it's 1,050 square feet of space. How much of that is retail? I always like to know that.
Mr. Tun will actually be utilizing probably the majority of that upper space. On the first floor, there is a very small back storage room that is the length of the premises, but it's only about 7 or 8 feet deep. But then also he does have a dumbwaiter to access the basement for storage as well. So the actual sales floor will be the majority of the upper half minus, maybe about 100, 150 square feet.
So this 1,050 feet, does that include the basement?
That does not include the basement.
Does it need to have all of that on here?
We'll get it straightened out.
All right, okay. All right. I'm willing to approve based on the fact that the premises has been continually licensed since at least 1973. And it's only been unlicensed for about the past year or so. Should be replacing an existing liquor store.
I'm going to approve as well based on those grounds, and the sales of the closest stores should not be affected since, as Commissioner Ford pointed out, this place was a liquor store until the end of March of last year, so I'll vote to approve.
Thank you very much for your time. I appreciate it.
Good luck.
Thank you.
All right, the next item, also in Buffalo, is number 318, 2828 W State Incorporated.
Good morning, members of the full board. My name is Jacob Pierkowski. I'm the attorney for Ariel Miller and her corporation, 2828 West State Street. I'm joined by Ms. Miller and her liquor license consultant, Robert Heil of SLA Solutions, and we're here on the matter of her application for a liquor store license. Just by way of just brief introduction here, my firm was retained to set up the new corporation, or set up Ms. Miller's corporation and proceed with the asset purchase agreement. Ms. Miller's paid the bulk sales tax at this point, and everything has been done in accord to allow her to set up her business and run it independently. We are aware of the prior problems, and Ms. Miller's had conversations with the staff already to ensure that it's very clear that she's the owner, she's going to be the only one running the store, and there should be no misunderstanding about who's doing hiring and firing and making all corporate decisions. Have anything to add?
No.
Okay.
So I guess my question is, why would she, given that she was aware, and I'm assuming you all were aware of what was pending with the former owners, why would she even buy the place rather than just wait to see what happens?
Well, the opportunity presented itself. Ms. Miller has been an employee of the former owners for about 10 years. And the opportunity came up and she was able to purchase it.
And exactly what is she getting for what she's paying? I mean, she's basically there's no money down, and she's got a $220,000 promissory note with the former owners?
That's correct. So she's buying all of the equipment, inventory, and furniture. And I understand that a liquidator's permit has been applied for, and all inventory and equipment have been accounted for with bulk sales.
And was she approached by them, or did she approach them?
I approached them.
Ms. Miller approached the prior licensee.
When?
Well, we signed the asset purchase agreement on November 14th of last year.
I mean, was she aware we were going to, assuming we could prove the charges, we were going to cancel the license?
I don't know of the awareness of that. It seemed very clear from my understanding when I reviewed the file that they were not going to remain in business.
Okay.
And I didn't know what path that would take, whether they would cancel themselves or that the authority would cancel. But from a business standpoint, it seemed like a position to obtain a store at a fairly decent price given the history and the location of it.
But she's not getting the building, correct?
No.
The building is rented, right?
Yes, it's $2,100 a month. There's a separate landlord, Ray Carpoletti. We have a lease.
And how much of the 220 is allocated towards the liquidator's permit?
Inventory is $150,000 in the allocation. $50,000 for equipment and $20,000 for furniture.
What's her relationship with the former owners? Are they friends? Or she just worked for them?
Miss Miller works for them, but she does date the brother of the prior licensee.
She dates the brother of the prior licensee?
That's correct.
What's his name?
Jason.
Was he involved with this store?
He was an employee.
Yeah.
He was never an owner, and he was never, his name wasn't involved in any of the prior veiling allegations.
Is he going to continue to work there?
He will be Miss Miller's employee, yes. In fact, about 7 employees are going to remain on. She thinks she might have to hire 2 new to assist, but...
So let me ask you this, are any of the other Tuckers going to work there?
There's one Tucker, Christopher, that is still employed. He's a brother as well.
Is Susan Tucker going to work there?
Absolutely not.
Is Nicole Tucker going to work there?
Absolutely not. And that was my initial conversation with Ms. Miller when she brought the file to my office. I said there has to be a very clear delineation here, and you're going to have to be very clear with these people who, although they're not family, you have a relationship with them, that they're really not even welcome in the store, because we can't have any implication that they have any ownership or any control.
Okay.
All right. I kind of have some concerns about former family members working there, but the fact of the matter is, I see letters of support from our Senator Catherine Young, from Sheriff Tim Whitcomb, even Fire Chief Scott Zink, and I see no other protest. So I'm willing to go out on a limb here and approve.
What's the monthly payment on the $220,000 promissory note?
$2,400 a month over 109 months.
All right, I'll approve as well.
Thank you.
Good luck.
Thank you very much. Thank you for your time. Oh, good.
Just, if we could, just one quick question. Is it necessary at this time to apply for a temporary permit, or will this be, they're trying to minimize their downtime, so we're looking for advisement.
You'll be receiving a letter that will give you conditions for approval. When you receive that, meet the conditions, then you can pick up the license.
Okay, thank you.
Thank you very
So
much.
that could be
Found them.
2 weeks, right?
No. We need their DBA, their
No,
certificate.
no, I mean as far as when they receive the letter.
Oh, the letter, they should get it within a couple days.
Oh, okay.
Not that bad.
Very good. Thank you.
Thank you.
No comments out there.
All right, are there any other matters in Buffalo?
There's no other matters in Buffalo.
Okay, we're going to move to Albany then. And the first item there is number 319, EZR Deli and Convenience, Inc.
Good morning. Mark Young, Bookkeeping Consulting Services, appearing with Flavia Akhtar. Just want to follow up, thank you for this opportunity. Ms. Akhtar had asked me to just relate.
All right, so I'm going to cut you short. This is a reconsideration. I'm the only no vote, so I'm assuming Commissioner Ford's vote is going to remain the same no matter what we do here? Am I a saint? Is that safe?
This is
Reconsideration, is this one?
319.
Yeah, hang on a second.
You voted yes previously.
Yeah.
So while he's looking at that, so we canceled the previous license, and the last time your client was here, she appeared to me to be hiding a relationship with the prior owner, which to me led me to believe there was something going on there, particularly since I didn't see any reason to even hide the relationship. But we have since gotten a letter from the landlord who is in support of your client and your client's family. So I'll reconsider this based on the landlord's representation that she has no connection to the former owner as far as the business goes.
And you now have your lottery license and SNAP license too?
Yes.
Yes.
So I'll vote to reconsider. Will you?
Yes.
Okay. And based on that, I'll vote to approve. Oh, you have to
Thank
vote
you.
again.
I vote to approve again.
All right, the next item in Albany is number 353, Manhattan RW, I'm sorry, what is the? Trapezzini Les LLC.
This is Albany?
If somebody signed in up in Albany for, let me go back and check. Oh, I'm sorry, no, it's the wrong number.
I would say.
Right number, wrong name. It's VAI Hospitality, Inc.
What number?
I'm going to have to track it down. Just give me a second.
317.
Good thing we come out here early to get these all in order. Okay, you can put your name on the record.
Yes. My name's James Moore. I'm the principal owner of VAI Hospitality, Inc. with my wife, Susan. She's ill today and is in bed with the flu, so
Oh, that's
she,
too bad.
she was not able to make it. I talked with council. I came here at his recommendation. A couple of letters from the mayor, I think a letter or two from council, along with tourism director, and then a personal narrative for me, just for the sake of expediency. And I think about most things have been said there, so I'm here primarily to address any concerns or answer any questions if the board may have some.
So it's a 500-foot case, and the city of Utica supports licensing you. My question was that we canceled the previous license at this location because it became a police focal point. And it is located in a residential building. So, but you indicated, at least somewhere I read, that you don't plan on having any security.
No, we do have security. There was a narrative that I sent that explains that in detail. It actually has a subheading of security, which was, my understanding, was one of the main concerns. I can briefly give you a rundown of how we're addressing that if you would like.
Yes, please.
We sought, prior to the board's discussion or anyone mentioning the situation of security, we actually have two other bars that we run. They're speakeasy type establishments. They require a password to get in. It's sort of a fun kind of thing. Those are located in Old Forge. So when we set this up, I know enough about Bering Street to realize the need for security. We were not able to find firms. It seems like the firms, they handle a few nightclubs, a football game or two, and then they grow beyond that for economic reasons and or liability reasons. We were not able to secure a security firm. We have secured a security firm, LB Security, there in Utica. The principal owner there is serving as our consultant. He has identified 6 or 8 of I'm going to call them his guys. They are licensed. They will go on our payroll, and then how they function, at what door, and in what numbers. The processes are all included on the narrative there that I sent.
Okay. So they'll all be licensed with the state, and you'll also license yourself?
Yes, sir.
Okay. And then the live music, what's that going to entail?
Live music is quite different. We're a much older clientele. It's mostly jazz, light blues, some acoustic. We have an 8-foot grand piano on the stage. It's sort of a throwback to an old speakeasy type show club. No rock and roll is about the only rule. And I'm a veteran of the music industry, so you will see we actually have. I walk around with the decibel meter. I'm a rock and roll musician's worst nightmare. So I walk around with the decibel meter, and the levels that we maintain in our facility in Old Forge will be similar. The method of operation here will be the same. 90, 95 peaks, 80 in the middle of the room. So probably the quietest thing that's been in that building in the last 35 years.
Okay. I got nothing.
Yeah, you're in the middle of the Utica Entertainment District. I mean, there's Lucan's right next door. They have the rock bands every weekend. Celtic Harp down the street. You're right down the street from the FX Matt Brewery, which has their Saranac nights every Thursday during the summer. Shots was the only bar on that street that was causing a lot of problems, so which is why it's no longer there. We have a letter of support from Mayor Palmieri. LB Security is run by, I believe, Nick Labella, who's former police chief of Utica. Is that correct?
That's correct.
All right, so, and the way you've run your other businesses has been admirable, so I vote to approve.
I'll vote to approve as well. Good luck.
Thank you.
All right, the next item, also in Albany, is 289 Smitta Liquor Incorporated.
Good morning, Mr. Chairman. Attorney Steve Denegris, the Denegris Law Firm in Albany, and Suresh Patel, the licensee.
So it's good that they got a scanner, but if you don't ask a 16-year-old for ID in the first place, the scanner's really useless.
Well, I understand that, and one of the reasons why we appear here also in support of the conditional offer, but also wanted to raise a few matters. My client felt very strongly about appearing and acknowledging the violation and also apologizing to the authority. Not only have we done that, but we also make sure now that the staff member has ATAPS training. We also make sure that there are prominent signs now that we're IDing, and also that we're IDing everybody now who's 30 years and younger, appears 30 years of age and younger. So we've tried to even increase that. We've made sure that the security system for cameras are available for any type of investigation or to assist the authority in any additional matters. And again, my client has been the licensee since I believe about 2005. My background is in law enforcement, Mr. Chairman, and I've spoken to a number of the police officers in the town of Colony. This business really has a very good reputation and is known as a responsible business. And just unfortunately, this was one incident. I believe we had one prior violation about 3 years ago. That individual who committed the violation was fired by my client, and we've had this one. I guess what I'm suggesting also, if the authority is to consider possibly maybe even mitigating the penalty down. If not, then we would speak in support of the conditional offer that we worked out with the county's office.
Yeah, I'm not going to lower it, given the age of the person, but I'll accept what you've offered.
All right. Thank you.
7,000 accepted.
Thank you.
All right. The next item in Albany is number 382. It's East Slope Ski Lodge, LLC.
Chairman Bradley, Commissioner Ford, members of the board, good morning. My name is Sean May. I'm here this morning with Spencer Montgomery, representing East Slope Ski Lodge and Apex Capital. This is a conditional no contest offer on an availing charge. The offer was $2,000. Submitted a statement of mitigation and 3 letters of support from the Senate Assembly in town. And we'll be relying on our statement today. If you have any questions, we're here to answer.
No, I'll accept the 2,000.
2,000 accepted.
Thank you, Chairman. Thank you, Commissioner.
Thank you.
All right. There aren't any other matters in Albany, so we'll move to the New York City calendar.
There's somebody
That's the licensing staff.
Oh, okay.
The first item is 311, LIC Wines and Liquors Incorporated.
Still morning. Good morning, everyone. Robert Romano. I'm here with Jasbir Gaba, who is the principal for LIC Wines and Liquors. If there's any opposition.
Is there opposition? Nope. Okay. Is this going to be an open store?
Open store. It's a very small store. There are 19 building developments in the immediate area. 2 years ago, there was an application that was approved for a store that never opened. The sales figures seem very strong.
Well, that's a question I had. Do we still have that license pending?
Which one pending?
127-6960.
127.
127.
It was June 2014.
We conditionally approved one, and
It's still a car parts or mechanic shop. And they never opened.
how far away is that from this location?
It's not. It would not be one of the 4 closest.
No city.
And the only store that had questionable sales, still had sales in excess of 6 million,
approved in
and I can show you
2015.
that that store
2 years ago.
really is not set up as, and that would be the one on 43rd Avenue, which is half a mile away.
Can I stop you there? What do you mean? So we never approved it?
It was, dates. Hang on, this is slow.
From what I could tell, it looked like
It was approved in June of 2014 and was disapproved by not meeting the conditions.
Oh, okay, so we just stopped, okay. So my question for your client is he owns a construction business in Virginia?
He does, and it's based out of Virginia. He does live here now, and I believe you're winding that down, but
Yeah,
you
I have a manager over there, he's running the business.
He what?
He's running my business.
He's gonna
And do you work just in Virginia, the construction, or is it all over?
No, just in Virginia.
So how long have you lived here? In New York?
4 years almost.
4 years ago? And how often do you go down there?
Maybe once a month. I usually go in the morning, I take a flight and attend my appointment and come back.
The store itself, as I said, is 700 feet. A portion of that would not be retail, would be storage and office. The development, Long Island City is, I believe, the fastest growing population in the city. 19 development projects, as I mentioned. I have photographs of all of them if you'd like to see. And as well as that store on 43rd Avenue, which does do significant business, 6 million. It is not really set up as a retail store. I have a photograph of it. It's really, it calls itself NY Wine Warehouse, and people.
So what is it, internet, you think, or?
I think the internet and also case sales. I mean,
Yeah, case sale is,
I have
there's no
I can
public,
show you.
Internet and what kind of sales?
We can't figure it out.
But there is a place you can go in, because there has to be, right?
It has to be, but it doesn't appear to be your typical.
Oh, I see, okay.
So we feel that for these reasons, that it would be to the public convenience and advantage in the granting of this license. If you have any questions, we're happy to answer.
I ask this question a lot. It says your total is 700 square feet. How much of that is retail?
about maybe,
About 600?
And some of the store is set up, there's like a mezzanine level a little higher up. It's actually only a few feet up. It's really, I would think the customers are going to be congregated in about 350 feet of space.
Okay.
All right. You ready? Sure. All right.
What'd you do with the store in Woodbury?
Woodbury, we sold it.
Because you didn't have it long. 2 years, huh?
I got a paid offer on that one and I sold it.
Yeah, I'm ready.
Yeah. I'm looking at the stores around you, and they seem to just to be kind of going up and down a little bit. If your retail space was any larger, I would vote to deny, but the three closest stores in 1,900, 2,500, 2,700, if you're only going to be 600, I think that it would be safe to place another license there, so I'll vote to approve.
I'll vote to approve as well. The closest store is 0.3 miles away and is showing a steady increase in sales, and the second closest is 0.5 miles away and is also showing at least over the last 3 years, a steady increase in sales. So I'll vote to approve, given the size of this store.
Thank you very much.
All right. The next item is 353, Trapezzino LES LLC.
Hi, good morning, everyone, again. Robert Romano. I'm here with Lucas Vincenzi, who's the principal of Trapezzini.
Is the community board here? No.
I'm not, the only disagreement, if you want to call it that, would be the
hours, right?
It's not even the hours. It's all we're looking for is what the previous tenant had, which was a pizza place. And this, I'd like to point out, Mr. Vincenzi, here's a free ad. It's
Can I see?
opening a very unique product, bringing in from Rome. And it's
high quality fast food.
it's sort of pizza and a pita, and also
It's about food.
It's all about food. This is an RW license. The previous licensee had hours. I have a copy of the license. It stated, stop serving alcoholic beverages at 12 a.m. on Sunday through Wednesday and 1 a.m. on Thursday, Friday, Saturday. That's all he's looking for. They wanted him to close at those hours, and they're just looking to remain open late. It's going to be a late night place. People are going to be eating.
So how long does he want to stay open?
That's it's not. They don't. If you want to give him extra hours to serve beer and wine, that's fine. We're not. That would be actually very helpful, and we would look very.
I mean, I'm not adverse. The problem I see with saying you're going to stop serving alcohol but stay open, it puts him in a level of jeopardy that if he's open and we go in there and it happens to be after he's supposed to stop serving, but somebody happens to blow it by 10 minutes, he's in trouble. If we give him an hour to close at, that might be later than what they're suggesting. At least he's safer.
It's up to you. Would you like to be open an hour and serve an hour later, or serve alcohol to 2 a.m. on the weekends and then close at 2 a.m. and 1 o'clock?
No, I would like to stay. It's not about the
It's really about the
alcohol,
food.
It's about the food, to be honest. Like,
And he's willing to take that risk. I mean, the
Okay.
registers, you can probably program the registers not to
I
ring
know,
up a sale.
absolutely. I mean, we don't want to have people, drinking late at our place. It's a nice place.
No.
It's not our goal at all. We would definitely would like to get something that is better than a pizza slice. That maybe at 3 a.m., to be honest.
So you're willing to stop serving alcohol earlier than your hours to close?
Correct. Which is exactly what the previous licensee had. We're not looking for anything else.
And what were their, what were their hours to close?
3 a.m. drinking, and also like we have a small selection of craft beer, like wine. It's not.
No, but it doesn't say when they were to close. Oh, so they were allowed to stay open?
They were open till 4 in the morning, I believe. It was Goodfellas?
Yeah.
Okay.
He said it was good.
And then the other stipulations that they have, you don't have any problems with them? Because I do. Not, I mean, it will not seek a change in class of its liquor license to a full-on premises liquor license without first obtaining the approval of Community Board 3?
We have no problem with that. They're not looking.
They're never going to give it to you.
Right.
Well, that means you can't even apply. Why wouldn't you just say without going to Community Board 3 seeking approval? It doesn't mean, you understand what I'm saying?
No.
If they don't approve, then basically this stipulation says you can't apply for a later, on-premise. I realize you don't,
He has no.
I realize you don't want an on-premise license, but you're
Actually,
giving
that
up a
came-
right to apply.
That came up, and we did that to appease them at the time.
Okay, then I'll leave it.
All right. It's not a problem for you.
All right, I'm ready.
So what hours are we looking for? What do you want?
The same as the other one.
Same as the other license?
Just, no rule as far as when he can close. I mean,
Well, the service of
diners are open
alcohol to
24
cease,
hours. I
correct?
probably, in all likelihood, wouldn't be.
Yeah.
But he'll stop serving at a very reasonable hour.
All right.
And you can program the registers not to ring up a sale. And he's not giving it away either.
So what hours are you going to stop serving? That's what I'm not clear on.
1
12
a.m.
and 1.
12 and 1, exactly.
Sunday
as they
through
are.
Wednesday, 12, Thursday through Saturday, 1.
Where's now?
Correct?
Correct.
Correct, all
And
right.
then he stays open if he wants to after that.
I'm willing to approve those hours.
And,
yes.
and in.
I'm willing to approve those hours too, so it would be 11 a.m. to 12 a.m. Sundays through Wednesdays, 1 a.m. Thursdays through Saturday for service of alcohol. The restaurant can stay open till 4. I am going to also put the rest of the community board stipulations in there, except for number 7, because that, to me, appears that they are trying to take the power away from this board to approve a full on-premises liquor license should one be sought down the road, and they don't have the power to do
Right,
that.
I was going to readdress that, but thank you very much.
But all other stipulations are in effect.
Without the hours and number 7.
Right.
All right.
Commissioner Ford?
Yes.
Thank you.
No, he voted, you're good.
Thank you.
Yeah, you're good.
Thank you very much.
All right, the next item is number 324, Lunchadelli, Inc.
So there seems to be well, why don't you put your name on the record and your client's name?
My name is Patrick DeLuca. I'm here representing Luci Deli. This is the stockholder, Mr. Molina, and we're here on a reconsideration of this disapproval.
So we actually have two cases today dealing with this same issue. What's your, okay. So the Deputy of
Can I-
Commissioner of Licensing is pointing to counsel. Yeah, and do you have an opinion on this? Because it would seem to me that they make a good point.
I think considering previous conversations and such, if the last bullet point on our advisory at the moment seems pretty broad, in my opinion, and it seems written pretty broadly. If it is the position of the members of the authority that we want to interpret that broadly, then I think that's a decision that can be made and be worked within. If it's to be looked at narrowly, that's another decision that the members can make.
So can you, just for those that our fans are sitting home watching at home on their couch, can you explain a little more specifically what we're talking about, the issue?
It seems to me there's some questions in regards to an advisory that has been in place, I believe, since 2015, if I remember correctly. In regards to questions that surround the ability of individuals who are not either green card holders or citizens, as is laid out, I believe, in Section 128 of 126, thank you, of the ABCL, and questions regarding the supremacy clause of the U.S. Constitution and how treaties impact our ability to regulate whether individuals who may fall outside of that provision of the ABCL are, because of the supremacy clause, otherwise allowed to traffic and receive a license, obviously, within the state of New York. My very quick update on this from yesterday. I know that there's not too much contention when it comes to people who are on the reciprocal treaty list that is, I believe, published by the Department of State, which really looks at the E1 and E2 investor visas. If I remember correctly, please.
You're correct, but on paragraph 4 of
Correct.
And that's 21, it says it doesn't matter.
Mhm.
And the advisory says that they can be stockholders independently of whether they work there or not, even if they're in their home country as owners. And in this case, his ability to own shares would fall under the advisory 21 because he is a citizen of a free trade agreement country, El Salvador. It is a free trade agreement
And I think
country.
part of the problem and part of the discussion that we've had internally is that particular question. I took a look yesterday at CAFTA-DR. I looked at all of the various provisions of CAFTA-DR. I also looked at the annexes of CAFTA-DR. It is probably one of the reasons I'm sitting up here and not writing treaties, because CAFTA-DR is not necessarily the easiest of items to interpret. However, I will say this: it's written pretty broadly, and the question that that we came to is this question on that fourth bullet point. What does it really mean under that fourth bullet point to either have a trade agreement and or an agreement for trade and I believe workers, if I remember the words exactly correct within that bullet point, and then how does it operate? If I remember, it may be CAFTA-DR 1012. There are some certain carve-outs that come within the annexes. I'm sure that you're aware. I don't know if you wish to speak onto that.
Because I have so many customers from El Salvador, and it seems that only my clients from El Salvador are the ones that encounter this issue. And if I could show you something, on the advisory, the list that it sends you to, after going through it, paragraph 4 says that you don't need an E1 or E2, but then on the bottom, when it sends you to a hot button list, it's the list for visas, whereas you don't need a visa at all to be a stockholder. And in Mr. Molina's case.
No, but I think what he's saying, correct me if I'm wrong, is you do need at least to have the ability to get one. Meaning that it doesn't mean you necessarily have to have one, but if you're not permitted to ever get one, then that would be problematic.
Tom, do you want to step out for a second?
Can I suggest a conference with council?
Yes. Wow.
Wow.
You got a thick check, you must have a thick checkbook.
To respect us?
Well, can you just, in the microphone, because obviously this is going to be,
Mark Miller, having nothing to do with this client, but everything to do with the Alcoholic Beverage Control Law. Since 1974, when I came on board at the Liquor Authority, it was told to me, because I read Section 126 Subdivision 4, that the exclusion deals with officers and a majority of directors, having nothing to do with shareholders. You don't ever have to set foot in the United States of America, and you can be a shareholder and be a licensee. That goes back to repeal. So I don't understand what this discussion is about.
well, the discussion's about the fact that this treaty is apparently written very poorly compared to other ones, but.
The treaty has only.
I get that, but we have another case on that's the same issue, exact issue, but it's a different set of circumstances, so most of it, we were discussing that, but go ahead.
Okay, and Kevin Dano, I was instrumental in adding this treaty stuff to this bulletin. It had to do with people who were otherwise not under the section of the law, so it has to do with an officer or a director who otherwise would not qualify. Then the treaty comes into play, and all of the issues that you're talking about then would come into play just the way you have been discussing them. But with regard to a shareholder, which is what I understand that this gentleman is, it doesn't come into play at all because the statute says he's qualified independently of the treaties.
Okay.
Mr. Marino is a stockholder, not an officer.
And he intends on working at this place?
He does now, and he has employment authorization.
Has he ever been licensed before?
You ever have a license before, person? No, I don't.
How long has he been here?
Since 2001.
And is he on a visa?
It's El Salvador has a unique, they call it a TPS. It's called Temporary Protected Status. It's sort of equivalent to almost a green card because, but it renews, I believe, every 18 months.
Every 18 months.
Okay.
And I never have a problem, and I can come back to El Salvador, come back,
Okay.
It's a unique country. That status is slightly unique. I think that's what's caused the confusion.
All right. I vote to grant reconsideration.
As do I.
Return to licensing?
Return to licensing.
Yes, return to licensing, and with the, obviously, emphasis on the fact that this gentleman is not an officer of the corporation, but is the sole stockholder.
Understood.
The disapproval states that. You good?
Yes, thank you.
Have a good day.
Good luck.
The next item is number 314, Moses and Rothschild Enterprises, Inc.
Morning. My name is Henry Warakomsky. This is the applicant. This is a new grocery store license in the village of Hempstead.
And there will be no consumption on premises?
No, it's off premise.
We know it's off premise, but that's one of the problems in Hempstead.
Yeah, well,
just
we
say
have all the
yes.
permits from the
No,
village, yeah. He has the village license from the village, the business
Well,
license.
so here we got an email from the mayor, and the mayor obviously is concerned about the village of Hempstead, and the one thing he's concerned about is the fact that many of these off-premise places become on-premise.
This is off premise.
Meaning, and when I say on-premise, I'm talking about in the front of the building as well.
Right. No, this
Does
is-
your client understand that?
Yes.
I don't need that. I have an email from the mayor, and that's what he's telling me his concern is.
No, this is off premise. He understands that.
So there'll be very little leeway if we end up with a charge here at any point that either someone was consuming inside or in front,
Yeah, no, this is all,
meaning that the license will be gone.
right, this is off premise.
I'll approve.
I'll approve as well.
Right, thank you.
Next item is 291 Soho House, New York Incorporated.
Good morning, Mr. Chairman, Commissioner. Donald Bernstein from Bernstein Rado on behalf of the licensee. There was a determination after a hearing on this disciplinary where the ALJ found that
7 of the 9 charges were not sustained. The only 2 that were sustained were failure to post the warning signs, which were off to the side, so the ALJ found that they were not clearly visible. That has since been corrected, and they are now conspicuously posted at the bar and have been since the investigation.
I do find this, and I'm not going to send it back simply because it's one minor charge, but on this, the ALJ sustained the failure to display license on November 21st, 2015, but dismissed the failure to display license from November 4th, 2015, and I'm trying to figure out how that is possible.
Because the investigator thought that a service bar was a stand-up bar. So one of the violations was failure to post a license or warning sign at that bar. The finding of the ALJ was that that was not a stand-up bar, therefore there was none required.
So you're telling me that the license that was not up on November 21st was up on November 4th?
No, it was dismissed because it was not a bar. It's not a stand-up bar, and there was
No, I understand that, but there must have been a license that was not up somewhere, because 2 weeks later.
Yes, there was, the license at the main bar was off to the side, and the ALJ found that it was not conspicuously displayed.
Okay. I'll dismiss 1, 2, 3, 4, sustain 5, dismiss 6, 7, 8. I'm sorry, sustain 8, and dismiss 9, $500.
Dismiss all except 5 and 8, $500.
Thank you.
Next item is 386D, Roebling Liquors Incorporated.
Donald Bernstein from Bernstein Rado on behalf of the licensee. And with me is Annetta Clemens Klensner, who is the owner by transfer from the original owner of the licensee, which holds a license that it has had since, with the prior owner since the 1970s for a liquor store in Williamsburg. We are here today on a request for reconsideration of a denied corporate change application. The denial was, I believe, from licensing. This is the first time, I believe, that this matter is before the full board. I would like to give you a little bit of a chronology. Basically, the application, which I was not involved with, there was prior counsel, was denied because after the transfer to Annetta, the original owner died, and the administrators of his estate challenged the transfer. The ruling of licensing was that until that is resolved, the corporate change would not be approved. So that's basically what happened. But let me just review the chronology. And by the way, the claim that was the basis for the denial is an action that the administrators commenced in surrogates court in Manhattan, where they alleged that the documents by which the prior owner, Sidney Cooper, transferred the shares to my client was somehow not enforceable. It is an allegation. It has not been tested in court. It has not been proved. It has not been sustained. I can tell you that when this first came to me, I wondered myself, how did my client come to acquire this? And I can tell you that in hours of conversations with Annetta, I am firmly convinced that the transfer occurred. It is documented. It is legitimate. If I did not feel that way, I would not be here asking for your approval.
Well, you're leaving a big part out of the transfer, though, aren't you?
Which is?
The $4.5 million stock account that goes along with it.
That has nothing to do with the liquor license.
Well, it's attached to the store, isn't it?
It's attached to the corporation. The corporation, I don't think it's attached to the store itself.
Well,
but
the
for whatever reason,
corporation.
Yes, but I will talk to you about that. And I think that after I speak, I would like Annetta to mention to you or talk to you about how she met Sidney Cooper, how their relationship developed. She has learned in the 15 years of her association with him a tremendous amount about this man and his family, his history, his business dealings. This is a gentleman who is extremely wealthy. He was a former CFO of Macy's. He worked for the government overseas doing audits in Europe. He had tremendous generosity buying businesses for family members, including $1 million car wash.
Well, I mean, we're not here to decide whether...
That's correct. I agree.
Whether she did get the transfer legitimately or not, but one of the concerns I have is when when did this transfer occur, and how much time passed before there was a corporate change application even in place?
So let me review the
Or a
chronology.
transfer application, really?
And I can answer those questions. So let me take it from when the transfer occurred. And you have the document.
Because normally they happen simultaneously, or at least one happens before the other. That did not occur here, correct?
That did not occur here. So the first, Mr. Sidney Cooper owned 100% of the stock. And after a long history with Annetta, he determined that he wanted to transfer the shares to her. He originally wanted to transfer them to a friend of his and give him the stock. That friend, who had just lost his wife, wasn't interested in coming to New York to do it. So he decided to give it to Annetta. The store had been in shambles. He asked her to work on it, to get it back operating properly, to show him what she could do, and after she succeeded in doing that, he signed an agreement that was prepared by an attorney, Norman Heller, that states that all of the shares of the stock are transferred to Annetta, that his stock certificate was canceled, and that she owned 100% of the stock. That is a document that you have, signed by both Annetta and Sidney Cooper, and notarized by Mr. Heller. I also have given you the stock certificate showing that she was issued 10 shares, which represents 100% of the stock. That was signed by both Annetta and by Sidney Cooper.
And that's dated April 19th, 2014?
Yes, that's correct.
And when did the
after that,
application to...
I think it was a couple of months later, where the licensee's accountant, and I'm not sure why they had their accountant do it, filed a corporate change application.
And this was after he passed away?
That was, right after he passed away, about 3 months after the transfer to Annetta was made. So yes.
So
all
that
things being
corporate change
considered,
application has...
It's a little late.
And it also has no... I'm assuming the estate obviously did not approve of it, and he wasn't alive to approve of it.
Well, let me answer that.
That's why we
In my
do these
view-
things first.
Yes, but, well, the estate doesn't have to approve it.
Well, if
because
he's
the
not
transfer-
alive, they do.
No, they don't, because the transfer was made before his death.
Which is why we make you do the paperwork first.
No, I understand that. So I agree with you, but you're talking about someone who, an attorney who prepared this document, who was not versed in SLA rules and regulations, and for better or worse, it is not infrequently an occurrence that a corporate change is effectuated and a filing is made. I'm not saying that's the right way to do it. It's not the right way to do it, but we have the facts that we have. So a couple of months after the transfer was made, the corporate change application was filed. At that point, the authority was notified of the pendency of the action. Now, one thing I want to point out that is very important is that there was no will filed for Sidney Cooper. Whether he had one or not, who knows? None was filed. The two administrators were appointed by the court. They are a niece and a nephew. Mr. Cooper was divorced, and he had no children. The reason why that's important for your consideration is we don't have a situation here where we have a will from Sid Cooper that says, I want to leave my assets or I want to leave my stock in Robo Brokers to so-and-so. And then you have that, and then you have another document that says, I'm giving it to Annetta. You don't have that. There is only one document signed by him. This goes to your question, Mr. Chairman, because it's important. We do know exactly what his intent was. There is no contradictory document.
Well, I'm not here to decide his intent. What I'm here to decide is the fact that this transfer was done months before the application was done. He's not around. And, you know, this could all be, in my view, resolved with the, and I understand council's attempted to have this done, could be resolved with the estate, because obviously there's a large asset that's going to go up in smoke which presumably someone's going to get, whether she gets it or the estate gets it, and none of you are working together to preserve it.
It is being preserved. Mr. Chairman, that's not accurate. It is being
Well,
preserved.
why
We are not-
isn't the estate signing on to the application?
I can't answer that because, well, I can speculate, but I can't answer that, and I'd rather not speculate. They don't want her to have it. They have gotten money from their uncle during his lifetime. I can talk about that.
It's not that she would get it, but why couldn't they? There was clearly a temporary situation set up where she was allowed by the court to run the business.
That's correct.
And keep the status quo.
And not touch the money.
And that could easily be continued through the fact that she could be licensed.
We have
And
asked the
you're not
estate-
working together to do that.
We have asked the estate to agree with us to allow this to occur without any, I mean, nothing that you decide is binding on the surrogate's court.
Right.
They have refused to cooperate. I know that
No,
my client's surrogate.
Let me ask you the fact that there was a court order that she was supposed to be giving books and records for examination, and that never occurred.
Well, Mr. Chairman, I don't agree with that, and that is a matter for the surrogate's court. There is discovery in a proceeding.
Well, it's a matter for the surrogate's court until we go and look and ask for the books and records, and they don't exist.
I am told, and my client is here, all of the books and records relating to liquor sales and purchases are there. They are at the store. I actually asked her to bring them here. She said there are 2 boxes full, so I said, forget it, don't bring it. We are happy to have an investigator
Then
go to
why
the store.
why aren't they allowed to see them?
Mr. Chairman, I'm not litigation counsel. We've produced a lot of records. We've produced ledgers. If they are having discovery disputes, that is outside the scope of this tribunal, I submit. It has nothing to do with the liquor license. During the course of litigation, there are issues and disputes that rise in contested litigation all the time. Any discovery dispute has nothing at all to do with the issue before the state liquor authority. That will be worked out, and they will figure that out. We are required to maintain books and records relating to liquor sales. We've got them. They're at the store. We're happy to bring them for an interview, or we're happy to meet with an SLA investigator. That should be the concern. I do want to address some other very important points, because you talk about working with the estate. We have no obligation to work with the estate, but they're refusing to work with us, and this is not something for them to approve or disapprove. They have no jurisdiction over this matter. In fact, when they commenced the proceeding, they brought an order to show cause. And in the order to show cause they brought, they asked the court to preliminarily enjoin my client from dissipating the stock, dissipating any assets, any property of the company, directing that the liquor license be deposited with the state liquor authority. That relief was not granted. The court only said that Annetta cannot further transfer the stock, which is fine. She has no intention of doing so. That she cannot reach the cash that's in the bank that has nothing to do with the liquor store, which is fine. She hasn't done that. She's not doing that. That's really outside the scope of licensing. What the estate is trying to do here is get you to give them the relief that the surrogate's court did not give them. They asked the surrogate's court for an injunction stopping my client from doing anything here and putting and transfer and surrendering or depositing the license with you. Let the surrogate's court give that relief if they deem it appropriate. They haven't done it. And I submit that the authority should not do that either. That the authority should pass upon the qualifications of my client, given the fact that she has submitted a signed and notarized document from Sid Cooper transferring these shares to her. Let's think about what the alternatives are. If you were to
I know what the alternatives are, but what I'm thinking about is the fact that we have a process in place, and the reason the process is in place the way it is to avoid situations like this. And your client and Mr. Cooper did not go through that process. So the reason that process is in place like that to avoid situations like this is so that we have some level of confidence that what she's accused of doing doesn't happen. And I don't have any confidence right now. Nor do I care one way or the other. But there was a process in place that was not filed here, that was not followed. I mean,
I understand that,
and that's why licensing said wait till the litigation is cleared up. That's not the reason I think it should have been denied. I think it should have been denied because the process was not followed, and there's no, in my mind, reliability right now.
A corporate change was, Mr. Chairman, I'm aware of many instances, for better or worse, where corporate change applications are not filed before transfers. There are situations where shareholders die and the corporate change isn't filed in advance. There are change in officers. There are resignations. It occurs many times. And we do our best to file beforehand if it's consensual and they're aware of the fact. But often that is not the case. And sometimes it is filed afterwards. I agree with
3 months afterwards? When she's, under that scenario, she's availing the license for those 3 months?
And if counsel's office brings charges...
well, I mean, that's what you're asking me to reward, is someone, because many times we take licenses under these scenarios.
I have had availing charges, and I've not had a situation, and I've had a number where we've paid fines, sometimes substantial, for an availing greater than this. She filed, she retained an accountant for maybe not best advised to file it. I don't think he really knew what he was doing. After it was denied, there were discussions with her new counsel and then counsel at the State Liquor Authority, who was told to refile instead of filing an Article 78 or request for reconsideration. That was done, and the only basis for denial was the pendency of the action. I understand what you're saying about the concern of the lapse, and it was a lapse. I don't think that that lapse of 3 months warrants the denial, because if this is confirmed denied, my client is out of this business, and there's no turning back, because she's out and she's gone. And if the surrogates court finds in a year or two that she was correct, that the estate has no valid claim, it's too late. She's gone. If counsel's office wants to bring an availing charge, they have every right to do that. We will do our best. I don't think at the end of the day you would cancel this license. And I would appeal to you
I don't know.
to
I don't have any more questions.
I think the estate's attorney has.
Oh, you're here? Oh, well,
It's up to you.
Do they even stand in here? I don't need, let me see where he's going first.
I would just want to say that if I'm not going to ask the other lawyers sitting in this room, but if I did, and I asked them how many of them filed corporate change applications after it was effectuated, I think you'd be very surprised.
It
I'm not
may
saying it's a
be,
good
but
thing to
the
do. I think it
benefit
would
we
be-
have is that this isn't a democracy here, up
I
here.
understand
so-
that. But I think the reality
And I'll be the
is
first to tell you I may be wrong, but I'll never admit it.
that I do not think a lapse of that 3-month period when she had engaged somebody to do it, relying upon them to do it, giving them the documentation, and for whatever reason they waited 3 months to file, warrants closing the store.
After he died. They waited 3 months, and you're dropping off the point right after he died. Well, that's a big deal.
If it was filed a month before he died, I don't know that we wouldn't be in the same situation. It may not have been approved.
He could have signed the application.
That's the point.
Right.
That's why the process is the way it is, but I don't know. You've been awful quiet over here, so.
Yeah, I've been taking this all in.
Clarence.
I like that. I actually think we're in this position right now because the process wasn't followed as it should have been.
But before you, I'm sorry to interrupt. I think that this is really unfairly severe to deny it based upon that. There have been instances of much worse availing, of undisclosed tied house, of repeated sales of much worse things where fines were paid, substantial fines were paid. To have a license effectively canceled, because that's the effect of what you would be doing, for a 3-month lapse, if it was in fact that much.
Well, let me talk to the estate lawyer.
Leopold Gross. I'm a lawyer with the law offices of Solomon E. Antar, and our office represents the estate of Sidney Cooper.
Which means part of your job is to make sure that all of the assets of the estate remain intact.
Correct.
You're aware that one of the assets, and I realize it's probably not a big asset given the size of the estate, is about to go up in smoke.
Well, but I also realize that continuing operating the store in violation of rules without keeping books and records is
Well,
a great-
ignore that. Ignore that. I'm talking about the fact that you have a fiduciary duty to safeguard the assets of the estate, correct?
Correct.
And by letting this go up in smoke, by not dealing with them, you are not doing that.
Not
Do
exactly.
you understand what the value of a liquor store in Williamsburg, Brooklyn is?
I do understand, but there's also a clear violation of a court order and a stipulation that's also part
So
of
you're
my
willing
fiduciary-
to let that asset go up in smoke because of what you're alleging is a violation?
Absolutely, and we do also believe that Ms. Kleckner has a fiduciary obligation to run a liquor store as a prudent and reasonable business owner, which she did not do, and
Or not run, so basically, or not run it at all.
correct.
And then the
because-
estate loses probably what amounts to $1 million.
Well, because we believe that we haven't gotten any books of records whatsoever.
I told you to ignore that. You're not focusing on the fact that you're about to lose a major asset of, have you ever applied for a liquor license
No,
in
I've
Brooklyn?
not. I've not.
You're not going to get another one.
And the estate has no interest of continuing this business.
Or selling it?
No, the estate has no interest to sell the liquor business as a going concern.
All
They
right.
believe the property is more valuable.
Do they own the building?
A corporation owns the building, and the corporation is going through the estate. So if the liquor store closes down, we have.
So my view, and you just changed my mind, I'm going to tell you that. My view now is that there is litigation going on, and the only one who's going to be hurt, should she win the litigation, is the applicant. Because you guys just told me you want to sell the building anyway, so you're not going to be hurt one way or the other.
Not exactly true, because the surrogate's court has to approve the sale, and the surrogate's court may order us to preserve the assets. But the way
Yeah, but you can't preserve the asset if the license is gone. There's not going to be another license. There will not, more than likely, within 8 weeks, someone else will come in there, in that area and apply for a liquor store, and if she wants to come back in 2 years and get one, she's not. She won't get one.
It expires
has
in
a
3
lease.
days.
She still
2
has a
days.
lease for 50 years. So the point of the matter is that it's a huge obligation for the estate, and my client has specifically instructed me, and we in fact also submitted sworn documentation, sworn evidence, which constitute judicial admissions that no books and records exist. So I have a fiduciary obligation to bring it to this board's attention that they operated the liquor store in extreme violation of.
Oh, we'll take care of that. We have other ways to take care of that, but what we're talking about is a license. So, all right, unless you have any questions for him.
Stepping back.
Yes.
Well, I do.
We're going to take 1 minute.
1 second.
Yes.
I just asked, and I was
Hold
told.
on, hold on, hold on. Are we back, Donald? All right, we're back on the record now.
Sorry about that. That by June, Mr. Cooper started failing, although he was mentally sharp, physically, obviously he was ill because he died 2 months later, and he was behind in filing tax returns. This was.
I mean, as I said, I'm not here to try to determine whether he was of clear mind or not. That's not
I'm
my
just trying to
job.
address the delay.
Okay.
All right. I'm going to grant the request for reconsideration back to licensing.
I am as well, and I'm also going to ask that licensing ignore the ongoing litigation and the way I look at this is that the status quo is maintained by renewing the license, assuming that she meets all renewal requirements. And if the surrogate's case goes against her, then obviously the estate will win the corporate assets and they can surrender the license at that point if they don't have any interest in operating a liquor store.
Thank you. Thank you very much.
Commissioner Ford, you're...
Yes.
All right.
Before you call the next item. To my staff and licensing, it's up to you if you want to stay or you want to go. This was a training tool. If you don't want to go, we'll disconnect for you. Got to hit the red button.
Yeah, no, I got it. We learned a lot, and I think we're good.
Okay. All right, have lunch. Have fun.
Thank you. Good luck,
All right,
guys.
thanks.
All set, Donald? Okay. The next item is 300, Quarter Horse LLC.
Can we call these all at once, right?
Sure. 300,
Right, you
325,
have three?
and 321. 300 is Quarter Horse, 325 is Vineyards of Farmingdale, 321 is Vineyards of Carl Place.
Kevin Dano for the licensees.
And it's Stu Leonard Jr. with Vineyards of Farmingdale.
Jill Tavallo with Vineyards of Carl Place.
And I'm Elizabeth Hollis with Quarter Horse.
So we've made a conditional plea offer of $50,000 for each store. It's a total of $150,000 to resolve this. I would like to point out that each of the licensees fully cooperated with the investigation in every way, produced thousands of documents.
From what I understand, once you got involved, they did, which I thank you for.
Thank you. Thank you for that, too. I want you to know that we've worked out with the council's office 3 different agreements with regard to the basic ways in which each of the stores does business. And this is consistent with other approvals of operating agreements that the Liquor Authority has done recently. So you've approved the agreement on how they deal with their service provider. You've approved the agreement on how they deal with their trademark, and you've approved the agreement on how they do their advertising. So what I'm looking to do now is put behind us, the past, move forward. And what we've done also is, at the request of each of the shareholders, each of the store owners, licensees, my office conducted a seminar for the owners and the service providers and the key employees to teach them what was in those agreements and how to comply with those agreements. And so we ask that you accept this conditional plea offer.
And so my concern with this was that seminar, and I wasn't here obviously, but I from what I understand, that seminar was given to Mr. Leonard in 2012 by us.
That's not true, sir. I know you've heard this, but here's what happened. There was not a seminar. There was a meeting of the excuse me. There was a meeting of the people that were people where more than one family owner owned a store, that was conducted by the Liquor Authority in Albany by then Chairman Dennis Rosen. the licensees were invited. They were told by the liquor authority that they could come to this office and participate via video conference, these machines. Mr.
I'm not saying he was at that meeting. From what I understand, there was a meeting after that meeting because he was not able to attend that meeting.
No, what happened is some of his attorneys came and met with the liquor authority, and they have been following their legal advice from attorneys. I'm not saying that everything, was done every way that you would like it to have been done. Otherwise, we wouldn't be making a conditional plea offer. But they have in every way attempted to be good citizens and to do things correctly. And to the extent, if it wasn't done correctly, to the extent it wasn't done correctly, it was not an intentional violation of the law or a difference from what was discussed. And I have to say, with regard to that meeting that you were talking about before, the one that they had tried to attend themselves and could not, I attempted to attend it also, and I was not allowed to. So it was a private meeting, and we then and they then asked the liquor authority what had taken place and at that meeting, and they got back an email that said it was a collegiate meeting to discuss the concerns of the industry, and nothing was resolved and no directions were given. And I could send you that.
No, I believe that. I'm talking about the second meeting that his attorneys were at.
Well, I was not.
I wasn't either, but I presume that any questions that they had about the way they were operating were answered at that meeting.
Well, I have to say that it didn't work. That meeting, I understand, talked about the websites, which are not at issue here. And
right.
Their website.
But neither one of us were at it, so we're arguing about something we don't have any facts of anyway. So I stand corrected. But
agreements that have been.
At this point, you're representing to me that they're operating within the bounds of the law, the New York stores.
I am representing you that they are operating within the confines of agreements that have been approved by the liquor authority.
And you've approved?
I haven't seen.
Oh, yeah. Oh, because you weren't here yet. It was by Council
Ms.
Flug. Okay. All right, do you have anything?
Nope, good. I'm willing to accept this since you appear to have helped them to decentralize. And so I approve the 50,000 per store.
I'll approve it as well, 50,000 each store. I don't need to explain to you what's going to happen if this happens again, though. So I think your lawyer probably already did that. So
We learned a lot.
Yeah.
Going through this process.
All right.
Good luck.
Thank you very much.
Thank you.
All right, the next item is 320, AAA Wine and Spirits Incorporated.
Good afternoon, Commissioner, Chairman, and staff. John Springer for the applicant. With me is the applicant,
Jelena Lisovska, AAA Wine and Spirits.
and this is Andrew Elise,
Andrew Elise, owner by Wine and Liquor.
and they're, the applicant's attorney, Michael Easy. This is a reconsideration.
Yeah, I'm not, Mr. Lynn. Oh, no, why don't you go ahead and.
Consideration. This is reconsideration of a 1-1 vote from October. What's changed significantly, there was some discussion at the hearing about Buy Wine and Liquor closing. The license is now in safekeeping. Initially, the applicant was interested in purchasing their inventory. Instead, they have a stock purchase agreement, which I have a copy of, where if this license is approved, he's going to come on board AAA with his management experience and his liquor pursuant to a liquidator's permit. The license is safekeeping. The liquor is still in the store with the landlord's consent. The litigation, the store wasn't closing because the store wasn't doing well. The shopping center was purchased, and they're putting in a car dealership. So he's there, I guess, basically on a month-to-month basis. The only real issue that Commissioner Ford brought up when he voted was the sales of the closest stores. Besides the fact that that really shouldn't be the main consideration for public convenience and advantage, as I pointed out in my submission, Chardonnay's was doing $3.53 million a year. their drop of $55,000 one year statistically is insignificant. We spoke at length about Elegant and how a previous board perhaps made a mistake by putting that store so close to Chardonnay. They begged to be there. It was too close. It's in a different neighborhood. So I think if you stack up the pluses and minuses, there's so many more pluses and minuses in this case. I would bring to Commissioner Ford's attention, assuming the chairman hasn't really changed his mind, the case of LIC Wines earlier today. That was a store that was 0.3 miles away. In this case, the closest store is 0.9 miles away. As you noted in your vote today, those sales were up and down. That store has 600 square feet of retail space. My client's store has 700 square feet of retail space and 300 square feet of storage and restroom in the back. So for consistency, I would mention that. And so in the plus column, it's a 1,000 square foot store. It's 0.2 miles from a new.
Well, we've heard what your new information is. So do you want to vote to reconsider or no?
Do Mr. Want to?
And I'll explain why.
Well, we're only voting to reconsider. I'm going to let you comment after we vote on that.
No, but that's the only thing that I'm going to comment on.
Oh, all right.
Go ahead.
I'm Charles Lynn, and I'm contesting this application, and I apologize for imposing, but I think there's two stages here. One is the question of whether reconsideration will be granted, and then the second question of public convenience and advantage. And the reason why I say that is that I think that this application either has to be sent back to licensing or a brand-new application has to be filed. And the reason why I say that is that the entire context, the entire scheme of this application has changed dramatically. When we came before the board, there was no sale of any kind whatsoever with Well-Buy Liquors, which is 1.76 miles away from the applicant. Now they are requesting that that license be surrendered or put into safekeeping.
It apparently already is in safekeeping.
Right. That the liquidator's permit be issued and that a corporate change application be filed.
No, they're not. They bought a stock purchase. They bought the company. Correct?
The principal of buy wine is buying 50% of AA wine, subject to conditional approval of AA wine's application. We're not doing a corporate change. We're asking to amend.
Who's going to own the other 50%?
My client.
Wait, Mr. Springer, it is a corporate change. You're saying it's the first application. Well, let me finish. The application has to be approved, and then you're going to file to get the new owner half ownership in. That's what you just said.
And that's exactly what I'm saying.
No, we're
So
amending the application.
Well, then it's a new application.
It doesn't have to be. Many times the application wasn't approved already. If you reconsider it, it's in the process.
But you're seeking to amend the application then.
And which requires probably a new application. And the reason being is that this isn't, corporate change applications just don't require a personal questionnaire to be supplied and then it's approved. In this situation, a copy of the agreement will have to be filed between applicant and Buy Wines for the transfer of stock so that licensing can thoroughly review that. The application itself must be revised to set forth the new principal and his status as an officer, director, and stockholder of the corporate applicant, which obviously caused a change in the current principal status. A personal questionnaire must be submitted by the new principal, as well as an applicant's statement. The method of operation must be changed to show the new principal managing the store with his hours and times of operation, as well as to set forth revisions in the current applicant's personal questionnaire as to his hours and times of operation. The statement of finances would have to be amended to include the transfer of inventory as an investment from the new principal or any other additional funds and source of these funds. A corporate resolution of applicant allowing for the transfer and the election of new officers and directors would have to be filed. Also, the current licensee has ownership of 2 individuals. I would think that an agreement or corporate resolution would have to be required of the partners to consent to this agreement with the applicant. As to financing, this application came to the board in October 2016 Wouldn't licensing want to know where the October 2016 to February 2017 rent and any other costs which have been paid since then came from, especially if expended from the proposed investor who has yet to appear on the license application? The underlying lease for applicant's premises now possibly comes into question because it's been 7 months since the time that this application was filed in August. There's a possibility that there's a provision in the lease, and we just had this maybe 2 months ago. I had a matter before the board where there was specific language that the lease was terminated if an application was not approved within a certain period of time. In addition to that...
Well, that has nothing to do with the
Okay.
sale of the assets.
All right,
I mean,
and
that's
finally-
something we would deal with in any reconsideration.
Okay, right. And finally, the authority should look at the transaction itself, which in this case makes no economic sense and is problematic at best. The new principal is selling 1/2 of his current inventory to applicant for 50% of the liquor store. But what does that really mean? If the inventory, say, is $20,000 and is sold on a liquidator's permit, the licensees who buy under the liquidator's permit usually buy at about 50% discount because these are literally a fire sale by the licensee. 1/2 of the $20,000 mentioned is $10,000. Its value in a liquidation sale is like $5,000. Applicant is transferring his 50% interest for 50% interest in his applicant's store for literally $5,000. You know, I would think that this has to be vetted as to why such a situation occurs. I mean, there's a lot of questions here. There's a lot of things that have to be done. And again, I apologize for imposing on this, but in essence, as Mr. Secretary had said, this has to be a brand new application. That is a monumental amount of things have been changed since we first came before the board. And I haven't even addressed the public convenience and advantage matter, but I think at least it's got to go back to licensing. But I'm almost certain that a new application has to be filed because of the enormity of these changes.
Okay, thank you. Mr. Springer?
Just to let you know, I do concur.
Mr. Lynn,
with-
basically,
because it's not as simple as it sounds. It is a re-review. A new application, when we request a new application, it's not because we're just being difficult. It's that the information that you're going to receive is a lot cleaner. It's fresh. Also, this information, for gross sales, goes back to August.
Okay.
Just to let you know.
I mean, it says,
I already submitted the stock purchase agreement. I have a personal question here. The man is licensed. He's on a license now.
Yeah, but
it's not like he's coming in, he has to be fingerprinted.
no, you heard them, and I'm going to defer to the
I can have
Deputy
this,
Commissioner of Licensing.
I can have this material
Springer,
to
hold on. Let him-
licensing by Friday.
Mr.
and-
Springer.
Then you need to file a new application. It's a corporate change. I'm going to vote no to reconsideration.
I was going to vote yes to reconsideration, so I guess we're still where we are.
I think you have to file a new application or amend, you're going to drastically amend the one that you already have.
If we had known it was going to take 90 days to get a reasons for denial, that basically said nothing. We would have filed a new application the morning after the.
You could have. I don't know,
The
that's,
man has a license right up the street.
I
He's
understand
on
that,
a
but
license. He's not-
there's a lot of other issues that need to be examined and on a corporate change. So,
Yeah, I was going to vote yes to go back to licensing anyway, so that's where it's going.
Can we, I mean, I can get the stuff to licensing by the end of the week. Can we put this over for 2 weeks?
no, just file a new application or go and amend the other one.
Well, yeah.
By
but-
amending the other one, you're granting reconsideration.
Yes, so-
I would-
You want them to file a new
File a
application.
new
File a new application.
You got a new corporate structure and financing and documents.
The
and all
next
that.
item is 329. It's a request for declaratory ruling for 601 Lexington Avenue in Manhattan.
Robert Skeen, representing Boston Properties, and request for a declaratory ruling. Their property is at 601 Lexington Avenue.
So my question, was this church here before that building went up?
I believe that church was part of it is actually a part of the condominium, the low-rise building.
But did they build the church when they built the building, or did they build the building around the church?
The church, and I don't have an answer for that, but I do have an answer that the church is connected directly to the remainder of that low-rise building.
No, I understand that.
I do not have an answer for you, Mr.
Okay.
Chairman.
All right, well, based on the diagrams that you've given us, the church is obviously part of the building, and the building is not exclusively being used. The rest of the building is not exclusively being used by the church or for church purposes. I mean, there's private condominiums and is there offices above it as well, or just condos?
Actually, it's commercial condominiums.
Commercial
There's no
condominiums.
residentials there. It's all commercial.
So there's office space above it, so I'll grant the declaratory ruling that the 200-foot rule doesn't apply.
I'll concur with that. The pastor says it's okay, so
He was on
who am I
board.
to argue with the father?
Thank you very much.
Thank you.
Next item is 327, DMM Enterprise, Inc.
Good afternoon, Jonathan Schloss of the law firm of Schloss & Schloss, representing DMM Enterprise, Inc. I'm here with my client, Yenny Hernandez, who's the principal.
And from El Salvador?
From El Salvador, here on with an employment authorization card. Similar to the last issue, but possibly a little different. I don't know the facts of that other case, but the same advisory, I believe, is at issue. Specifically advisory number 2015-21, which it has 4 bullet points of permissible licensees. It was rejected on the 3rd bullet point, which I understand it's not on the quote-unquote reciprocal trade country, but El Salvador is a member of CAFTA-DR. And while
Now, she's not a stockholder here. She's the lone owner here?
she's the sole owner of the
But
stock
she's,
of DMM.
and so she's an officer of the corporation?
Yes. I believe that, although, as counsel pointed out, the language of CAFTA may be poorly worded and whatnot, I think it is clear that El Salvador is one of the countries that in which the United States permits its citizens to engage in trade with, and vice versa. And that last bullet point in the advisory specifically interprets ABC Law 126.3 as broadly. And it includes foreign nationals from any other country who can satisfy the authority that his or her country has a treaty with the United States that permits citizens of both countries to engage in trade with and or, not and, but and or work in each other's country on a reciprocal basis. Clearly, there's a trade agreement. They are allowed to engage in trade. So, and she's from El Salvador. I believe it falls under that 4th bullet point.
And she's here on an employment card, you said?
Employment authorization card.
And what's that, how long is that term?
Well, that was expired this November something. My immigration lawyer applied for a green card and also put a fingerprint, and they approved. I got the extension, I got the letter, but they just gotta send me the ID.
I didn't understand what you
Okay,
said.
I'm not an immigration lawyer, and I didn't handle it.
That makes 2 of us.
I didn't handle this. But my understanding is that the employment authorization card was extended. She applied for green card status, and while that application is pending, the employment authorization card, my understanding is that has been extended. I don't know until when, but
And how long has she had the employment authorization card?
For 4 years.
Do you have to keep getting it renewed?
They tell me after keep it for 3 years, I can apply for a green card. Cause I'm holding a U visa for victims of crime or domestic violence.
Oh.
I believe we.
Okay, I got it.
I believe we did submit papers from the immigration attorney when it was requested.
Okay.
But aren't we at the same situation?
It's a little different. But she is an officer of this corporation, whereas the last guy was just a stockholder.
Right.
So it is.
The advisory does not make any distinction.
No, I know.
Yeah. You ready?
Yeah.
Yeah. I'm willing to grant reconsideration.
I am as well. So that goes back to licensing?
Back to licensing, yes.
Okay. All right. Thank you.
Keeping you busy, Jackie.
It's no problem.
Want to make sure you
No,
have a
she
job.
doesn't have anything to do anyway.
Yes, eat bonbons and watch soaps, that's all I do.
The next item is 354, El Rincon de las Americanas, Inc.
Good afternoon, Jonathan Schloss of the law firm Schloss & Schloss for Elvin Cohen de las Americas, Inc. I'm here with my client, Juan Mazriego, who's one of the principals. We've submitted a additional offer of $8,000 in full satisfaction of all charges. By in our submission.
How about 10? I mean, that some of the charges, particularly the using the women to get the men to buy them drinks, and given that it is Spring Valley, which we've had significant problems with in the past, I see these as pretty egregious.
Understood. And the issue with that is that they did have someone in as an assistant manager. They thought it was going to be a great marketer, and obviously was not. He is no longer there at all. They even considered at one point to apply to make that individual an owner. An application was submitted, not by my office, and that, for whatever reason, never came through.
Because we denied it. That's Oscar Max Zurego?
No, Angel.
Oh, no, I mean, that's the other egregious charge is the availing.
Angel Dominguez. Yeah.
So,
he.
I mean, there's 8 charges here. I don't think 10 is even unreasonable.
Well,
I still think it's a gift, to be honest.
Some of them, like for instance, the village building inspector told him that, yeah, you can go ahead and move your bar. It was just a misunderstanding. He didn't know.
Well, the village building inspector can tell him to do that. The neighbor can tell him to do that. But at the end of the day, you're supposed to be asking us.
Understood, and we in fact did, and it was approved in May of.
No, I understand that, but his ignorance doesn't really help me with these other stuff that went around, as far as the availing, the failure to conform to the application with the DJs. I'm at 10. I don't know. I mean.
The main source of the egregious, if you will, violations that Chairman characterized, he's no longer there.
Well, that gives me some level of relief, but it doesn't change my.
Yeah. I'm of the same frame of mind as, bless you, of the chairman. I think it should be higher, but I'm willing to go with 10,000 too.
If you need time, you'll get a letter with the offer in it. You don't have to decide today.
I'm sorry.
You don't have to decide today. You'll get a letter with the proposal.
Bless you.
And then we can may I have one moment with the secretary.
You'll get a letter saying your CNC was denied, counteroffer of $10,000, and you've got 20 days after that to
either accept and without an appearance.
Right. Otherwise, it goes back to counsel's office.
We have 20 days to accept
You're
the
going to get a letter, okay, saying your offer was denied, the counteroffer $10,000. If you don't do anything, counsel's office will take it back and schedule a hearing.
Okay. Thank you.
So that's what you want. So we'll send you a letter. Okay.
The next item is 309 Atlantic Cafe Incorporated.
Good afternoon, Martin Mailer of Mailer and Buscemi. This is a request for an addition of the hours that have already been granted to this licensee. We went before the Community Board, and when we went before the Community Board, we explained that we were only closing at 11 o'clock and had no need for any security guard. But what we did tell them was that we were going to get one anyway, and I have...
you said you were going to close at 11?
No, I'm sorry. What am I saying?
I thought they were upset about the hours.
No, yes, I'm sorry. The hours, we want to increase the hours to 2 o'clock and 4 o'clock. Right now,
They're
Yeah.
midnight and 1.
They're
11
midnight and 1 right now?
Yeah, yes. And we went before the community board and explained to them that we will agree to whatever they want to do in terms of assuring them that there'll be no problems. And they asked us to sign a stipulation. We did sign the stipulation, and I think I gave that stipulation to the Liquor Authority. If not, I have a copy of it here, where we agreed to security guards, where we agreed to not having outside promoters, where we agreed to the type of music that was to be played. And then they went ahead and said, well, because you told us in the beginning that you were going to have a security guard, which we had every intention of having, but there was no need for one at the time, it was stopped. But we've since...
Well, I'm not following. You signed a stipulation saying you would have the security guards, and then they said what? Now that you need security, they got upset?
No. When we initially went before them to get the license,
Oh, okay.
all right, we said that we would have them, but because of the hours that he closed...
They said you don't need them.
Right. So then, when we went before them again for increased hours, they wanted us to sign a stipulation, which we signed, saying that we would have the security guard and we would have these other provisions in them. And then they, I think you have the letter of disapproval. It says that because you didn't have the security guards in the first place, no, we don't want you to have these increased hours. And I have to emphasize the fact that this is not a 500-foot case.
Yeah, no, I know.
So we're trying to, we still will comply with the conditions that they set forth, yet they refuse to hear our extended hours. So that's why we're coming before the full board.
So extended hours with security guards wouldn't be an issue?
I have, may I?
Yeah.
This has been in place since the beginning of January anyway.
So security guards are part of your license right now, method of operation right now?
Correct.
Okay.
You may have that too, if you want to keep it.
Want to see there.
I'm sorry, I also have, I don't know if you received this, but here is,
I'm reading a letter from them from 2015 in June. Was that
who are you talking about, the community board?
community board to your
Yeah,
client?
no, that's when it was approved, it was, well.
Disapproved.
It was disapproved by them 2 years ago, but you allowed us to go at the hours that are currently in effect.
Oh, okay.
And then.
And that
because
was a
again-
full-on liquor license. It's not an RW.
No, it's a full-on, it's not an, it's a tavern.
Okay.
It has a food component.
All right, I got
This man's a cook. May I just?
Yes.
This is what was given to the community board in response to their request, specifically this stipulation, which was signed. So we'll agree to.
No, we have that.
Oh, you do?
Yeah.
Yeah, I thought you did. All right, but we will agree to all of these things.
No, I get it. I'm just reading what they wrote to us. Did I require that you have security?
I don't think you were there.
Is that on the license? Not I, but
The prior,
Rosen in June of 2015?
Didn't I, hang on. I didn't attach the agenda to this. I'll take a peek.
It's not on the conditions.
Okay.
No, that's March of 2016? No, it's not in the conditions of the.
No, June.
No, this was,
Oh, wait, I guess it would have come here in March
Right.
of 2016.
on the agenda sheet, it does not list anything about security guards.
Okay. So I don't know why, the community board seems to think that we imposed that condition, but I don't have any evidence that we did, so.
No, and you didn't. We voluntarily told them that we would have them. It's just that it didn't warrant it at the time. It was an expense that wasn't justified given the hours. Now that we have.
All right,
we don't-
and they also indicated that at the time that they reviewed it, that you hadn't been open a full year, but now you have, with no problems. So, given the stipulations you signed with them, I'll grant your 2 a.m. during the week and 4 a.m. on the weekend. You're to serve, I guess the stipulation says food until at least 3:30 a.m.?
Yes, which we have.
So all these stipulations will become part of the license?
That's, right, yes, there's no
Okay,
problem.
so I'll vote to approve that.
Thank you very much.
Well, you need another vote.
Oh, I'm sorry, I thought you voted. I'm sorry.
I did, but he didn't.
No, I thought you did.
No, based on the fact that I was thinking that along the same lines as the chairman, that this letter from the community board was dated October 31st. It's 4 months ago almost, so, and I think you've had a clean bill of health, so I vote to approve as well.
Thank you very much.
All right.
Want that?
You can keep.
All right, here, we'll put it in the file.
All right, the next item, actually, we have 3 items in a row for the same place. 292, Ethics Bar and Lounge. You also have 293 and 294 are for the same licensee.
You had quite a day here, didn't you?
Well, none of the charges were sustained.
I know,
None
you
of the
won,
charges
you
should
won,
have been
you won
sustained.
every one.
Yes, I did. But look, I didn't win anything. There wasn't any evidence that we were doing anything wrong. I mean, that's the bottom line.
All right, so on 292, we'll dismiss 1, 2, 3, 4, 5, 6, and 7. So I'll dismiss those.
All dismissed on 292. Yep.
293, dismiss 1.
Security guard was licensed. Dismiss 1.
And 294, dismiss 1 and 2.
Thank you.
Dismissed 1 and 2. There you go.
The next item is 308, Break Time Properties, Inc.
A little bit of explanation is in place here. I represented this gentleman, or this licensee, and it went out of business. It had a charge going back to 2015. I requested the authority bring it forward. It never could do that. The police officer, for whatever the reason, couldn't do that. But then he subsequently went out of business. There is an application pending in front of the liquor authority as we speak that was denied pursuant to your bulletin. And I contacted the existing licensee, and he said he didn't care, so he agreed to having the license canceled. The only reason I didn't include the $1,000 bond is that he just can't afford to pay back the bond company the $1,000. He's out of business. I can get the license to the liquor authority as soon as tomorrow, if that's when you need it. All I'm asking is that you accept the penalty of cancellation and then reopen the pending application that's on that premises. This is a summer place. This is in the Hamptons, and it's critical that.
All right, I'll accept the cancel, no bond.
Cancel, no barn. License expired.
And then I would
Yeah,
ask
no
that
history.
And then you're going to have them surrender,
Yeah, I'll have that. I can have that by tomorrow.
and then, I guess, reactivate the
Well, it
application.
expires the end of the month.
Yeah.
Oh, the license expires at the end of the month.
But I can get it to you anyway. Thank you very much.
Take care.
All right, next item is 313, Herrick Street Corp.
Good afternoon. Francis Buscemi for the applicant. This is a application for a new retail liquor store license application. I believe there's,
Yeah, there's a protest.
you want to hear from?
Yes, yep. Are you protesting? Come on up.
My name is Helen Chan from Jericho Wines and Liquors, and I'm one of the closest stores to. So we're protesting because we believe there's too many liquor stores in the area already. About 10 existing retail liquor stores within the 1 mile radius. So Long Island is mostly a driving community. In the area, most people commute by car, so it's very convenient to commute from one destination within another destination to get their liquors. Plus, this store is located on Herrick's Road, which is a very busy road. And also, within the 0.4 miles, there's a high school in the area, and 0.1 mile, which is 1 block away, a daycare center. So I don't think there's public convenience or we need another additional liquor store added to this area. In addition, with the recent approval of a mega regional store, New York Fine Wines and Liquor, that retail space is 43,000 square feet, designated over 26,000 to wine and liquor, and that is only 13 minutes drive away from our area. So that would draw a lot of business away from the community, and therefore we don't need another liquor store in the area.
Okay, can you answer a question? Is Grand Wine and Liquor on Hillside Avenue open?
Grand,
Do you know?
I'm not sure if that's open, but there's Lisbon Villa and.
No, I'm aware of the other ones. I'm asking about Grand.
I'm not sure.
Okay, thank you.
What was the other one you said just opened, the mega store?
New York
Total
Wines
Wines
and
that we
Liquor,
just voted.
that's in,
Okay.
by Westbury.
Got it.
That's only 4 miles away from us. So 26,000 square feet is equivalent to opening 13 stores at one shot, based on average 2,000 square feet size. So I think that will impact the community greatly.
Thank you.
Do you know if,
You know, I'm not sure.
is your client, or,
I asked,
no, he doesn't know?
I just asked, Mr. Chairman.
Can we send enforcement out to them?
Why, you're not getting any?
They just didn't respond. But that's all right, go ahead.
Yeah. All right, this is for a new liquor store license application. With me today is Mr. Ree, the principal of the applicant. This is for a store located at 122 Herrick's Road in Mineola. The Herrick's Road is a very busy main thoroughfare. None of the 4 closest stores are located on Herrick's Road. 3 of the 4 closest stores are located on Jericho Turnpike. 1 of the stores is located on Mineola Boulevard. Now, we have Villa Liquor and Jericho Wines. They're both in shopping centers. Cordial and Lisbon, the other 2 stores, only have metered street parking. With regard to the development that's going on in the area.
Well, let me go back to the parking. I see your guy is on Herrick's,
On
and then he has an exit onto Wardwell Road as well?
No, just.
Okay.
You're going to call it Herrick and First, just about. All right.
And do you have, it's on-street parking then?
He has a small parking lot dedicated to the building itself. Mr. Ree owns the dry cleaners, which is right next door to this building.
Oh, okay.
He recently purchased this building. It's part of our application. He wishes to use the building next door to operate the
see.
liquor store. He will be managing the business full-time. He's got his wife that will be working as a cashier part-time at the store. His family also operates together. They operate, he has sons and his wife that are managing the dry cleaners as well. He's been in the dry cleaners over there for quite a number of years. With regard to the residential development in the area, Mineola has a number of projects that have been recently completed and are also under construction and are going to be starting. We've got, to point out 4 developments. There's something known as 1/3 at 250 Old Country Road. That was recently built, just built, and is a 315-unit residential units. Another one.
How far is that?
That's about a mile, less than a mile away. We have Modera, which is a 275-unit building at 140 Old Country Road, recently built. We have a 296-unit development that's under construction now at 199 East 2nd. And Corpus Christi Elementary School has just been purchased by a residential developer. The town has just provided the necessary tax breaks the developer needs to proceed, and he's going to be putting up a 192-unit development there, where the old elementary school used to be. So that's adding a total of over 1,078 units to that area within about a mile, all within about a mile of where the applicant has applied. Now, Mr. Rhee, he's of Korean descent. He enjoys Korean products such as Korean soju and Korean wine. And he's canvassed the surrounding liquor stores. And and his intent is, this is what he's looking to specialize in addition to a nice selection of sakis. He's looking to specialize in Korean soju and Korean wines. It's not a huge category, but it's something that the other stores just are not carrying. He has to go to Great Neck. He lives in Mineola himself, Mr. Rhee, and at this point, he has to travel to Great Neck and Flushing in order to buy the products that he wants to have in his home. So we'd be looking to carry a full selection of those products at the store, which is just missing. The other stores do carry some selection of sake, but other than that, the sojos and the Korean wines just don't exist elsewhere.
What percentage does he think he's going to carry?
It's not a huge, he's going to carry as much as you can get. He's researched, he's found about 40 to 50 SKUs of these products so far. So if that's everything, he's going to carry everything. If he can build that up to 100 SKUs through further research, he's going to do that. In addition to those Korean products, there's some fine Japanese sake that he's discovered. There's a Dase or Dashi, which is a Japanese sake product, which is a very premium kosher sake that he wants to carry. What's interesting about that is that they actually take the rice grains, and something very unusual, they take the rice grains themselves and they tumble them to wear them down. Same process as like tumbled marble, for the tiles and whatnot. So they're actually eroding the outer layers of the grain to get to, and they have 3 grades of this. One grade is, one is just untouched, the full grain rice with the outer coating or whatever you want to call it. Then there's a 50% where it's getting closer to the heart of the grain, and then they even go to a 23%, which is even closer. And you can taste the differences in the quality. It's a very premium product. It runs between $30 and $80.
What's the Korean population of that area, if you know?
The Asian, I can't tell you the Korean population specifically. The Asian population has increased, and it's 6,000, approximately 6,000 now. And I have that in my statement to you.
Do you carry soju?
Carry very limited soju. From what we know is some of those specialty soju stores, suppliers, they will not deliver to Long Island because there's not enough demand for it. And that's why they won't deliver.
Okay.
It's too far away.
All right. Thank you. Do you have any questions?
No.
Okay. Anything else?
You've got over 18% of the area, the population's forecast for Asian population at over 18% within 1.25 mile radius of the entire population.
Okay.
We believe that we're serving, and in looking at the gross sales here, again, Villa and Jericho, they're in shopping centers. We have sales of Villa, which are over 1.5 million. Jericho is 2+ million. The only store that's really marginal, and to be honest, I don't know how they are even in business with the kind of sales they're doing, and they're in almost a 2,000 square foot store. So to be doing those kinds
Is that in a shopping plaza?
No, that's on street, only metered parking. Mr. Rhee has gone there, he's gone to Lisbon, very difficult parking situations, only metered street parking there. And again, for a store that's almost 2,000 square feet, to say that they're doing those sales figures, to me, just doesn't make sense. I believe we're bringing something to...
Are you a protester, sir?
Oh, sorry.
Oh,
no,
okay,
he's-
go ahead.
works for us.
Oh, I can't, I don't have my glasses on, I can't see. I apologize.
I believe that bringing in product line that's really not being carried by other stores. We're sure, if someone wants to buy this product, wholesalers are going to sell it. Wholesales carry it, and they're going to sell
And
it.
I assume the goal here is to have the customers of the dry cleaning business become liquor store customers.
Oh, yeah.
Okay.
Sure.
Any-
And again, put it out to the,
No.
Okay, go ahead.
Your retail square footage was about 2,300, is that what I read?
Correct.
Okay. I'm going to vote to approve. I see the closest store, Villa, is due to about maybe around 1,200, so they've gone down a little bit, but headed back towards where they were. Other store seems to be, next one seems to be holding her own, if not increasing a little bit. Other one, a little bit down.
It's voting.
And I'm looking at this, and this is just through 6:30 too. We still don't have an answer from this Grand Wine and Liquor, correct? I don't know about that, all right.
Yeah.
And the other
There's
one,
been nothing. We can
Lisbon's-
send it to enforcement.
Yeah, please do. And I see Lisbon has gone up, so I'm going to vote to approve.
I'm going to vote to approve as well. The two closest stores are both in shopping plazas, and shows, the first store, while somewhat decreasing, it's minimal. The second store, Jericho Wines, is showing, since 2013, a significant increase of 250,000 in sales, or 200,000 in sales. I think there is a public convenience and advantage to the Asian alcohol that he wants to sell, as well as the fact that he has off-street parking, and it would be convenient for the dry cleaning customers that he currently services. So I'll vote to approve as well. I think he's nuts, but good luck.
thank you. Have a good day.
All right, the next item is 302 7 Washington Lane Corp.
$302?
Yes.
Good afternoon. My name is Frank Palillo. If you can introduce yourself, please.
I'm Tanya Hira Passon, and this is my husband, Roberto Passon.
They're married, so if she introduces him, he doesn't get to introduce himself.
Say that again?
I said they're married, so she introduces him, he doesn't get to introduce himself. So.
I know that feeling.
Oh, yes. This is an application for an on-premises liquor license for a premises that's currently operating. For years, was it 9 years now? For 9 years, Tanya operated this location, and we now filed a new application with Tanya and her husband, taking over the exact same location.
Wait, say that again?
For 9 years, Tanya has operated this premises
Oh, really? I wasn't aware of that.
by the name of Shai Shai.
Oh, I knew there was another license there. I didn't realize it was hers. Yeah.
But is that
And
the
then-
same license that we imposed at
So
30?
what's the,
Well, they got married.
It is.
And other partners decided they no longer wanted to be involved. We got a new lease for the premises, and we are now filing this application. It's basically the same owner who's been there for nearly 10 years now.
They paid a $30,000 civil penalty back
We
in
did in October
2015.
of 2015.
and what was that for?
Availing?
That was, yes,
I see that, but what was the,
the husband was working in the premises, and we did not report him when we should have. That was the availing, and we paid the fine for it. There was also a Sidewalk Cafe issue. We had a Sidewalk Cafe, but did not have it licensed with the authority.
okay.
Just to clean the record, both of those applications were disapproved pending the disciplinary. Mr. Palillo sent me a letter from 2015 that was from licensing asking to reactivate those. We will just reactivate those applications just to clean the record for Chai Chai.
Okay.
We'll cover the addition of the principal and the Sidewalk Cafe.
And then the community board is not a fan.
Correct.
What? You don't have any history at the other 6 places?
None. Well, nor do we have a history of this one, other than the one availing charge in 10 years of license history.
And then they're going to shut one of the current places and make a restaurant? Or that's this place?
This place.
Okay.
Shai Shai.
What were the hours of the former?
Well, the hours are the same, I'm sure. What are your, okay, but what time do you close during the week? What time do you close on the weekend? What time do you close? Just what time do you close?
We close around like 1 o'clock.
Yeah, but that's all the man's asking. So what time do, 2 a.m. on the weekends, 1 a.m. on the weekdays?
And you're going to have a sidewalk cafe?
Yes.
Is that approved yet by the city?
Yes.
What are the hours that going to be? 10?
So, does it? Yeah.
Community Board seems to have a problem with the sidewalk cafe.
Community Board has a problem with this applicant.
Yeah.
Basically. And the problem is that community boards are designed to protect residents.
Right.
And when we have a problem with residents over the last 10 years that we fight with legitimately, because we can't always agree that we've done something wrong because there's construction and there's a cyclone fence.
Yeah.
Roberto hung up paintings on the sidewalk, on the cyclone fence.
But
Because
cities,
it was attractive.
all right, but the city's granted the sidewalk
Oh, yes.
cafe license.
Now, we don't, other than the history, we don't have any complaints of this location, right?
Legitimate restaurants, sir.
What are they talking about in the letter? They talk about all these complaints. I'm not aware of any.
Nor did they enunciate any at the meeting.
They didn't, no noise, nothing like that?
No, we have no problems.
And you own the place right across the street?
Yep. And Roberto is a Michelin star chef, I should add. If I don't add it, I'll hear about it afterwards.
As you should. All right.
Ready?
Do we have a menu in here?
I'm certain you do.
Yeah. There.
Oh, I got it. Okay. Yeah, I'm ready.
Looking at menus like this at 1:30 in the afternoon when I haven't eaten since 7 o'clock, it's terrible for me, let me tell you. I'm going to, since you have the license from the city for the sidewalk and so forth, I'm going to vote to approve. I don't really see any other issues with the license.
So now what, just to be clear, what, the outside, I agree with at 10 PM.
Yeah.
What are they looking for inside? No, you're looking for later than 10.
Later than 10, during the week. 2 a.m. and 1 a.m.
2 AM and 1 AM, so 1 AM during the week, 2 AM on weekends. And the music situation is just recorded?
Just recorded music.
No DJs, no live, no,
No room.
okay.
2 a.m. Friday and Saturday.
Yes.
That, okay, all right.
So 10, I'll vote to approve 10 AM on the outside since the city
10
has,
p.m., please.
what'd I say?
AM.
Oh, 10 PM on the outside. Since the city's approved the outside sidewalk cafe, I'm not going to limit the fact that they're not allowed to serve alcohol on it. And then the indoors, 1 AM during the week and 2 AM on the weekends. Good luck.
What we're seeking, it's a legitimate restaurant.
And I want to make it clear that they have 6 restaurants with no history with us whatsoever, so.
We have
Yeah.
more. It's now 7. Since
7, I'm sorry.
Thank you.
Good luck.
Good luck.
Next item is 257 Bushido Restaurant Company, LLC.
Yeah, my name is Frank Palillo. Could you just introduce yourself, please?
Joaquin Baca.
This matter was on, I think, early January originally.
Yes.
I notified the community board. I never got a response of any sort from the community board.
We did.
I understand that the community board objected without even knowing what's going on here. We've never even met with them.
Well, do you want to read it? I mean, they don't really give us a reason. I can show it to you. They basically say he's I think this is the one where they say he's violating the 500-foot rule.
As a courtesy, I requested the secretary put this matter over. I re-notified the community board to give them another opportunity to meet with us and talk to us about this application. On January 6th, and was received on January 11th. I'd be happy to hand that up to the secretary if you like. But no one's,
No, I mean, they've been notified by us, right,
no one's paying
Tom?
attention to me.
Yes, be here, yes.
Oh, so you've never met with the community board?
I've never even been called in. I first heard there was a problem when I saw it on the full board calendar.
But you did the 500-foot hearing, and they made a submission to the 500-foot
They may
hearing.
have done it when I wasn't there.
The hearing was October 13th.
And they made a
The
submission, right?
The letter was dated October 11th.
Yeah.
It's not stamped, but.
They didn't appear, but they... All right, so the question they have, which is, I guess, the one, they say you don't comply with the 500-foot rule, so clearly they don't understand that. But the question that they raised that I would like some clarification on is does he have another place?
I do own another restaurant, or I'm 50% in another place, but it's
Where is it? And
It's Arlo Dog?
Arlo Dog, yeah.
What's the corporate name?
Arlo Dog LLC.
It's Arlo Dog.
Arlo
LLC.
Dog.
I'm looking for their letter.
9:15.
It's right after the memo. You mean the full?
9:15 Wickoff?
So they're talking about, is that on Wyckoff Avenue?
No, sir, that's Lorimer and Concelia.
So what are they talking about?
Yeah, it says 9:15.
The applicant is located on the border of both 83rd and 104th precinct. According to the 104th precinct, the applicant also have a bar at another location at 915 Wyckoff Avenue, and they've received multiple summonses for serving to underage persons, overcrowding, and is at present being invested, I'm reading word for word, for other issues. Do you have any idea what they're talking about?
You have no relationship to 915 Wyckoff.
And we don't have any information that you do, so.
The protocol might have been to call us in and discuss this with us.
Yeah. All right, so we have a sidewalk cafe here, right?
Correct.
That's already approved?
It's still pending.
Has this, go ahead.
Has it been applied to the city?
Yes. So, waiting.
That's what's pending? All right.
So and then I see you, Barlow Lodge, that's your place?
Arlo Dog. That's the corporate name.
And what was the refusal to appear and testify in November 2015? We got a letter of warning? Which I'm assuming,
yes.
the reason you got a letter of warning is because it was not that serious, but,
That was,
I got picked up on the subway for having a pocket knife coming back from the farmer's market, and they gave me I had to go to court, got an ACD.
oh, and we didn't get notified, is that what it was?
exactly. Well, we notified, but we didn't follow up and tell you what happened afterwards.
And then we called you in and you didn't come?
Dismissed.
After the ACD, didn't,
Okay.
Further advise the authority like you should have.
So no live music, just recorded background music? Okay. Do you have any questions?
So this public school and junior high school, is that true or not? Located, more than, that doesn't say within 500, that's material, never mind.
I mean, I have to, just for the record, I'm going to, and Mr. Palillo's already done this, the community board has basically given us absolutely no guidance on what objection they actually have. And since it appears that you've contacted them on more than one occasion and they have refused, or not even contacted you back,
No response.
it's very difficult for us to even consider what their opinion is, given the fact that they're giving us wrong information and a blanket statement that this restaurant doesn't comply with the 500-foot rule, which is not really what the 500-foot rule is about.
They also,
And Tom, as a 500-foot law, I'm sorry, Tom.
they also seem to have you confused with another address, another licensee. So,
Do you know how many restaurants are within 500 feet?
I'm sure it's in the application off the top of it. Don't ask.
I see, 3? Okay.
It's what we submitted, I honestly don't know.
What time is the outdoor cafe open till?
I think we're going for 11, or no, 10.
11, and during the weekend, 1 on the weekends, or?
The outdoor, yeah, 10.
No, the outdoor.
Yeah, that's what I'm saying. It's 11 during the week and 1 a.m. on the weekends.
11 and 1.
Those are the New York City Sidewalk Cafe hours, or 11 a.m. during the week and 1 a.m. on the weekends.
Okay. And what are the inside hours?
2 a.m.
All week?
I mean, ideally, I'd like permission to, but I mean, I might wind up changing those hours once.
Okay, don't argue against yourself. 2 a.m.,
2.
7 days a week, yes.
Okay, go ahead.
all right. Okay. Ready?
Yeah.
All right. I'll vote to approve. I mean, with the hours of 11, Sidewalk Cafe 11 and 1, and then the 2 a.m. Closing in general, 7 days a week? Okay. Assuming that you get your Sidewalk Cafe license from the city too, which is pending. Community Board is kind of, their objections are noted, but they're vague and correct. So,
I'll approve 2 on the same hours. I was actually going to do less hours, but I don't, I just, given the community board's lack of information here, I don't, they didn't even complain about the outdoor cafe, so I'll approve 11 and 1 on the outdoor sidewalk cafe, and then 2 o'clock across the board inside.
Thank you.
Good luck.
Next item is 386, Down and Dirty Tacos and Tequila Bar Meatpacking LLC.
Start off on compromise, I suppose, of a small matter.
street number not posted and the fire extinguisher.
I'll accept.
Accept.
Thank you, have a good 2 weeks.
The next item is 304, DC4 Group Incorporated.
Applicant here? Did you sign this in? Okay. Why don't you go, and we didn't get anything, right, Tom, as far as adjournment?
Nope.
All right, so go ahead. Be brief, please.
Robert Sweating for the opposition. Basically, the area is Bay Ridge, Brooklyn, and there's no new development going on. The closest two stores are both on 3rd Avenue, which is where this applicant wants to open a store. Excuse me, the closest store is only 415 feet away. I can give you pictures.
No, we don't, oh, go ahead.
It shows that from where the applicant wants to open his store, it's visible to the existing store. That's to the second closest, rather the first closest. The sales are also declining at that store. The next problem is that the second closest store, again, which is on 3rd Avenue, has been open for less than 6 months. Obviously, it's drawing from that exact same area. It's, again, second closest store in six months open. In addition, just about 4 months ago, I think 3 months ago, you granted a removal for McGovern's to move across the street, and it basically doubled in size and has a brand-new, built-out, beautiful store, but is going to also be attracting business.
Where is that one?
McGovern's. That is at 7207 3rd Avenue.
Oh, that's not open yet.
No, it is open. It's a removal.
So it's not one of the 5 closest then?
Not one of the 5, it's
Okay,
about the
but it is
6th
in the
closest,
area,
right.
okay.
So again, you've got these stores being that close. You have another store within 6 months, which is the second closest. And in the area of Bay Ridge, there's no really new development. It's the same market they're all trying to compete for.
All right, you want to just put who you represent on the record? Just your names.
Konstantin Dimitrov,
Yeah, and your store.
King Sellers.
Thank you.
Personnel King Sellers.
Joe Mancino, Pepinos Liquors.
Dan Xiaodong from New Mickey Liquor.
Come on.
Hi, I'm Heather. I'm not actually represented. Robert, but I own Long's Wines and Liquors. I'm one
Okay,
of the
anyone
their
else who's not
stores.
represented, come up and put your name on.
But I also wanted to, I did submit some paperwork showing that when Pepino's opened in October.
We
that-
have that.
You have that.
Yep,
So
thank
the
you.
sales went down.
Yep,
Okay.
thanks. Anyone else? All right, the applicant is not here. As council pointed out, we just opened the second closest in August of 2016. That's 0.2 miles away. And we just did a removal in the same vicinity and put another store there. And the closest store is 446 feet away, which as was pointed out to us, is actually within eye visibility of the applicant's location. The sales don't indicate the need for another store, and I don't even think they've been reflected accurately since we just opened Pepino's, and Pepino's can't really we can't reflect what their activity is going to do to the other store's sales at this point. So I'm going to vote to deny.
I vote to deny as well for all those reasons. All right.
The next item is 303, CB Wines and Spirits of New York LLC.
Good afternoon, Commissioner, Mr. Chairman, boss of the member. My name is Hector Caraballo. I'm with Dennis Buchanan, I'm sorry, from CB Wines and Spirits of New York, DBA Goodfellas Wines and Spirits at 1295 Broadway in Brooklyn.
Okay, are you representing? Come on up.
We have representatives here from the two closest stores, 1083 Gates and Popular. One of the things I found confusing is in this application, they don't list the closest liquor stores. So I'm assuming that
Well, your clients are the two closest.
my clients are the two closest.
Yes.
All right?
I have them listed. I don't know why you. The application we have, it does list.
The application I have lists, well, I'll give you the page.
Chairman, I think the memo lists.
No, but I'm seeing I'm looking at the application. They have Popular Liquor as the closest, Bacchus Wines and Liquor is the next closest, which we have in our memo as the third.
I think they didn't have.
They don't
Geneva,
listen, that for whatever reason, they don't list 1083 Gates Avenue Wine and Liquor, so.
Right, and they don't list Geneva or Juice Spot or Hello Liquor.
Okay.
Closest liquor store is only, it's going to be 1 block away. There was one which was opened recently 2 blocks away from the Gates Avenue store, which is here. Basically, this is in Bushwick. While the area is changing, there's not any new development in the area, any large buildings, et cetera. The sales are flat or declining. The profits of all the stores that I've spoken to are declining. We don't feel there's a need in the community for an additional liquor store this close to the others at this time. Thank you.
Thank you.
I'll just have them identify themselves.
These are both your clients? Okay.
I'm 1083 Gates Avenue, Wine and Liquor. My name is Mulong Lee.
Popular Liquor, 1102 Lafayette Avenue.
Can I ask you a question, though? Are they, both of their stores open or closed? They're not bulletproof? No, I mean, are they bulletproof? Both? And do you know about Bacchus Wines and Liquor? Is that bulletproof? And what about D&G Wines and Liquors? Is that bulletproof? You don't know about that one? Do you, sir? Never been in it? Okay, go ahead.
Well, our store is going to be no bulletproof door.
So you guys are partners?
Yes, sir. Before we made the decision to take, make the move to take the store here, we went over the neighborhood, we check all the demographics, populations, and you can see the population is increasing over the last 10 years by 10%. There's a lot of movement, new wave for customers moving into the neighborhood from not just from the city, but from Williamsburg all the way to Eastern Parkway, and both Bushwick, all the way to Ralph Avenue, all the way to obviously on Broadway as well. We're going to carry a much different inventory that Popular Liquors and the other stores are carrying. We designate, as you can see on my emails, designated area for New York liquor, also for New York wines. It does include Upstate and Long Island, which the current stores over here, they don't carry. I went asked for specific names, Pink Dar, from also wine from Sonoma, and they don't carry at all. Our selection is going to be completely different, something that they don't carry. We're going to have also.
So besides New York, what are they not carrying?
They don't carry from Long Island, New York, organic, which we have a designated area for organic. We have a designated area for kosher wine as well. If you look at my pictures there, each section is divided individually with a chalkboard above each section. That's when it shows to the customer what we carry there. Again, kosher, organics, which is very big nowadays. We're going to have the New York Long Island, New York Upstate. We're going to have New York hard liquor, which they don't carry at all.
Okay.
Location does have parking in the back of the building. Okay, not to mention also side street parking, which is residential. They have meter parking as well in the area. So I think, our location the area does support another liquor store. And this is a very different store. This is more upscale compared with what is in the area. This is more like a city type of store. We're going to need approximately about 10 to 15 employees there. We're going to have a different type of customer service with background in retail. We're going to want people on the floor all the time. We're going to have probably 3 associates walking around the store with a cashier. I'll be there myself 24/7. And that's
You better not be there 24/7.
Well, open business hours, I would say. Business hours. And the store is 2,000 square feet. We're going to designate close to 1,100 as a retail space. In the back of the building is our stock room, which is about almost 950 square feet as well.
Okay. Do you have any population numbers to? I know you said it's going up 10%. How do you know?
Yeah, these same emails with totals population right now. Just on the zip codes 112, 206, 207, 237, and 221, which we're located. This is the stores, the zip codes close to the store. Right now it's 314,405 population, with most of the people on the age of 30, 31 years old.
What's it say? How much has it gone up in the last 5 or 10 years?
10% increase.
Since when?
Since 2000.
So that's 17 years.
I'm sorry, in 2006, I'm sorry.
Since 2006. So that's still 10 years.
10 years. That's the trend.
You don't have anything, what are the projections in 5 years? Do you have that or no?
According to, I went to the office of the Nidia Velasquez to get some information from them, which is the representative for the area. They told me that, with the new development, they're actually building apartments in the area. There are a lot of buildings under construction, so the people taking opportunity, the advantage of this new way for people coming in from the city and from Williamsburg. And they project, according to what the lady told me, I mean, I was expecting email from them yesterday, but they didn't send it to me. They're projecting to increase about 15% on the next 15 years. 15.
Okay, thank you. Do you want? Yeah.
I think one of the other things that we were looking at when we were deciding whether or not this is going to be a worthwhile venture was that While the population might be changing, 10 or 15%, I think that the makeup of the population of the area, the demographics of the area have certainly changed. And what we're looking to do is to provide a different experience than the traditional store there had. There had been, in the area, look, the Bulletproof store was a necessity, but it has changed a lot, and the demographics of it had changed. And I think that we fill a separate need than the other stores do.
All right. Are you going to do tastings or anything like that, education?
Yeah.
We do have, when you come in into the store on the right side and the front, it's an area with a tasting bar. This is going to be away from the foot traffic, where it's not going to be inconvenient for customers coming in to purchase something. It's a counter. It's about 70 foot long, and that's what we're going to have the tastings there.
And are you doing internet sales or no?
Eventually, yeah, we're going to work on that. We're building a website, and we're planning to do as much as the customers suggest in the area. Which I stand in the front of the building while we were doing construction, and I ask customers. They're very excited. And they complain about the other liquor stores in the area. They weren't clean. The service is not very good. They don't talk to you, and they're very excited about what we're doing there. Website is something that definitely we're going to consider in the future.
It was very encouraging when we were under construction there. The amount of the local people in the area who would look in the windows, kind of stop by as we were working, saying that they were looking forward to something. It was going to be a little bit different, and they were hoping that it does raise the entire area up.
And let me ask you, we have a source of funds information section here, and it says David Lerner Associates. What, you have an account with? Who is that?
I do.
What is it?
It's an investment.
Okay.
Yeah.
I just know a David Lerner.
Well, let me add something as well, that also the landlords, one of the stipulations and one of the demand that when we approached this landlord about this building was that they want something upscale, because they own more than half of the block, and they want something different. They want something that match the demand for the new community coming into the building, and they want something clean, nice, upscale. And
Okay.
that's what we built.
So the question I have for your clients is the New York,
They both carry New York wines.
but how many?
Do you know how many New York wines you carry?
I guess maybe 10%.
10% out of how many? How many SKUs do you have in your store? No, SKU. How many products do you have in your store? Different products.
Wow, that's a lot.
Well, so if you carry 10%,
10% that New York State wine. Taylor or the Long Island, something like
Taylor?
Yeah, Taylor is New York State wine.
No, and you? How many?
What percentage? What percentage of his wine is New York State?
It's maybe not now. It's for me because I.
How many?
It's mostly California. That's what his answer was.
Okay, for me, can I explain?
Yeah.
Yeah, I'm in there already 27 years. That store I'm in there. So they're talking about that. I know very well. It's not true. Okay? Because of the developer in there, sometimes that store open 6 months, 10 months, no here, already closed. For me, I'm in there, you can see my growth, profit, not increase.
Actually, it did.
That's it, because I had one store closed 2 years ago.
Oh.
One store. So I just gathered some people. 1 month, they $10,000. 1 month.
Which is, okay.
I think the other thing is also that as they've been there a long time, and we're not denying that the neighborhood is changing, but they hopefully should be able to get some benefit.
Well, and I'm not denying that, but I think the neighborhood needs some benefit. And the thing that jumps out to me is that they're both bulletproof.
Well,
and they're both doing, I would border on saying exceptionally well for a bulletproof store when I know that the people that are moving in there are demanding more than that.
and I'm sure that they'll accommodate the people.
They can't with a bulletproof store.
Well, can take the bulletproof down. I mean, Bacchus is not bulletproof.
Well, you can, you just have to apply to do it.
Said they can
Yeah.
take the
I mean, so the
when they feel that it's right. I mean, it's,
Gates Avenue Wine and Liquor has gone up 130,000 in 3 years, from 300,000 to 431, and it looks like they're going to hit 500 this year.
because one store is closed. That's what.
I understand that, but
Well, that makes all the difference.
the other store went from 700,000 to 776 in 2 years. And the other two closest stores have also gone up. The only one that has gone down is the furthest store, which is D&G Wines, and I don't understand how they're even open, because it's apparent they can't be open given the sales numbers they're doing.
They have other problems, it
I don't
looks
even
like.
have them on my list of your closest liquor stores.
They're the fourth closest on 99 Ralph Avenue, and in 2015, they did 108,000, which can't even be paying their rent. So I don't know what, go ahead.
I'm looking at the closest stores too, and I calculated it out too, and it looks like they're definitely on sales increases. Maybe that is because the other store left. Yeah, so I mean, that would make sense.
That's so close because the building construction, that's all, that's so close. So new 2 years, so that increase 1 month, this $10,000.
Yeah.
Then for me, improve the service for community. Before I open the 9 to 10, right? So now I open 8 to 10. Increase the for customer.
All right, thank you.
All right, thank you.
Then I wanted to just say that one more thing. It's 15 years ago, I'm opening there. If I don't use the food, I already died in there.
We don't doubt that.
Yeah,
But-
because the counter store robbed me.
I'm sure.
Yeah, I understand. I understand.
So that's the area.
Okay, let's go.
All right. How much your store is going to be retail? 2,000 square feet.
Going to be close to 11, about March 1056, 1,056, and about 900, almost 950 on the stockroom.
So roughly a little over 1,000 square feet.
Yeah,
square
over
foot.
1,000.
All right.
And also include high-end wines that we're going to carry as well.
All right. I'm going to vote to approve. I'm looking at the numbers for the other stores, and for whatever reason, they have gone up. And you're going to be an open floor plan as opposed to a bulletproof, so I think there is a public convenience and advantage to be met there. So I vote to approve.
Are you willing to commit to a percentage of New York products?
Yes.
What percentage?
In wines, about, close to 15%. And on liquor, it's going to be about 8%. That's a section.
So why don't you just give me a number, percentage total for
8% on hard liquor.
All right, so I'll approve if you're willing to go 10% New York products. I don't care what the products are.
It's going to be more than that.
Okay, so you're committed to 10, but I'm telling you have to stay 10%.
Absolutely.
If it's more than that, great.
Absolutely.
So I'll approve based on 10% of New York products being provided. The two closest store sales, as I said, have gone up consistently over the last 3 years, and they're both bulletproof stores, whereas we try to promote, particularly in a gentrifying neighborhood, open floor plans, because I think that serves the public convenience and advantage. These gentlemen have indicated they will conduct tastings, have an open floor plan, and do 10% of New York products. So based on that, I'll approve.
Commissioner
Thank you
Ford,
very much.
okay with that percentage?
Yes, yeah, absolutely, yeah.
Do you have any questions?
From this point forward, how do we get the license for us?
You'll receive a letter from licensing, so you can finish with the rest of the conditions. Okay, meet the conditions, get the license.
Next item is 315, E. Kissendell, Inc.
Something with us, though? Oh, well. What was the number, Tom?
315.
I just want to make sure we're not. All right, go ahead.
Good afternoon.
3:15, you said?
3:15, yep.
Go ahead.
I have the num,
Yeah, that's the number they have.
okay. so-
You're DBA Paradise Empire? Yeah, okay, so put your appearance on the record.
My name is Manuel A. Sanchez Jr., and I'm representing E. Kieseldale,
Who is Ernie Rodriguez?
and Ernie Rodriguez is...
Oh, you're the representative?
He's the contact person,
Okay.
yes. I'm the attorney, Judge.
All right, go ahead.
All right. I believe this is a new application for a liquor license. The person who's going to be, who's the head of the organization or the corporation is here. Her name is Paula White Howard.
So do you want to come up to the microphone? Because obviously you're going to have the information. You're opening a restaurant? What kind of restaurant is it?
It's a Caribbean restaurant.
And why do you need a DJ for a restaurant and karaoke?
DJ, I don't...
With the bar,
You've asked to have a DJ.
yes.
Why?
Whenever time we have a party at the bar or anything like that, or people come for booking and need somebody for entertainment, we request a DJ that time.
So are you going to use promoters as well?
No, not necessary.
So the DJ is for if you have a party or
Like
something like that?
somebody coming for
Special
booking,
occasions
special
only.
occasion.
Like not Friday and Saturday night, we got
No,
DJs
no,
going on.
no.
And why the karaoke? Is that for the same thing?
For the same.
One at a time.
Yeah, because sometime on a Friday night, we might have a karaoke. And then we can request a DJ that time, but not on an often basis.
But see, the problem that we have when someone comes in and tells us they want to be a restaurant, frequently they try to hide the fact that they actually want to be a nightclub. And they tell us they're going to be a restaurant, and then they say, oh, we want karaoke, we want a DJ, we want live music, and the next thing we know, 6 months from now, the police are there 100 times in a month because you have 500 people in there and electric dance music going on, and there's no food being served. Are you going to be a legitimate restaurant?
Yes,
You don't have any plans to move the tables late at night and turn into a dance club?
nothing like that.
What's the occupancy?
About 70?
70, 75.
Like under 100 people?
Yeah,
Yeah, less.
Does anybody have any experience with this? Because, well, you're part owner? Well, you're a representative. I hope.
You're going to volunteer to help me.
So you're going to work for her?
Yes.
Doing what? Where's your bar now? Okay. And what are the hours of this place?
9?
No, what time do you want to close?
Oh, 4 a.m., probably 12? No.
Well, how about we come back with another number? 4 a.m. is not going to happen, given that you don't have any experience. If you come back to me in a year, I might give you 4 a.m. So how about 2 a.m.?
That's fine.
And you have no relationship with
No,
this Kevin Patterson from before, previous licensee?
no.
No, she's not related to him.
Okay, all right. No relationship, nothing? Okay, good. All right.
I'm ready whenever you are.
I think, I don't see really any experience, but that in and of itself is not a disqualifier. So I'm willing to allow you to stay open till 2. Is that every night, or what? What are you looking for? Close on Sundays? Okay. So Monday through Saturday till 2 o'clock, closing. All right. DJ, karaoke,
Only on occasion when they have a party.
occasion for parties, things
We'll
like
have
that.
somebody come in for entertainment only.
Which means the restaurant would be closed.
Well, they'll be serving people, but some people have come in, they're.
Well, I mean, we're getting mixed messages here. You want the DJ for private parties? Do you have a private party room? Because what I'm seeing is that it's an open restaurant. You don't have any room to have parties. So if the party is going on, does that mean the restaurant is closed, that someone rented it out?
No, I believe it'll be open, right? The restaurant will be open.
Then where is the party going to be?
But normally we have people who come in, like we used to visit from when the previous owner owned the place, and you will have like people come in for the party, and we'll cater for them during the whole thing, like a kids party or something like that.
Right, but that means your restaurant is not open to the public at that point. You're just having the party.
The public still come in and walk in, because whenever time you come to book the place, we told them, you know, you're booking, but the restaurant party is still open. So if they agree, yes or no.
You're aware we shut the place that was here previously because they had issues. You guys weren't involved with that, were you?
No, we don't know.
Did you work there?
No.
Did you go there?
Yes. We always stop and buy food coming from work.
You're fine with the DJ?
So I'm fine with the DJ if you want to have it for parties or something like that, but not generally to have a DJ like for a Friday or Saturday night. I mean, if you have it for a function, that's different to me.
That'll be the understanding.
And I'm okay with that. I mean, the place is not that big, so. I'm
How
giving you-
many people does it fit?
75, you said? Under 100?
All right.
That's kind of why I don't think.
Well, there's not going to be any karaoke. We're going to start with that. I will approve 2 a.m. closing, recorded music. I will allow DJ for private events. No promoting, no live music. You have to have food available at all times while you're open. That means, typically to 1:40. And I see you have a DJ platform, and I'm a little uneasy about this, and I have a feeling you're going to be in front of me again. And if you are in front of me again over the DJ, I'm taking the whole place. Because I've seen, I don't know how many times we see this, and you don't seem to have a complete understanding of what you want. That's why I'm concerned. And then when you find out what you want is different than what you told me, you need to come back here and file an application to change that. Or otherwise, you're risking the entire business. So I'll approve on those grounds.
Thank you very much.
And Commissioner Ford, you're good with
Yes, exactly, yes.
You want those?
All right, the next item is 385 Dazzles Restaurant and Lounge Incorporated.
I don't think it's going to happen. I don't think that's going to happen today.
Afternoon, Mr. Chairman, Commissioners. My name is Guy Parisi. I represent the applicant. Early this morning, I emailed a letter from the mayor of the city of Mount Vernon to the secretary and commissioner of licensing. Did you receive it?
I got it. The members don't have it.
If you don't, it's pretty clear that the stuff has to be in by Friday. He's coming from Utica. I'm coming from Albany. Tom is putting together all of these documents. If you mail something today, we're not getting it. This application's been pending since September. There was plenty of time to get us a letter.
I just received it the day before yesterday. The applicant's here. He was in the hospital last week and just got out. He had some surgery. That was one of the reasons it was put over last time. And may I read I have an original copy here.
Just paraphrase it, I'm taking it, he supports the application.
Yes, he does. And he's aware of the prior adverse history of the premises, but notwithstanding, it's been an asset to the community for the last 4 years. It's been a family restaurant. And I point out that it's only a restaurant, wine and beer. He's not seeking any liquor for it.
Why don't we go back to your client's history, though? He was formerly the owner of what was the name of his on-premise place in Westchester?
Dazzle, same name. From what I can see from the history, I did not represent him before. The license was canceled on one occasion because a fine of $5,000 was imposed and he didn't pay it.
Actually, it's closer to 10.
It was 10,000.
But it wasn't
And
paid.
then the last one, it was revoked in July of 2013. And the prior to
Well,
that-
I mean, the thing that bothers me is not just the fact that he didn't pay the fine, but that he went and had the money to pay to sue us to try to get the fine overturned, which then he lost and he still didn't pay us. And is that basically what happened?
No,
You didn't file a case with a motion with the appellate division?
yes, I think my lawyer did,
Yeah, and you paid him to do that, right?
yes.
And you didn't pay us.
But he's the one who messed up the whole application and never filed.
Well,
on
he's
time.
working for you.
At the time, yes.
So you hired him, right? You paid him.
I hired him and paid him, and then when we get to court, one of the lawyers here said his license was suspended. And I didn't know that. And when we get the letter for appeal,
So what's going to happen this time when we find out that you're running a disorderly premise, and I have to send my investigators out there and use all this agency's resources and the police department's resources, and then you come, we get charges, we get we prove the charges, and then you decide that you're not paying the fine.
no, I guarantee, I hope that will never happen again.
I hope it wouldn't happen either, but what am I supposed to believe based on what I just read to you?
Well, for the past 4 years, the whole dynamic of business changed. We try to keep it as nice and clean.
It's not just following the law and keeping it nice and clean, but it's also showing some level of respect to this agency's oversight of the restaurant, which you clearly didn't do, because we gave you a fine, and rather than just say, I can't afford it, here's my license, you took us to court.
It was on the recommendation of the lawyer that I had. I didn't aware of that I was disrespecting the court.
And you've also had significant violations at your other place.
Which other places that?
The eating place beer.
Right, that is at 132 South Fourth, and this address for this location is 130, so it's right next door.
It's right next door.
Oh,
And this Dazzles, so the Dazzles that we revoked, you didn't even move it, we're talking about the same location.
Yes, same location.
And why are you going for a restaurant wine instead of an on-premise?
Because I changed the whole, back then before it was more like hard liquor party, now it's changed, it's more full restaurant.
Yeah.
He's turned over.
Can I see the letter from the mayor?
Yes.
Because I actually just ran into members of the government of Mount Vernon a couple months ago, and they were telling me how concerned they were with stuff that's going on in Mount Vernon and the licenses there.
we have a copy of this, I guess?
No, we don't. Oh, Tom might. Is this the same menu from when it was shut?
No, I think we have a different one.
Who's we?
My attorney should have one. This is the menu? This is it's a little extension, but.
This is the full menu?
I have the menu. I'm asking, is it the same menu?
This is the recent, I don't know if this one you have, the recent one, yes, this one.
If we had the menu that was on file from the other application, it would have been from 2004. I don't see it scanned in,
Okay.
so it would be old.
So what happened at the other place? Because the other place was open in 2005, yet you didn't have any trouble until almost 2010.
Okay. And then when I purchased the building for the restaurant, my brother used to run the other store. So that's when he have some problems over there.
Does this history follow?
No.
So
would-
this
it
is
would
a new
follow-
license? We wouldn't know about this history if there's
You
a,
would, no, you would not know about it. It's only.
because
it
it's a new
goes-
license.
Yeah, it's a new license, so it's his history is called.
What kind of hours are you looking for?
But I open from 8 in the morning till 12 in PM during the week.
What about
2 o'clock, like on weekends.
How late?
Like during the weekends, like 2 o'clock.
What's closing hours in that county? Is it 2?
No, it's 4. It's Westchester.
Westchester, all right. Well, you ready? In my notes, I had, when I reviewed this, my decision was to deny. But I'm strongly swayed by this letter from the mayor in support of you. He seems to think quite a bit of you. So if we all go down, I guess we all go down together, because I'm going to vote to approve it on those hours, 12 during the week and 2 on the weekends. And hopefully we won't have to see you back here for any of those kind of things again.
I hope so too, sir.
Do you want us, no, you're going to give it back, yeah. We got it in email. You said it was 2 on weekends. What was the other time?
12 during the week and 2 on the weekends.
Yeah.
Friday and Saturday.
And Saturday.
I'll vote to approve as well. Nothing but recorded music. That means no DJs, no karaoke, no live music, no promoters, no use of promoters. This is normally something I would not be approving, but I recognize that Mount Vernon is in an economic state that the mayor pointed out in his letter could use whatever businesses are interested in opening. And he clearly is aware of your history, so if he's willing to live with it, then unlike Commissioner Ford, I'm not going down for it. I'm basically agreeing that he knows his city better than I do. So if he's willing to live with you, I am too. What were the hours? 11?
12 during the week and 2 on the weekends.
Okay, with those hours. But the only music is recorded music.
Recorded music only. No promoters, no DJs, no live music.
Thank you.
And I never forget a face, so your only hope if you end up back in here when I'm here is that it's to come say hello.
All right.
Good luck.
Okay, the next item is 351, America's Unidas Deli LLC.
Good afternoon. My name is Marcelin Martin, and I'm representing Edgar Lozano for Unidas, American Unidas Deli LLC. My bones are cramped anyhow. I made an application, and I was told that we're going to have a hearing based on the application.
And you're having it right now.
Yes, so I'm here for it.
Did he have anything to do with the premise with the prior owners?
Not to my knowledge.
Does he realize that, that we canceled the previous license?
Not to my, there was a license in that store before and they canceled it. You don't?
No.
No.
How long has he owned it?
He's in there from, I think it's March. Was it March? We sent out the community board letter in March. But we didn't make the application until September.
So is this, I guess my question is directed at you, is this a restaurant, or why isn't this an eating place beer?
Because they're serving wine.
But is it a restaurant or a,
Wine and beer.
It says restaurant or serving wine, beer, and cider.
It's not a deli, it's a restaurant. They have kitchen in the back,
so they're not selling anything,
no package.
okay.
The place before was a grocery store.
On the menu.
So that's what I'm saying, it's not part grocery store, this is a straight restaurant.
Straight restaurant.
All right.
What's the occupancy? It's like,
It's very small.
they have 10,
10,
6,
12.
10, 12 people?
Indicated 10.
Because he says, his affidavit says eating place beer. That's why I ask.
Restaurant RW, was it RW? I think.
You see his affidavit?
Oh, the restaurant on premises.
You mean, who's he, the applicant?
Restaurant wine.
Yeah.
Okay. Here. Oh, that. Got it.
And what happened? They served
Oh,
to the
that
Ecuadorian.
No,
I see it, it was December. That's not what they applied.
All right, so that's why I was confused, because in your affidavit, you said you were applying for an eating place beer, but the rest of the application says restaurant wine. All right. What are your hours?
4 to 10. Because they serve breakfast early because of the working guys that come in early. So they come in to cook at 4 o'clock, and then by 6, they have the guys coming in.
You're talking 4 a.m.?
Yes.
Right, okay. And it closes at 10?
Yes.
All days, 7 days?
Yes.
You know you can't sell liquor at 4 a.m.
No.
And you're just going to play recorded music?
Yes.
All right, I note that the police department has sent from Spring Valley, because they obviously have concerns, and they sent a letter indicating that they do not object to this, only because you're not requesting dancing, DJs. Actually, you told them you'd close at 9:30.
It's 9:30, 10 by the time they finish straightening up. They're out of there by 10.
I don't care when they're out of there. When's he not letting anybody else in?
By 9:30 because they close at 10.
So can we say
And the place
9:30
is so
closing?
sorry.
Can we say 9:30 closing? That's what the
Yes,
letter
okay.
says.
He can stay there all night and clean it. I don't care. It's,
They're not selling anything after 9:30.
right, okay.
So 4 a.m. to 9:30.
Right, okay.
That agrees with the letter of support you got from the police department.
Okay.
All right?
It's actually, just to be clear, it's a letter of no objection. I'm not going to say that they're supporting.
They're not opposing at this time.
Yeah, because they will come back and yell at us.
I'm sure.
All right, I'll approve 4 to 9:30. Just background recorded music.
Thank you. It's a very small place. Nobody can dance.
It's got to vote. I'm only one vote.
I approve
Thanks
as
a
well.
lot.
Those terms, yeah.
Next item is 349 North Babylon Liquor and Wine Incorporated.
The applicant here? Did you guys sign it in? Okay, you're objecting, right? Yeah, come on up.
My name is Scott Kemick. I believe I am the closest store.
Grape Culture.
Grape Culture.
And what's your distance away?
So we're about 0.9 miles away, and I know that our competition in St. James, he's about a mile away from that store.
Your competition is who?
Would be Licorium, which is, I'll give you the corporate name, because he's new.
Oh, that's Viona Wine and Liquor?
Right.
Okay.
Yeah. So we're in a small hamlet of the larger Smithtown area, and
Oh, so you two are both in St. James?
So we're both
Okay, I
in-
see.
Right.
Okay.
So yeah. Now our population is about 14,000 in our zip code. Again, being in the hamlet of Smithtown, which has got a population of about 40,000, there's 3 stores in Smithtown for about 40,000 people. We have 2 stores for about 14,000. So
You're the other store? Okay, I'll give you.
yeah. So I'm just trying to say, it's disproportionate. We have one supermarket in town. It's very rural. There's no open swaths of land. There's no construction on the horizon. You know, we've been pretty flat with population. I think it's actually decreased a little bit. It just really doesn't warrant it. There's already, that Viona is on the same road, on the same side of the street. You know, it doesn't really.
Is it accurate to say that there's 11 stores within 3-mile radius?
Yeah. Oh, yeah. Absolutely. Yeah. I've got it right here. I mean, I've listed. I don't know if you have it, but I mean, I could call them out to you if you want. But I use the
No,
lamp
that's fine.
system. Yeah, I use the lamp system to actually come up with all these.
Okay, why don't we give him a shot?
Yeah. Okay.
How you doing? My name is Mike Fieri from Stony Brook Wine and Liquors, which I believe I am the third.
No, you're
Am I the-
fifth.
Am I the fifth?
About 2.6 miles, does that sound right?
Sounds a little long.
2192 Wisconsin?
Yeah.
Yeah.
But on Google, I don't know what you use to find that, but I know on one of them, Google Earth or Bing Maps, it comes up wrong.
Okay.
Which I think that's long, because we went through this about.
So how far do you think you are?
Probably just about on that 2-mile mark.
Okay.
Because we went through this 2 years ago. We were here with another store that was opening in between, actually, where our Scott stores and this proposed store. And that's how I knew we went around that whole thing. And what it basically is too is distance-wise, it's pretty far where I'm at. But North Shore, Suffolk is kind of a little different too. It's not like the city. You know, it's as much as the distance in the car, you're not passing, thousands of homes. And in that meanwhile too, you're passing a school and 2 nursing homes and actually even in this place there was another school. You know, it's a kind of a rural area. So, distance-wise, listening to a lot of these 0.4s and 3s and seems, miles
Well, this is,
away.
so basically what you're saying is a driving community.
Completely. We share the same customers as of, in all the local stores,
Okay. And, okay, I don't have anything else.
And I feel the area, like Scott mentioned, it's kind of peaked years ago. It's an old town that every ounce of land has got a mailbox or, a car park on it, But, as far as like, that's available.
Okay.
There's just no new growth.
All right, I think we're ready.
Yeah, applicant is not here. Is that
Right.
correct?
Yes.
Well,
And it is 2:30, and we started at 10.
Well, I'm going to vote to deny. It looks like the 4 closest stores, their sales, I just calculated out, looks like they're on a slight decline, so I don't think there's a need.
I'm going to vote to deny as well. There's 11 stores within 3 miles, and applicant, as Commissioner Ford pointed out, is not here, so it's very difficult to find out what he would be doing or she would be doing different from the current stores and what their public convenience and advantage would be. Just based on the fact that he's applying is not serving the public convenience and advantage, so I'm going to vote to deny.
Next item
Can
is,
we take 2 minutes?
okay. Item is 328, Ms. Gizo's Pizza Corp., if I'm pronouncing that right. Am I even close?
Say that number again, Tom?
328.
All right, so this is a 200-foot reconsideration?
Based on a handicap door entry?
Yeah, I'll send back to, we had an investigation done, and it appears that the door is not regularly used. I'll send it back to licensing.
Back to licensing. Very much.
Next item is 383, BYP Corporation.
383.
Good afternoon, Bernardina Soto, BYP Corporation.
Have all these health violations been corrected?
Yes.
Are you the licensee?
No.
Well, we sent a letter that the licensee was to appear.
I know, but he's working, so he gave me this paper.
Where does he work?
What's that? I don't know. It's like a school he works. But he gave me the.
Well, who are you?
I work with him.
Where?
In the restaurant.
Does he work in the restaurant?
No, he doesn't work because he got his job. So I'm like the manager.
You're like the manager, or you are the manager?
Manager.
Does that indicate, is she on the,
I gotta get in the other program to find that stuff.
Oh, let me see.
It's in the CNG.
Oh, it is? All right.
Yeah, I'm just trying to see if I can get something quick on it.
do you know why we called you in here?
Yes, because they gave us
No,
the fine of the $750
Yeah, but do you know what the violations were?
from the health department.
Well, you've been open for about 7 months at the
Says
time of the violations, and they had evidence of rats.
No employees. That's what's on file.
Yes, but we already fixed everything, and they were blaming us that the basement belongs to us, and it didn't, because in the lease, it doesn't say the basement.
Well, I'm not gonna, we haven't, on the application, he's indicated to us that he's gonna work at the restaurant and have no employees. How many employees does he have?
No, it's just, I'm there now with my husband, that's it, because he's working now.
Who's your husband?
Israel Davila.
So it's not Jose Valentin.
No, he's not in the restaurant now.
So he doesn't work there ever?
Yeah, he's working, but now he's working and,
Exemption for workers' comp. For no employees.
All right, so yeah, I'm not gonna accept this. He needs to come in here, and we're gonna have to send enforcement out again.
Okay.
Because he's not running the restaurant the way he told us he was going to.
Do you want to just deny this? You want
Yes.
to hold it over?
No, we'll deny it. And then can you just email enforcement and tell them that they have to go back out here?
Sure.
You're gonna do that? You can, thank you, while you're.
Okay, thank you.
And you were okay with that?
Yes.
All right. The next item is 350, Wine 365 Incorporated.
Good afternoon. Joseph Levy here on behalf of Wine 365 Incorporated. It's an application for a change of class from a wine store to a liquor store. There is some opposition here today, if you'd like to hear from them first.
Sure.
What number was that again, Tom? I'm sorry.
350.
50.
Good afternoon, Glenn Wright. I represent Primetime Liquors. With me is George Soros. I sent in a submission last week. Before I get to public convenience, the distances, whether or not they're going to be able to offer anything else in the neighborhood. I just like to say this seems to me fundamentally unfair. The applicant seems to be like someone who knows how to work the system, that they came in about 2 years ago. And
Well, see, and I'm not going to get into whether it's unfair or not unfair, but they haven't been granted anything. Anyone can apply for anything as many times as they want. So there's nothing unfair with them applying.
Oh, I'm not.
I would probably, I understand where you're going with this, and I don't like to argue about whether someone should be applying or not, because they have every right to apply. But go ahead.
Yeah, I mean, I don't believe there was a written stipulation. They absolutely have a right to apply, and I believe the discussion was 1 year anyway. But I think if they were to be granted, it would be somewhat unfair. They've submitted this application 1 year and 8 months after opening. During the hearing, they repeatedly said that they had absolutely no interest in selling wine. They talked about their experiences. Sommeliers, and even on their website they say, we focus on wine because we have no interest in selling spirits, and yet here they are. As far as my client tells me, their selections of wines are also a misrepresentation. During that hearing, they also talked about offering a lot of small vineyard wines from Long Island, a lot of very esoteric brands. He tells me that they mainly carry all the generic wines that are available through some of the major distributors. So I would submit that if they were to be able to sell spirits at this point, they would probably carry a comparably generic selection. They are a large store. They're 2,400 square feet. So I think if they were to be granted liquor, they would have a major impact on the surrounding stores, including my clients. There are 6 stores, 7 including this one, within 1,900 feet. They are all either on the same, 3 are on the same avenue. The other 3 are on the avenues directly adjacent to it in either direction, in about a maybe 5 block, maybe 6 block radius. The area to the east is Prime Park Slope. I submitted a map with my paper showing that area has already been saturated. A lot of upscale wine stores. There are about 10 between that and Prospect Park. To the west, it's mostly industrial. It's mostly strip malls. I've included some pictures from Google Street View, but taken from the corner in front of their store. Now, those photos in each direction show that there's not a lot of buildings on the horizon. Those photos were taken in October 2016. Where they're located, and I can understand when they came before you, there's a few developments. It's about 6 developments right immediate around them. But then you just get beyond that, and you get a church, you get a major highway to the south, and then beyond that it's more industrial. You've got a Staples, you've got factories. There's just, to the west, you've got then the Gowanus Canal. I mean, if there's no, bigger demarcation between shopping districts, I don't know what there is. So to the east is saturated, to the west, there's simply no more room to build development. So I think one of the reasons they were granted, in my opinion, was that I saw some articles with their original application about the growth along 4th Avenue. I would submit that has not been sustained, that the building market in Brooklyn, is overpriced and saturated. As far as the other stores, they're all open floor plan. I'm talking about the 6 stores immediately surrounding them. The sales have increased moderately at most of them. The 3rd closest, 10th Street, Mujibee, the sales are declining. But as I submitted...
Is it accurate that is a internet? Oh, no, I'm thinking of Borisol's... oh, no, Muhariji and 10th Street. That's an internet business, though, isn't it?
Maybe you can speak to that.
Well, they're open to the public. They open at...
Well, everyone has to be open, but most of their business is internet?
It's a bulletproof store that
Has significant online? Okay. I watched the video of
okay.
this. I've seen it.
All right. So those sales are declining. I put in my papers, census and the surveys, bringing it right up to 2015. There was a 10% increase since 2010, but there's been, out of the nearest six, three of the liquor stores are new locations, not sales, but brand new locations since 2010. So I think that was factored in when they came before the board 2 years ago, and the board made very clear that they wouldn't be granting it if it was a full liquor, that it was only a wine. And then that was echoed again when the second closest store, who's here today, and she'll speak in a minute, Good Wine, came before you to upgrade to a full liquor, and Commissioner Kim again said that 365 Wine would not have gotten granted if it was a full liquor. And there was another license on Next Avenue, I don't recall the name, that was denied around 2015. So this board has been pretty consistent that this area, has been saturated. I don't think they're going to really offer anything different. This growth cannot continue. It's a landlocked area. I just don't see this. There's been an increase in some of the sales of the stores, but that's not going to just increase ad infinitum. And I would ask that the 3 stores that have opened since 2010, that they have a while to settle in. And once again,
What's the third one? I see Good Wine opened and Acme Spirits open. Oh, these guys. is
Brooklyn
what you're talking-
Barrel? Oh, those guys, yeah.
They're the other new one. Okay.
Brooklyn Barrel and Acme Spirits.
Oh, then Brooklyn Barrel, when did they open? 2011?
Yeah, I think 2010. Acme
Okay,
Spirits
all
opened
right.
in 2013. Gowanus Wine Merchants opened in 2012. And then these guys opened in
Oh, I see, okay.
2015.
Yep.
They didn't get their license to March 2015. So I would just ask that these all have, a while to settle. This is not just an upward trajectory that's going to be ad infinitum.
Okay, thank you. Anybody else in protest?
My name is Heather Johnston, and I am the owner of Good Wine NYC LLC. We do business as Good Wine. I purchased the store from Piccotti e Vino that opened, I think, 2016. So it has been an established wine shop for quite some time. I applied for an upgrade and was opposed and denied. And my feeling, very strongly, is that the other thing is that while I was getting the sale of the business, Wine 365 was also in the process of opening. And so my understanding was that they did get granted because on the stipulation, written or otherwise, that it would just be a wine shop. And so my grave concern for myself and my business is that I'll be the only, store in town that will not be also able to offer liquors. And I don't do what a lot of other people do. I have very small producers. I have a serious background in food. We do tremendous wine education, and I feel good about that differentiation, but there is an issue that I know we are physically close and in close competition, and my sales will absolutely go down. My feeling is, should they be approved.
Okay. Thank you.
Thank you.
Go ahead.
All right. So a number of points that were made by Mr. Wright are actually factually correct. He mentioned the area is landlocked. There's not a whole lot of room for growth, and that's pretty much a true statement on the Gowanus side with that industrial neighborhood and being landlocked. However, what he failed to mention to this board was that there was a major zoning change in 2011 that allowed for residential construction that went above what were prior limits. As a result of that, there have been somewhere around 16 or 17 new residential development projects in the immediate neighborhood. And by immediate neighborhood, I mean on 4th Avenue, right around this particular store. I'll just read through them quickly, and then I can submit this if you'd like to review them. And you'll notice that probably 75% of these projects were started within the last calendar year. So what I would put before the board is that circumstances have changed from when this application was originally before the board as a wine store license. Now, I was not representing them as the wine store license, although I've watched the video quite a few times. There was no stipulation that they would only be.
And then you watched yourself then.
I watched myself actually protest, but I protest on behalf of Good Wine because I was under the interpretation, as Mr. Wright had mentioned, that this was going to be a 2,500 square foot store, and I was concerned that a store that big in this neighborhood would not make sense and would hurt the other stores because every other store here is of the boutique variety. What you learn from the video is that half the size of their store, 1,200 or 1,300 square feet, is storage and wine education. That's what they proposed.
Which is the only reason it got approved.
Correct. And I really had nothing else to say after I was told that it's actually not going to be a 2,500 square foot store because being 1,200 square feet, it's in line with the boutique nature of the other stores in the neighborhood, and that's what we have here, and that's what's continued.
Well, no, I mean, I don't know that represents what you actually said, because I can quote you. You said, there's no need for another store no matter what the business model. The area is being well-served, and this store is too big. Now, granted, you found out it was not too big, but any business model means any business model. Given your interests were different then, which this is a novel occurrence for me.
Me as well. I don't often have to argue against myself. What I will say here, though...
You never win those arguments either.
Kind of like at home.
Yep.
But anyway, what I would say is different between that day over 2 years ago and today is these massive development projects. So you have a 430-unit building going up 365 bond, 270 apartments, 363 bond, 4th Avenue at 250 on 1st Street, 44 condo units, 609 4th Avenue, 79 residential units, 470 4th Avenue, 105 new high-end rentals, 488 4th Avenue, under development currently, 269 4th Avenue, under development, 26 residential units, a planned building at 243 4th Avenue. So I'll hand this up to you so you can take a look at it. I've got citations for each of these things. And I don't know how familiar you folks are with this neighborhood, this sort of borderline between Gowanus and Park Slope. These are two very different neighborhoods. All of the stores that we're talking about today, with the exception of two, are on a different avenue. 4th Avenue, which is what we're talking about here, there are two other liquor stores. One of them is 6 blocks away in one direction, the other is 5 blocks away in the other. And this is a major thoroughfare. And the one that's 6 blocks away in the one direction is a bulletproof store that focuses their sales primarily on internet sales. We are primarily here today asking to change the class of this license because of the feedback we are getting from our customers. We have become a neighborhood staple. These two gentlemen have gotten involved with the local community, the Civic Center. I've actually got a letter here, if you're interested in seeing it, from City Council indicating that they are applauding them for being, was age-friendly? Is that so age-friendly designation? This is a bigger store.
What's an age-friendly designation?
I'll explain. They have a space that has very wide aisles to accommodate people with wheelchairs, people with strollers. They have a designated children's area with games that kids can occupy themselves while their parents are picking up some wine or whatever it is. And they've gone out of their way to create an environment that fosters that sense of community that they said they were going to do initially. They're involved with the community. They're acknowledged by a lot of people in the neighborhood. All of their clients say, look, I understand the next liquor store is only 1,200 feet away or 1,500 feet away, but it's up this huge hill, and it's a real inconvenience to get up that hill if you're old or if you have a wheelchair or if you have a kid, and they just are looking for some convenience. So we're talking about public convenience and advantage today, and I would tell you that allowing these gentlemen to add liquor to their existing wine store would be a perfect example of conveniencing the public in this neighborhood. They're committed to being wine guys. They are wine guys. That's their history. That's their credentials. We're not talking about a conversion here from a wine store to a liquor-only store. We're talking about maintaining levels of inventory that's probably 3 wine SKUs to every 1 alcohol SKU, right? So we're not talking about a drastic departure from the original plan. We're talking about adding some additional products that would help them to better service their community. So the incredible change in growth in the neighborhood, plus the fact that on this avenue, you only have 2 other stores, and neither of them are very close. This is still densely populated New York City. This is not rural Long Island or upstate. So I think we should be using that rule of thumb that we apply to the densely populated neighborhoods in the city. And you can see all the residential growth. These guys took a gamble a couple years ago that 4th Avenue would explode as they had been promised, and it hadn't really happened yet. And now it's happening. And we have these articles, these projects that are underway, people moving into the neighborhood. Park Slope is very saturated with, it's overbuilt, you have stores there. We're not getting any increased population number in Park Slope, it's done. Gowanus, however, with the new zoning changes, there's an opportunity there for businesses, there's an opportunity there for residents, there's a great influx of people, you have tons of public transportation, and you have guys who have held themselves out as good operators and have done exactly what they said over the last 2 years.
Okay. No.
Yep.
No.
All right.
Can I see the exhibit that he handed up?
Yes.
Given that he didn't file in advance, and I really thought there was a deadline on Friday.
Well, you can, yeah, you can come look at it. It's development, but there's no need for,
That didn't
okay, go ahead.
accept it as an exhibit. Just look at it. I'm looking at the closest store. Looks like these figures are from 6/30, so looks like they're on target to do 1.8 million, which would be a good return back to what they did in 2015. The other store is 2.6, if I have my figures correct. I don't really have any objections to changing the class to a liquor store, so I'm going to vote to approve.
I'm going to vote to deny. I did watch the tape, and while there's certainly no stipulation that you would remain a wine store, you did get approved because you were a wine store and because you were sommeliers and because you were going to do high-end, hard or less available vineyards and things of that nature, and you created a niche that I think became attractive to the board at the time. I don't think that they would have put a liquor store in here. And in fact, they voted against you until they found out that you were going to use a significant part of your area for, even the wine store they voted against, until they found out you were going to use a significant part of your space for wine education. No, I understand that, but my point being that you were on a very thin line on the approval, and a lot of it was because of your experience and because of the business model that you proposed. 100% of it, I think, was. Not to mention that we did have an application for a full liquor by Best Wines, or Good Wine, I'm sorry, and we rejected that in 2015. I'm not saying that either one of you may be full liquor at some point, but your development started in 2007. That we didn't respond to that with Good Wine. Maybe when it becomes more complete, there will be a need for another one, but right now, given what I watched on the tape and the fact that we've rejected the one previously, I'm not ready to give anybody a full liquor license, nor will there be another liquor store there.
Chairman, can I add one thing?
Yes.
To maybe sway you a bit? Again, we're talking about 4th Avenue here as opposed to 5th Avenue.
No, I understand that.
Good Wine was on 5th Avenue where there are many, many stores. 4th Avenue, there really aren't. The two on 4th Avenue, the one with the tremendous internet sales, that's also a bulletproof store, not an open format store. They also.
But it was before. When they approved this wine license, it was a bulletproof store then.
Their hours, though, are not very convenient for people in the neighborhood. They don't open up until the evening. They're not.
Well, then those people have to go to 5th, or they have to go to
So these guys
to
are
3rd.
open, these guys are open at noon every day, and that's an extra convenience also, because if you take them out of play, if someone's looking to go and buy spirits during the day, there's nothing else there at all in that direction.
No, I understand that, but I mean, at this point, given how close these are, and the fact of the matter is, as council pointed out, that we opened one in 2012, we opened one in 2013, we opened Good Wine in 2015 or 14. I don't know that any of that has played out entirely at how it's going to affect everybody. If all those apartments come to fruition, you probably are seeing at some point, I mean, somebody be getting either Good Wine or them or both getting a full liquor license, but right now I'm not ready to do it, so I vote to deny.
All right, and the next item is 316 Wine on 9 LLC.
Go ahead.
Hello, my name's Dave Hardesty, here for a 2,625 square feet liquor wine store on Route 9 in Wappingers Falls.
And is this a standalone building?
Yes, it's a standalone building.
What was there previously?
Right now, I'm operating a tanning salon at that location.
Is it your building?
My family's, my wife's and her 3 sisters own the building and the property. I've been operating a tanning salon there for 7 years.
How much retail space are you thinking about? He says you have 2,600
Roughly
total?
2,000. There's a pre-existing door. We're going to just use that door as a separator for the stock room behind that.
You have parking?
Parking all around the building, yes.
You're right on Albany Post Road? Right on Route 9 there?
Right on Route 9, yes. The reason for the name.
Right.
Was Dakota Wines, did that replace an existing store as he has claimed? Do you know? Issued 7/13.
I mean, you realize we moved the place right very close to you in December. Are you aware of that?
I'm familiar with that.
On East Main
That operator has moved a few times. and
East Main Street in Wappingers?
He used to be a tenant of my brother-in-law's, and I.
He did?
He used to.
He's moving from Hopewell Junction.
Uh,
I don't think he's even open yet where he is he, Jackie?
It's, yeah, it's actually
No, he's moving to Hopewell Junction.
Oh.
removed to
It
this
doesn't surprise me if
location
he's
from.
moving again.
Yeah.
Read it.
He's a character.
He's on East Main now, and he's moving to Hopewell Junction.
Oh, well, that changes everything. Okay.
Dakota?
No, I'm talking
Oh,
about
the one- the other one.
Vinovin.
Oh, the other one, yeah, everybody's moving around this place.
Oh, that guy's moving, okay, I see.
There was
So
a-
we did move,
One moved out of.
Dakota, we
one moved from Hopewell Junction, and one guy moved into Hopewell Junction.
all right, so the closest store is actually 1.3 miles away. Correct?
Yes. Or will be. Because the closest store is still there,
No, I get that, but he's going, right?
if it gets approved.
Oh, I see, he didn't file, he just filed it, we didn't approve it yet.
Right.
Okay, I thought we approved it.
You approved the move from Hopewell Junction to
Poughkeepsie.
to Wappingers, or Poughkeepsie rather, but the other one you haven't approved yet.
But nobody likes where they are in Poughkeepsie, they're all moving around.
I'm from Poughkeepsie, so I left.
So they haven't moved yet.
No, they filed an application to move.
Let's see where it is.
Where are they moving to? Yeah.
A long way away. Like several miles.
All right.
Still in Dutchess County, but.
You ready? Questions?
Did you answer his question about retail space? How much of it was going to be retail?
It's about 2,000.
Approximately 2,000. There's an existing exit in the rear that we're gonna work off of, to separate at that point. And there's 2 bathrooms that are we're gonna use one of the bathrooms for an office.
Does the rear exit go to parking?
Yes.
Yeah, I'm ready.
All right. I'll vote to approve, especially in light of your closest store is applying to move. So I see a public convenience and advantage of being served.
I'm going to vote to approve as well. The closest store is 0.9 miles away. He has filed an application to relocate to Hopewell Junction. That's obviously pending, so we haven't approved that yet, but his sales he was just issued his license in December of 2014, so it's difficult to figure out what his sales numbers are at this point, because he doesn't really have,
The first removal was conditionally approved in February.
oh, we did approve the one.
It's conditionally approved, it
Oh.
hasn't been issued yet, yeah.
Okay, so he's gone, so I'm taking him out of the mix. The other licensees' sales have gone up or remained steady. And that would be the closest is 1.3 miles away. And the next closest is actually a 40,000 square foot store that's doing over 14 million in sales. So I don't anticipate you're going to affect him much. So I'll vote to approve based on that.
Thank you all.
All right, the next item is 305, DKK Wines LLC.
Did we approve that conditionally already? I seem to remember that.
Outside, we could have, I don't know. No, I don't think it came to you. I
We
think
had to
it's-
have, because it's like 5 miles.
I'll take a look at it.
Good afternoon, Kenneth Gale, representing DKK Wines LLC.
Are your clients here?
I'm also my client.
Oh, okay. Your partner here or no?
No.
Okay. What's DKK? Oh, you're currently a wine store looking to become a liquor store. Okay.
We want to add small batch spirits.
Is there any protest here? And we didn't get any protests.
Yep.
Why do you want to sell liquor? I mean, I know why. What's the reason though? What's the reason that you're changing?
Well, our closest competitor, Rand, he doesn't offer the type of spirits that our current customers are looking for.
What's
So,
your closest competitor?
Rand Liquor. I don't know the corporate name, but it's on
Ricky's Liquor Corp?
Yes.
That's 1029 Bedford?
Yes, sir.
He doesn't, is he bulletproof?
Yes.
He is.
Yes.
Is Trey Morey, and that's just a specialty wine shop?
Yeah, I don't think they sell spirits at all.
And what about 369 Northstern Avenue Liquors? Are they bulletproof?
I don't think Mr. Barnes ever opened.
Yeah,
We got approved the same day, and he.
369 Nordstrom, you're telling me is not, Nordstrom is not open?
I don't think so. Oh wait, is that Brooklyn Cellars? No, we're 296 or 369. Oh, that's bulletproof also. Yes.
It is bulletproof? Okay.
So you're going to have an open floor plan. You have an open floor plan with like a 200 square foot store.
Yeah, and we're just gonna add some shelving behind the counter and do small batch bourbon, gins, a vodka or two. Nothing much.
Yeah. All right. Any more questions, Chairman?
No.
All right.
Where do you guys sit?
Oh, we stand.
Yeah. There's no protest. I think you have, with your minimal size, I see minimal impact on the other stores, so I'm going to vote to approve.
I'm going to vote to approve as well. The store's closet size with 200 square feet. The closest store is a bulletproof store, and the third closest store, which is 0.3 miles away, is also a bulletproof store. He indicates he's going to specialize in small batch.
My partner actually sent me a list of what he's looking at. Sorry about that. Green Hook Gin from Brooklyn by the Still One Distillery, Industry City Vodka, Albany Distilling Company Whiskey.
Okay, so I recognize they're all small batch. And there are no protests, either written or otherwise, so I'll vote to approve.
Thank you.
And the next item is 384, Butterfield AWP LLC.
Good afternoon. This is an offer of compromise to resolve the charges.
We get a check from the previous case?
Not as of a week ago. Let me check again.
Did they pay the 12,000?
What they did.
He's a little slow here.
Yeah, it's paid.
You did?
All right, I'll
Working
accept.
faster than mine, so.
Accept.
Thank you.
All right, next item then is 372 to 376, Old Blackthorn Inn Incorporated.
It's also an offer of compromise that was submitted to resolve the charges.
Conditions on method of op.
Yeah, I counter, we cancel and bond.
Well, let me just add this. The counsel's office has been in direct conversations with the police chief at Rockville Center, that since they went.
Our counsel's office?
Yes.
Have you, or is that Amaretto? Okay.
Yeah, because this was a summary suspension. So as a
Right.
result of the summary suspension, going to court back and forth, and then trying to bring this offer of compromise to resolve it, because the judge at the Article 78 proceeding also suggested we try and settle this as much as possible. We came up with the offer of compromise to do so, but in doing so, we agreed that they would only operate till 2 a.m. They wouldn't operate any later than 2 a.m. And that my understanding is that the police commissioner was okay with that being done, as the other things that they've changed as a result of their conversations with the police department have worked since that time.
What hours were they supposed to have before?
2 a.m. Actually, if I'm not mistaken, I believe the judge had them closing at 1 or 1:30.
No, I'm saying before all this, before our summary suspension, what were the hours that we allowed them to be open?
That was one of the questions. I didn't represent them on their applications. The legal department had it down as being 2 a.m., although there was some applications that were filed by a previous attorney, Tom Bray, who was supposed to change this. It was an alteration application that was filed. They had been operating till 4 a.m. on the weekends. As part of this offer, we agreed that we would only operate till 2 a.m. and not beyond 2 a.m.
Is this a restaurant? Supposed to be a restaurant?
It's a
Jackie?
restaurant,
Hard
it's a
to go-
bar.
I gotta go back. It's a 1998 record.
Yeah.
So I gotta go
It's an
into
old
the others.
application where there was an alteration, where when the alteration was filed, they indicated that there were certain changes in the alteration, such as I saw that they put a DJ booth in, then indicated there was
05?
also a DJ. That goes back to '05. And again, that was, I think, just before they put in the change in method of operation application that had been used.
What we have listed in the method of op for our data screen, which prints on the license, it says tavern serving wine, beer wine.
Beer wine.
Someone must have looked at it at some point.
It only has a beer wine license?
I'm sorry, beer
Oh,
wine.
beer, wine,
Well,
and
that's,
liquor.
it's, sorry, scrolled off the page, liquor.
So for example, when the 2005 alteration application was submitted, there was clearly the DJ booth was indicated and so on and so forth.
I don't know. What you come back with, Chairman, Councilman?
He has it as, our prosecutor has it as a restaurant/tavern, so it's combo.
They have a DJ now?
Yes, my understanding is they have it.
So the this is what I would live with, potentially. The DJ goes. There's no live music.
I don't know if there is now.
I don't know if there is now either, but I realize the application doesn't probably indicate this stuff. There's no use of promoters.
They don't do that, okay.
They shut, at least for the time being, at 1 o'clock every night.
About cabaret. No dancing?
Well, no dancing.
I believe they have that license issued by Rockville Center.
That's fine, but there's no dancing. And the only reason it is because it looks like that I'm considering this is because it looks, is one, your representation that the police department's fine with it, and two, that it looks like it got out of hand recently.
Yeah, it did. It got out of hand recently, and then it was addressed with the police department. Once it was addressed with the police department, and the court indicated a 1 p.m. closing or 1:30 on the weekend. I'm not sure what it was because I wasn't at the original stipulation proceeding. I was away. Another attorney was there. There haven't been any problems whatsoever with the
So 1 a.m. closing, at least for a year, you can come back and ask for more in a year. And then it's going to be $30,000.
Obviously, I can't give you that.
No, I know.
Today.
But you have it, and I don't know I don't even know if he agrees with it.
I even think that's being generous, but I'll go along with that.
Well, you can toughen it if you want.
No, that's fine.
All right, so we'll do that as a counter offer then.
30,000.
It's a counteroffer, yes.
Yeah.
And all those conditions on the method.
Yeah,
would be
so all
done.
those, the method of operation changes, at least for a year.
Yep.
You want it as a formal method of operation change?
No, can we just do it with, I can
Operator's
just
process.
institute it, can't I?
As long as you.
Well, if we agree, we can agree that we would put that into place for a year
It's
and
better
have to
for the
come back
record
before the
to
authority.
show the
Right.
flow.
Right.
Since
Okay.
And I'm also assuming
All
that
of
that's
this
going to
license.
contain during the Article 78 proceeding, obviously security guards and everything that was with the.
This would nullify, in fairness, I think they should keep the security guards. So,
Yeah.
Right.
But if this is accepted by them, it would then render the Article 78 moot, and we do a
Correct,
stipulation.
that's not my question, Counsel. My question is very specific as to the fact that there was a lot of very serious conduct at this establishment where people were very seriously injured. My understanding is that as of the time when the stay was issued and the hours changed, things have been better, and that's what I was told by Mr. Alvarado as well. Part of the back and forth that you've engaged in good faith with Mr. Alvarado was a set of conditions. I know that the members are looking to impose more serious conditions. That's absolutely their prerogative. I'm just ensuring that the other conditions that came as part of that stay are also going to be part of this, and that's okay.
And I believe,
Yes.
and I believe
Unless
the
they contradict what I just said.
Right, exactly.
And I believe the only one that was in addition to that was the security
Okay,
issue.
I'm just making
I believe should be
triple
kept.
sure. No,
Yeah.
thank you, Counsel. I just want to be really, really sure
All
about
right, so that's where we are.
All right, the next item then is 347,
I'm never going to know.
Stanton Restaurant Corp.
This is a request for reconsideration, which was brought up.
347.
With regard to a previous counteroffer that was made by the authority, we have submitted additional documentation to you. There's a letter of December 7th, which you should have. That included all the steps that were taken in this matter to resolve the problems that were there, as well as letters from the community. There was also conversation in that matter with the local police captain. The police would not submit a letter as that's not their policy, but Mr. Jones had a phone call with Captain Hellman regarding the premise. I believe that's been,
All right, so it's 15 $56,000, and you're representing all of these regulations are now, they're in compliance.
No. What they are now is they paid all the fines as indicated in the letter before you, but now what they have to do is physically do work, which is gonna cost $100,000, I believe, in order to make the final changes so that the TCO will be given.
Okay.
Once that's done, then we will have the TCO. We will not reopen until such time as the TCO is granted.
Okay, so I'll accept the 15,000 on that condition.
15,000 accepted.
You earned your money on that one.
The next item, or is actually three items for the same licensee. It's 298, 364, and 369, Javar Corp. If you might want to pull them all out together.
298, say them again?
298, 364, 369.
The only thing I can say on this is that.
Just give me a second to.
Oh, sure, they can pull them out, sure.
Okay.
Just briefly, there was previous charges where you canceled the license. This is now up here before you on these charges.
Who are you? Okay. So what, are you here on this one? Okay. Why don't you finish what you were going to say?
That basically, you've canceled the license, so I don't have any.
You don't want us to revoke it, is what you're saying?
No, only for the landlord's sake as well.
Right, okay.
Good afternoon. My name is Detective Ed Negron. I serve as the 114 Precinct Community Affairs Officer. I'm here today to discuss incidents that have occurred in response to or as a result of Aces Nightclub, which is located at 3210 37th Avenue.
But just to stop you there, you realize we canceled the place already.
No, it hasn't been imposed yet.
It hasn't been imposed, but we haven't imposed it, but they've lost their license.
Okay.
Is that what you're here for?
Yes.
Okay, they're going to lose their license again.
Okay.
So you win.
Okay. So you don't want to hear it?
All right.
Okay.
What I would ask that if there is a new application, because I'm sure we will get one in the next 3 months, and you get notified of it, that if you have issues or some type of measures you want them to take, whoever that may be, that you come here again and tell me what those are.
Okay.
Chairman,
But I'm canceling and bonding.
Cancellation order went out, and it is effective March 9th for the prior matter.
Okay, and I'm canceling and bonding, or not bonding, we've already bonded, so I'm canceling on the other 3 cases as well.
Thank you.
Yep. So that's going to be another 2 weeks, but they have to go and obviously give it to them, but that's how long it takes. All right.
Thank you very much.
Yep,
Very nice.
you too.
It's fine. No, go ahead. You're fine.
The next item, well, someone signed in for 357. Mr. Joe Zhu? All right. But by that, you adjourned that. Okay, well, sorry about that. I thought you had gotten a response.
I don't have it, so we can't.
No, because it was adjourned.
Yeah, so this is adjourned.
Well,
You didn't keep it with you?
you want I make a copy and give it to you?
Yeah. Or just give me what you got.
Yeah.
Because I leave my adjourned stuff home.
Good.
Yeah. Okay. Do you have it?
No.
Oh. That's okay. Do you have it? Yep. Go ahead.
I was already here.
Okay, go ahead.
Chairman, this is basically a no contest. My client owns a deli in College Point, Queens. He's had it for 3 years. He's never had a violation or any incident involving the liquor authority or the police. He's never been in trouble in his life. He has 2 newborns. He works there with his wife and basically 7 days, almost 6 to 7 days a week, sometimes Sundays. This incident is an employee who is already under investigation by the police and targeted. This person Mr. Bros lives in the neighborhood, and so do I. And he had approached my client asking for work. At the time, it was actually timely because it was around December that he had just started, and he had asked to work a few hours a week while my client would work the mornings because my client's wife had just went to China for 2 months. So he was taking care of his children and would let this employee work a few hours at night. Well, now this Mr. Bros was under investigation. He was the target. Any time he was in the store, he would bring whatever customers and send them to the store. Mr. Bros pled guilty. My client had absolutely nothing to do with these drug transactions. He just took him on as an employee and made a bad decision by doing that. There was a search warrant executed at the time. They went into the store and they did find 40 packs of cigarettes that I believe were on stand. He paid a fine for that. It was a disorderly conduct, the $300 fine. For the nuisance and abatement, he paid, the store has been open ever since. It was opened approximately 2 days after, and he paid a $5,000 fine. What we're asking is that he be given a second opportunity and that his license not be canceled. And whatever fine the board deems just and appropriate.
So do we receive any notification from Department of Taxation about the cigarettes?
Did we? That would be you.
I don't have the number.
Oh, sorry.
No, it's okay.
I mean,
42-page nuisance.
this went on for a year.
I believe 3 months.
Like 3 months, yeah.
Well, there was a sale on 1/27/17.
Right, through March.
There was a sale on 1/30/16, 2/12/16, 2/17/16, 3/1/16, 3/4/16, 3/8/16, and 3/9/16.
Yes.
Well, that's a year. We got February 2016 to January of 2017.
No, that's incorrect. It was 2016.
And we're not talking about 6 or 7 different undercovers. We had the same guy going back every 3 days to buy drugs from this place.
The same person.
I know. Which would lead me to believe he clearly was not the only person going in there to buy them, and you want me to believe that your client was never in the store when this happened?
That's correct.
All of these, 1, 2, 3, 4, 5, 6, 7, 8. 8 of these.
I think that's a mistake. That first one?
But no, I'll give him the benefit of the doubt that it's a mistake, but there were 8 different sales over a 3-month period.
If my client was in the store at the time during the sales, he would have been apprehended as well, sir. He was never the target of the investigation and never took part in
I used to do these cases. He wouldn't have been apprehended. How are they going to prove he had anything to do with it? It doesn't mean he didn't know what was going on.
But he's the owner. There's no reason to pay somebody else to be in the store because he's there running the store. It's a very small delta.
And they're not just selling marijuana. One of them was heroin. Xanax, Percocet. I mean, they had a whole supermarket.
But it was all through this one person.
No, it was for one person that we know of, the undercover. But we don't know how many other people were coming in and out of there to purchase, right? I'm sure that he was not the only customer, this guy, because that's not how drug dealers work.
I understand what you're saying. I apologize. That other clients.
And it was clear the way you found him was you call him on his cell phone.
That he would direct other people to the store. That's that I have no idea about. This is my client.
I mean, if it was just, if the heroin wasn't involved in the Percocet and the Xanax, I might have some level of sympathy.
This was a one-time incident, sir and gentlemen. Adam, but he is a law-abiding citizen. He's the only deli in approximately 10-block area. And he serves, he wakes up, he's in the store at 6:30 in the morning. There's several Pepsi Cola and business establishments that go to him. He cooks breakfast in the morning for them. He's there till almost 8 o'clock at night. And he has never partaken in any of the criminal activity.
Did he get arrested at all?
He was arrested for the cigarettes and given a violation and a $300 fine.
And what the other guy, did the other guy plea? To what?
To a felony.
And I just want to correct the record. This is not a one-time incident.
No.
I mean,
It's one,
it may be what you're saying is that one person who was working there, but we have basically 2 months of activity of serious illicit narcotics being sold out of this establishment.
No, and let's be honest. I mean, the police didn't get there because it wasn't happening before. They got there because they found out it was happening. That's why they sent the undercover in there.
that I'm unsure of. It might have been, I believe that.
Well, every sale, it appears, except for the first one, he called the individual who handed him the drugs. The first one, he walked in and asked for it, which means that they didn't have a prior relationship. The police knew they were selling it out of there and sent it. That's what it means to me, at least.
Okay, that's a possibility, but I say in your mind, but absolutely not. Knowing him for over 3 years, I'm in there daily, actually in his delicatessen. For the record, I'm a criminal lawyer.
I don't know what you think.
What I'm stating is that
I understand. It's the problem I'm having. If it was only the marijuana, I would probably give the second chance. But I mean, there's a heroin problem going on in this state, in the country. And the fact of the matter is, whether he knew or was just ignorant of it, to me, they're both equally problems. So the only thing I could take is a cancel and bond, given the level of the types of drugs that were being sold here. Because if he didn't know, he should have. And given, as counsel pointed out, the number of instances, and as I said, I know in my gut that this undercover was not their only customer.
the only thing is that it's no coincidence that at the time that as soon as this person started working is when the undercover started going in and going for sales. My client was working there for two and a half years before, and no one.
I'm not insinuating. If your client was doing it before, he would have been arrested too. What I'm saying is, if he didn't know about it, he should have. And there is a level of responsibility to know what your employees are doing. And the bottom line to me is that there was Percocet, there was Xanax, there was heroin. It was more than just, half ounces of marijuana or $10 bags of marijuana. And that, not to mention the cigarettes, which is obviously the minor part of it. But I'm a cancel and bond.
I was thinking of a monetary penalty, but I don't know that you could afford that either.
Well, that's the other issue.
So,
Sorry, I'm not familiar with the procedures. If one board member states
No, we're generally, he hasn't really finished what he was saying yet.
there is a monetary fine, whatever suggestion, because it is 25% of his income. He's been there for almost 3 years, and it is a substantial loss. And then I sincerely vouch, not to vouch, but I'm saying I just know that he's a good man, and he has never partaken, and he did not know about this.
I even, that's the point I'm making, though. Even if I'm taking you at that, at your word that is true. That's my problem, is even if he didn't know anything about it, that to me is a huge problem because of what was being sold. So
I was thinking of a $10,000 fine. I don't know if you can even afford that.
Say something?
Mm-hmm.
Please do.
I know I make a mistake. I was working hard to feed my family. And then I try to help this guy, and this guy never have stable job. He always asking every day, can you give me a couple hours, I work for you. That's all, any fine I said because I need a license to keep the store running, because the bus stop used to be in front of my store, and they moved to next avenue. the business be bad. I need a liquor license to keep store going and then feed my family.
I understand that, but I can't.
So if you can give me 5, 7, I just working more hours.
I mean, you can still go to the hearing and put it on the ALJ and tell them exactly what you're telling me. Oh, no, this is no contest, I'm sorry.
I'll let him,
I didn't know about anything.
contest.
I didn't know
So
about
you
anything.
won't cancel this?
No, I think
I mean, I'm not, if there is a money, it's not 10,000, it's not even close. I mean, what are you looking at?
Going back and talk more.
Yeah. Tax
Wait,
department?
are we back on?
Oh, I'm sorry.
Okay.
Were you arrested by the tax department? Who were you arrested by?
Same day I got arrested with the guy.
109, the local precinct, I guess.
But he got charged with the sale of untaxed cigarettes?
Possession. He went to court and received a disorderly conduct and $300 fine.
Okay.
All right. So, $25,000 fine. I think that's all we're going to get out of here. So I think that's it, or canceling bond. It's the narcotics that's an issue. So sorry about that, but it is.
You can sit down and think about it. He's giving you either or. I mean, if the other, what I would suggest if you can't pay it is you cancel and bond and come back in a year. But this is in my view, is extremely serious.
Consider 20,000 double the amount.
He just told me he couldn't make 25. He's not going to make 20.
How much time would he have?
You probably wouldn't get the letter till how long?
It'll be a couple weeks before the letter goes out. He'll give another 20 days or so to pay the penalty. If you want to give him longer than that, you can, it's up
Well, I
to
don't
you.
know. I mean, how much longer can we give him? I'll give you 30 days after you get the letter.
A month and a half.
It's probably a month and a half.
Right.
And if we don't get paid, we cancel the license anyway.
Be a year from the cancellation notice.
Well, I mean, I'm not telling him that he'll get it in a year. I'm saying that he probably should, the best case scenario is that he waits after it's canceled and then comes back and tries again. I mean, generally, we are not adverse to giving people second chances, but I'm just not going to hand out a second chance to somebody whose store was selling heroin. Oh, you guys want to sit down? Because we have other cases. You can second call it.
He's going to try to come up with the 25,000.
All right.
Okay.
25,000.
25,000?
30 days.
Pay after the letter goes
Yes.
out. Okay.
30 days after.
The letter, after, the letter will have a date on it, and it says due 30 days after that date.
All right. The next item is number 380, Circle A Foods, Inc.
Neil Trivedi, for the respondent. I believe that there's I was dealing with Michael Almarato.
Yeah, it's an offer, cancel and bond.
Yes, that's not a problem. My client will probably take the cancel and forfeiture of the bond. But also he has a sale going on at the same time where I'm representing the purchaser who's has applied for it and his license has been, disapproved because of this pending
Right.
issue.
That's the way it goes.
Concern is that would he be able to vacate that disapproval based on the fact that it's a cancellation?
How long ago did we disapprove it?
We disapproved it November 12th. We've
No.
already processed the refund.
Yeah, no, he has to reapply. Right?
I don't know.
Yeah, he just has to reapply, but it won't affect his ability to get it.
Right. Yeah,
I mean, he can get a temporary in how long?
in about a week.
A week, yeah.
Oh.
This is the buyer that I'm representing.
We already processed the refund, sent the money back, so just reapply and you'll get a temporary. It shouldn't have, you're not related to the guy that owns it now, right? Yeah, so it won't be a problem.
That won't be,
But given, I'm assuming you have a clean history and, okay.
that part won't be a problem. Oh.
No, but the temporary would come in within the next couple of weeks.
As long as you reapply, you should get a temporary within 10 days after you apply.
Got canceled first.
Yeah, you got to get
Gotta get
canceled
canceled
first.
first.
Yeah, that's going to take a couple weeks for you to get the cancellation. You understand what I'm saying?
Yeah, but can I reapply immediately right now while
Yeah.
the cancellation is still pending
Just
with the
put
letter?
we put a cover letter in there that there's a cancellation pending,
Okay.
so that at least my staff won't have to look everything up from scratch. They'll know. You can just ask it held in abeyance until the cancellation is served.
Okay. All right, thank you.
So we accept cancel and
Accept, cancel,
bond.
and bond.
Okay.
Next item is 307, B&L Mordecai, Inc. Where did Mr. McCallum go? All right, let's skip over that one until he comes back. How about 312, River Coyote LLC?
312?
Yep.
Where's the knife?
How do you end up with, oh, I thought this was Levy.
Well, I called you and you weren't there.
Oh, all right, so who are we going with? I don't care. All right, go ahead.
307 or?
312.
312.
Joseph Levy, here on behalf of River Coyote. I have with me the sole principal. Much happier to be arguing against the community board here than myself. This is transfer of assets for a beer and wine license that the community board still denied. There had existed a license in this space for more than 10 years. The most recent iteration was a beer and wine license with a number of stipulations, including closing hours during the week of midnight and on the weekends 2 a.m. We purchased the assets of that business, had some communications with the community board about potentially adopting every single existing stipulation, including the method of operation and the hours, and whether or not, if we did that, considering it's a beer and wine license with a proven operator with a track record, they would consider just giving us sort of an administrative approval as opposed to calling us into their community board meeting, which they typically do if there's a midnight cap 7 days a week. But I thought it was worth asking here because we're adopting the whole stipulations on it's beer and wine, it's midnight during the week and 2 on the weekends. They initially said yes, we did not attend a meeting. They sent us a stipulation form to fill out, sign, and send back, which we did. And then upon following up, because we hadn't gotten their copy back signed, they said, oh, you know what, we actually can't do this. We need you to come to next month's meeting. We went to next month's meeting, we presented the application, we said, in the interest of working with the community, we're happy to take every single stipulation that the prior person did that you approved, and they still said no. They wanted to cut back the hours from 12 and 2 to 12 and 1. And if you know this neighborhood at all, most places are open till 3 or 4. So closing at 12 and 2 was already a stretch for us. Ideally, we'd like to be open till 2 a.m. 7 days a week, but we were happy to take a bit of a haircut on the hours in the interest of getting things through quickly. Again, this was an asset sale. My client's currently operating in the space on a temporary permit. You know, no violations to speak of so far. He was licensed by the authority previously for a cocktail bar that was open till 2 a.m. 7 days a week.
What was the name of that?
Was it Yaver, right? Jennifer.
We don't have that.
That was a number of years ago.
Oh, no, I got it, I'm sorry. That's New Amsterdam Hospitality?
Yes, in a different community board. They didn't have any violation history there whatsoever, although they weren't open for that long.
Okay.
The concept.
What, so he wants, the old place was 12 to 2?
So originally, this was a 4 a.m. license here. The reason that the community board was okay approving the last version of this is because they were going to cut their hours back to 12 and 2. We said, we'll take those hours too. They didn't have a problem. They didn't seem to be an issue for the community or the authority. And we could make that work with our concept, which is coffee bar by day, wine bar at night, open for breakfast, lunch, and dinner.
All right, so I'll give you 1 and 2.
Okay.
The 2 is Friday and Saturday?
Yes. Assuming Commissioner Ford is on that. And then, are you all right with the rest of these? It will not, I have a problem myself with it will not seek a change of class without approval.
I will tell you, the conversation I had with the board office was that I wanted to be open earlier in the day as opposed to opening at noon. I wanted to open at 7 a.m. so we can do breakfast business. I told them that I will not agree to not upgrading ever, although I would agree to notifying them, which is the law, and I have to do that.
I mean, and that you'll seek their approval. It doesn't mean you have to obtain it.
Absolutely.
Okay, so we're going to ixnay that, then that's
So
stipulation number 8 is out.
Correct, and they
And the
also
hours
mentioned
two
that
was out.
the prior method of operation included recorded background music and some live acoustic music, no DJs, no promoters. That is in line with what we'd like to do as well.
Is that in here? I don't know where.
It was.
Oh, I see. It will play ambient background music only consisting of recorded music, not have DJs. All right, so number 6 will, ambient background music and acoustic what?
Acoustic live music.
Acoustic live music.
Correct, but it will not, rise to that entertainment level.
Ambient acoustic live music.
No DJs, no promoters, none of that good stuff.
No more than 3 musicians.
All right, and no more than 3, 3?
It says here, 3 musicians.
Are you all right with that?
Sure.
Don't want too many of them.
You good with those hours on number 6 also for the music?
11 a.m. to 10 p.m. Sundays, 11 a.m. to 12 a.m. Yeah, I'm good with those.
Yep. Yeah, that's good.
Everybody's good with that?
Yep. And then the rest of them are, you're good with no happy hours, no pub crawls or party buses, no unlimited drink. Well, that's law.
Yeah, that's all fine with us.
Okay.
9, 13, 16.
I will waive the 1 bathroom rule under those stipulations. I will approve.
1 bathroom rule waived, and the rest of those that we just talked about?
And then just to be clear, no live DJs, no promoters, other than the ambient music, no live music. Other than the ambient acoustic, no live music. And the hours are 1 and 2.
Correct.
Okay.
Thank you.
Good luck.
Next item is 307, B&L Mordecai, Inc.
Hope it was worth the wait. Okay, my name's Thomas McCowan, here with the applicant, B&L Mordecai. I'd like to make a couple quick introductions. We have Nicole Brown, who will be the full-time manager. I have Marvin Lindo, co-principal, and William Storms, the co-principal. The matters before the members, the prior
licensee. His license was canceled. We're to be operating a full-service Caribbean-themed restaurant, lunch and dinner.
And who is she?
Full-time manager.
She's going to be the manager? And we have that in here?
You have a personal questionnaire.
Okay.
She's had experience.
Okay, that was my problem. That was my question, is the other two guys don't have any experience, so you do.
Well, Marvin does. He's been working in retail for PC Richards in the area for in excess of a decade. So, but that's why, we do have Nicole here.
That's what I'm saying. PC Richards isn't a bar, is it?
What's retail?
Come on.
But
Stick
we're
with the
covered.
fact that you have the manager.
We're covered. I made a late submission. We did had a quality vetting with the community board. We have the stipulation which I submitted, and both Ms. Brown and Mr. Marvin Lindo, they've taken the ATAP training courses, which I've submitted to the members also. Stipulated hours, weekday, weekends.
12 a.m. Sunday through Thursday, 1 a.m. Friday and Saturday.
That's correct.
And that's the only thing they ask for.
And to operate as a full-service restaurant, which we are.
So no DJs, no dancing,
None at all.
no live music?
None at all. The only agreement which has not been memorialized in there is they ask that we operate for a certain period of time. In the event we want to petition for hours or anything, we'll come back to the board and make that request. But
Okay.
going forward, what you have before you is the record.
Any security since given the previous?
We do. We have, it's anticipated, I did indicate that. There are a number of security cameras which they've put in for interior and exterior surveillance, and it's anticipated on the Friday and Saturday night, which should be, the later hours, they will have one licensed security, which was indicated also in the application.
Because the last two places have had
The last
some
two
issues.
places, I did a FOIL Freedom of Information request, and I saw what was there, and that probably explains the skepticism we encountered when we went before the board, and they were pretty thorough in their vetting, and in the end, I think they were pretty satisfied.
And you guys and ladies had nothing to do with that old place? Or the other one before that?
Nothing.
All right.
And a statement's been submitted for the record to that effect.
Okay. I'll approve based, with the stipulations.
I approve with those stipulations too, as by the board and agreed
No
to.
DJ, and then add no DJs, no dancing, no live music.
Got it. That's correct.
Good luck.
Thank you for your patience. Thank you very much.
Thank you. The last item I have for an appearance is 269 Mangaroni
Great, Nicole.
LLC.
What number?
269.
PC Richards and Son.
Well, it's funny I mentioned it because it was still in my head. One of the board members recused themselves at the hearing because he had purchased a television from Mr. Lindo, and he felt he had a conflict of interest that no one really saw.
What, do you feel like he got it for nothing or something? He already bought it.
I don't know. That's why it was still in my brain. This is a finding of facts from the ALJ. There were 4 charges. The charges were not sustained. Request.
All right, so I'll dismiss 1, 2, 3, and 4.
Dismiss. Thank you very much. Enjoy your weekend.
You too.
See you tomorrow.
Tomorrow, what's he coming in to see you?
You ready to proceed?
Let's go. Let's rock.
All right. 252.
10 minutes.
3,500.
Accept.
Accept.
253.
3,000.
253, you said, 3,000?
Yes.
All right. No response. 3,000.
254.
10,000 because of the history.
10,000.
255.
Cancel and bond, accept.
Accept, cancel, and bond.
256.
Bring these guys in.
You okay with that,
Yes,
Commissioner?
bring 'em
Okay,
in.
258.
I had counter 2,500.
I'd counter 3,000. I'll go with him, 2,500. I counter 2,500.
259.
Accept.
Accept.
260.
3,000.
3,000.
261.
3,000.
3,000.
262.
500.
500.
263.
250.
250.
264.
I'll accept. Why didn't we charge 2 sales there, do you know?
Not sure.
Okay.
7,000 accept.
265.
So I had that they didn't have notice of the first sale and then got the second 2 months later. I'll go to 5,000. What's the failure to supervise charge related to? Do you know, Chris? Is that just related to the sale?
It's related to
I could look further. I'm not quite sure.
No, I'll just lower the offer to 5,000. I really don't think they didn't have notice after the first sale.
5,000 counter.
266.
2,000.
2,000.
267.
Sustain one, 3,500.
3,500, yes.
268.
Sustain one, 3,500.
Sustain one, 3,500.
270.
Just want to recuse myself for the record.
Why? Oh, you were the judge on this. Okay, sustain one, 3,000.
3,000.
271.
Cancel for the record.
Canceled. No bond.
272.
3,000.
3,000.
273.
And counter 3,000.
Yep, it is 3,000. Isn't it?
Yeah.
273 is sustain charge one, 3,000.
You all set, Commissioner Ford?
Yes, that's what
Okay.
you said, yeah.
274.
Hold on a minute. Yeah, okay. Sustain charge one, 3,000.
3,000.
275.
Sustain charge one, 6,000.
6,000. Yeah, okay.
277.
Dismiss charge two at council's request, except cancel and bond.
Cancel and bond.
277? I'm sorry. I missed 276. I take that.
Yeah, that was confused. Sorry, Tom.
276 was.
Right, that's the one you just did. I had the wrong.
Oh, okay, that's
I
cancel and
jumped
bond,
in-
right?
I jumped ahead of you.
Okay, thank you.
277.
So I counter with 3,500. They've been open 4 months and they still have not sent, I'm assuming they still have not. Oh, they did supply the records. All right, I'll accept the 3,000. I thought they hadn't supplied the records.
Yep, 3,000 accept.
278.
No response.
1,500.
1,500.
279.
1,500.
1,500.
280.
Let me guess, 1,500.
No, that's 2,000, because that's 7 months. That's over 6 months, so 2,000.
All right.
281.
Counter 5,000.
I'd note that I think that there are conditions
Yeah.
on the letter. That's why.
But is this you're gonna have them file a method of op? Because here's the situation, if they accept the 5,000,
Right,
they're gonna
then
be
it doesn't
sending a
go
letter
in.
not to licensing for us to modify our records.
All right, so counter 5,000, and they have to submit a method
File a
of,
method of
file a method of operation change for all the stipulations.
Okay.
For the 4 stipulations, which is no security.
No DJs, no karaoke, no dancing.
Right.
Yep.
You good to go with that?
Yes, counter 5 plus method
Two-
of operation change.
282.
I'll accept 6,500.
6,500.
283.
Accept.
Cancel and bonds. 2 bars were separated by door that was locked, so you had to leave. Yeah, I'm countering with cancel and bond. This is a mess.
That's when both areas are separate. Are they both licensed, though?
All the two
No, it was 1 license, 2 bars, right? The guy had 1 license for the area and separated it into 2 separate
Yes.
places. Yeah, I got counter with cancel and bond.
Cancel and bond.
284.
Accept.
1,500 accept.
285.
Accept.
8,500 accept.
286.
So I'll take the 2,000, because the alternative is to cancel and bond.
Well, they're expired.
Right.
They're done.
So are we even going to get this? Let's try, 2,000.
I don't think they realize that all these other applications have been denied.
Yeah, I'll accept.
2,000.
287.
Second offense. Should be 65.
Yeah, I'll take the 6,000.
6,000, accept.
288.
6,000.
288, 6,000. All right.
290.
I would just note the fact pattern.
Yeah, no, I got cancel and bond. Sustain 1, sustain 2. At a minimum, there was statutory rape by one of the employees to one of the employees. And another employee asked the customer to drive the 16-year-old employee home, allegedly while she was drunk, and then assaulted her. So I got cancel and bond.
Cancel and bond it is.
295.
License.
So license is surrendered?
Yep.
Cancel and bond.
Cancel and bond.
296.
Excuse for the record.
Sustain 1 through 6, cancel and bond.
1 through 6, sustain, cancel and bond.
299.
Sustain 1 through 3, dismiss 4 and 5.
Wait, hold on. Are we, did I miss one?
297, isn't it?
297?
Yeah.
Yeah.
I'm sorry, 297.
Sustain 1, 2, and 3, dismiss 4 and 5, 2,500.
2,500.
I'm going to stick it together a little bit here. 299.
Letter of warning.
Letter of warning.
301.
Do we know if these adverse history were both for cigarettes?
Yes. I think I went back and looked. They're both for cigarettes.
That's a cancel and bond then.
3 times you're out, cancel and bond. 306 was adjourned.
Yep. 306 was adjourned. 322.
Cancel and bond.
Yep, accept.
323.
Letter of warning.
Oh, I'll reconsider. I thought she was going to show up, to be honest with you.
Do you want her?
Yeah, she doesn't understand what she did, so
Okay.
she has to come in.
Okay.
Bring her in?
Yes.
Yeah.
I mean, I'm willing to
All right.
work with her, but she still thinks
Right.
she's right.
Okay.
326.
Letter of warning.
Letter of warning.
330.
Accept.
Accept.
331.
3,500.
3,500.
332.
Accept.
1,500, accept.
333 and 334.
Counter at 10,000.
10,000 counter.
335.
Accept.
Accept. 500.
336.
Accept.
Accept.
337.
Letter of warning, accept.
Accept.
338.
Accept.
41 bucks, yeah, we accept.
339.
Accept.
Accept.
341 and 342.
Accept.
Accept.
343.
Accept.
2,000, accept.
344.
Is this application still going, or did we already approve it?
Give me a second. It's still pending.
All right, can you make sure that comes here, and then I'll accept the 6,000.
6,000, accept.
345.
Accept.
Cancel and bond, accept.
346.
I'll reconsider and accept the 2,500.
Was rejected.
Money's been paid.
So you're saying accept 2,500?
Yeah, because we got the previous, they were delinquent, right?
Oh, it's paid now, yes. Okay,
Yes.
got it. Sorry.
So now I'll accept the 2,500.
352 was adjourned. 355.
I just note that it seems like nothing's been paid on adverse.
Nothing's been paid?
Is that what I note, Tom, from your notes?
Right.
Nothing's been paid.
Cancel and bond.
Cancel and bond.
$356.
What is this on, is this a $500 usually, do you know, Chris?
Not sure. Right
The delegation says 1,500.
15.
1,500.
1,500.
358.
Accept.
Accept.
My God, there's a lot of cases today.
359.
Letter of warning, accept.
Letter of warning, accept. $22.
That should go in delegation.
Hold on. 359 was. Did we get lost in the shuffle here?
No, 359 's
letter of warning.
letter of warning.
359 was a.
No contest of fault, improper.
Oh, I do. I'm sorry. Never mind. I'm old. Never mind. 360.
Cancel and bond, accept.
Accept.
361.
Dismiss 1, sustain 2, dismiss 3.
Just recuse for the record.
Okay.
Surrendered now, so.
Is the license got surrendered?
Yes.
So cancel and bond.
Cancel and bond. Bless you.
Bless you.
362.
Dismiss 1, 2, I'm sorry, sustain 1, 2, 3, and 4. I'm assuming we have not renewed.
No.
Cancel and bond.
So 7 people were there to pick her up, but not one of them helped her clean up anything. Okay.
Good neighbors.
Good friends, good family.
363.
Let's return to council.
Is this right? Oh, it's 363, wouldn't, I don't have that.
That was returned to.
That was returned to
yeah,
council.
my
Yeah.
note's not on. Yeah. Sorry.
Maybe we'll have
365. That 360. There was a email plea, not guilty plea received.
Right.
So the prosecutor has asked to have it sent back.
All right.
So
360
365, is that correct, that legally all we can do for this 18 and under is 1,000?
That's what, if they had their training
Yes.
prior to the sale?
Yes, it
That's
looks,
in the law.
it looks like they did.
Well, it's actually the statute requires a bond claim. They're asking for an.
Yeah, I'll take
Yeah.
the penalty, so $1,000.
$1,000.
366.
Sustain 1, 3,000.
Oh, 366.
It's a sale to minor.
Okay. 3,000, yes.
367.
Accept.
200, accept. No pool tables.
368.
Dismiss 1, sustain 2. How did that happen? 3,000. They dismissed the charge regarding the DJ playing, but they sustained the charge of the DJ booth.
So they're allowed to have recorded music, but not allowed to have a place to
I
play it
believe
from.
Judge Stoll found that DJs are recorded and went through an analysis of that, which.
I think this is an old license though, right? Yeah, that's why.
Yes.
All right, so I'll dismiss 1, sustain 2, 3,000. That's not going to be policy though.
3,000.
370.
Accept.
Accept. 750.
377.
No, 371.
Well, hold on. Did I get no one? Sorry. 371.
Accept.
Accept 10.5. Now 377.
377.
Yep.
Accept.
Accept.
378.
3,000.
I got to shake each one.
3,000.
379.
3,000.
no, 3,500.
3,500.
I want to counter 3,500. This is under 18. There's no,
18 or under 18? Oh, 18.
he's under 18. He's-
Should know better.
You're okay with that?
Yes,
Commissioner?
yes.
381.
Now, since 1955,
Yeah, I'll accept 3,000 instead of 4,500.
386A and 386B.
Accept, cancel, and bond.
accept, cancel, and bond.
Only thing I had left, I had the minutes from the,
Do I have 382? No, did I miss? Sorry. I just want to make sure. Is that held?
Yeah, what did we
East
do with
Slope-
382?
East Slope Ski Lodge.
Yes, that was.
382 was Albany, that we did that.
Okay,
That
I'm sorry,
was-
I missed it.
Yes.
I apologize.
accept- we
All I have,
accepted. I
don't
apologize.
go, all I have, the minutes for the last two meetings and those decisions.
Oh, and I
I got your typos.
handed the draft with the typos to you, and once those are fixed, I don't need to see them again. And then the minutes I approve.
Okay, Commissioner?
Approve, yes.
All right, nothing else?
That's it.
We're